Hello, all my CMA Inter students. I know this is something that you all have been waiting for since long, but better late than never. And First of all, let me give you a clear disclaimer that CMA Inter students who are looking for a marathon in like a mix of Hindi and English, it's already there. Don't worry on that part. Yes, CMA Inter Law Marathon in complete English I had not uploaded. However, I have already uploaded the revision of the company law portion of CMA Inter Law in 100% English. It's already there on the channel. You'll also find the link over here. But this marathon covers your commercial law portion, your ethics, as well as industrial laws. So you can revise all these in 100% English in a super quick, effective manner. So this is absolutely like quick, comprehensive, exam oriented, and direct and crisp. So no chit chat, nothing. It's just going to have, you are going to enjoy that pure content. So if you really want to study, if you really want to revise and get just a quick glance, a quick view, remove your doubts. So this is going to be super effective. So enjoy the marathon. And of course, if you have any doubts, you can always drop in the comments and we'll share you the links, whatever is being provided. And stay tuned on the channel because a lot more is coming to your way before your exams. Thank you. Let's now revise the chapter of Introduction to Law and Legal System of India. Right. The first thing that we see in this particular chapter is about constitution. So what is constitution? Constitution is basically a document, right? And it tells us a lot of things. It tells us about the nature of our government. It confers rights to the citizens, it gives lawmaking powers and whatnot, right? So Constitution of India is the supreme law in our nation. It is the lengthiest constitution of the world. It came into force on 26 January 1950, right? Although it was adopted by the Constituent Assembly on 26 November 1949. Now, this particular constitution has 470 articles. It is grouped into 25 parts and has 12 schedules and 5 appendices, right? Now, the preamble of constitution tells us the source, right? It tells us the date of commencement, it tells us the rights and freedoms, it tells us the nature of government, right? Now what is there in preamble? It clearly states that India is going to be a sovereign, secular, socialist, democratic republic nation, okay, which is going to give justice, liberty, equality and fraternity to all its citizens. Now, the first thing that we read over here is fundamental rights, which is also called as Magna Carta, right? Which is ideally there in part 3 of our constitution. And starting from article number 14, we read the first right, that is right to equality, right? So these are the 6 fundamental rights. If we go on to read them in detail, right to equality is containing articles 14 to articles 18. What is right to equality? The first thing is equality before law. That means everyone is going to be treated equally in the eyes of law, and everyone is going to get equal protection of laws. It doesn't matter whether you belong to a particular caste or religion or sex or place of birth. It doesn't matter. However, there is one exception, and that exception is president and governor. They are not going to be answerable to any court. There won't be any criminal or civil proceedings against them, right, during the tenure of their office. Okay. Then comes your Article 15, which talks about that nobody is going to be discriminated on the grounds of religion, race, caste, sex, place of birth, right? That means if you want to go to any shop, any public restaurant, if you want to use any public utility services like wells, tanks, roads, you cannot be denied access just because you belong to a particular religion, race, caste, sex, etc. Right? Then we have Article 16, which talks about equal opportunity of employment as well as in promotion. So if you want to be employed in any office under the government basically, then you will not be discriminated on these grounds. However, there are again exceptions, that government has the power that they can make provisions or they can reserve some seats for the backward classes, some promotions for the backward or the scheduled caste and the tribes, right? They can also say that if you want to be employed over here, the employment is going to be only of the persons who reside in that state. Maybe they're trying to promote that, right? They could also say that if you want to be employed in a particular religious institution, then you have to belong to that particular religion only, right? Then we have Article 17, which talks about abolition of untouchability, which existed back in time, right? And that was all about the disability, that if you are born in a particular caste, then you are untouchable and you are disabled from entering into certain places, from touching certain places, from being denied access to a lot of things, right? That has been abolished. Now, abolition of titles is also there, which is contained in Article 18, which talks that nobody is going to be conferred any title. Now, any title doesn't mean that the highest civilian award like Bharat Ratna and all. No, it doesn't mean that. And it also doesn't mean the military or academic titles which are being conferred, like we have doctor, like we have brigadiers, and all of that, right? But we talk about the titles like Sir, Lord, Raja, Maharaja, something like that, right? So they are not going to be conferred. And if you are a citizen, then you're not going to accept foreign title from foreign state also. And if you're not a citizen, then also you're not going to accept foreign title, any title from any foreign person, as long as you're holding any office under the state. Okay. Next, we have the second right that we have is right to freedom, which is from Article 19 to Article 22. So, what is freedom? There are basically 6 freedom which are given in Article 19, and they're subject to restriction. So, you have freedom to speak, freedom to speech and expression, assembly, that means people can meet, association, that means they can form associations, they can move from one place to another, they can reside over here, they can settle over there, right, within India, they can practice any profession, trade, occupation, right? But this is all subject to certain restrictions. These restrictions are that if at all you hurt the security of the state or friendly relations or public order or morality or contempt of court or defamation or sovereignty and integrity, then these rights can be restricted. Then we have Article 20, which talks about protection in respect of conviction. Here we read 3 terms, that is ex post facto. Then you have double jeopardy and self incrimination. What is it? Ex post facto talks about that if you have been convicted for an offense, that means you have been found guilty of doing this, then you can be punished only that punishment which existed at the time of commission of an offense. Subsequently, if the punishment is penalty is increased, you cannot be inflicted that greater penalty. Double jeopardy is that you cannot be prosecuted for the same offense twice, and self incrimination, you cannot be forced to witness against your own self. Article 21 is right to life and personal liberty, right? What is it? Now, everyone has a right to live, and right to live doesn't mean that you're just alive. It means you have a quality of life, right? Now, if somebody is going to have a quality of life apart from that just physical existence, that means he has the right to get that free air to breathe. That means there shouldn't be environment pollution, right? He has the right to travel abroad also if the law permits, right? He has the right to livelihood, right to shelter, privacy, food, marriage, education, reputation, right? Right to speedy trial, right against handcuffing, right to free legal aid. Free legal aid is not available to everyone, but the ones who fall below that specified income criteria, right? So these all rights are also included in this right to life. Okay. Then we have the next right, although we have right 21A also, which talks about education, that every person is going to be given free education till the age of 14, right? Okay. Next, we have right against exploitation, and there are 2 articles. One is prohibition of traffic in human and of forced labor, right, which is available to everyone, whether you are a citizen or you are a non-citizen, right? The buying and selling of humans is not allowed. And then there is prohibition on employment of children. Children, that means under the age of 14. Prohibition of employment or child labor doesn't mean that you cannot work at home. You can definitely work at home because that's some harmless, innocent work that you're doing. But being exposed in factories or doing some work under the mines or doing some hazardous activities, that is something which is not allowed and completely prohibited, right? Okay. Then we have right to freedom of religion, right? We know that India is a secular nation. India does not have any religion, yet the people in India are free to practice their own religion. So Article 25 states that you are free to profess, practice, and propagate religion. That means you can uh, mm, first of all clearly declare that I belong to a particular religion, do its religious practices, and also tell others about it. Okay, now you also have the freedom to establish your own religious institutions if you want to, right? And they can also own movable property, like we have established maybe temples, mosque, and everything, right? So you have that power also. Then Article 27. Now, if government is collecting taxes, they cannot use the tax to promote a particular religion, because India does not have any religion. So nobody can be compelled to pay taxes for doing a religious activity, because it's not promoting any religion. Article 28. If there is an institute which belongs to government or is being run on government's fund, then that institute is not going to give any religious instructions. Okay, that educational institution is not going to give any religious instructions. Then we have cultural and educational rights, which primarily relates to the minorities. Okay, what is it? That every citizen has the right to get admitted to the educational institution which is being maintained by government, because everyone is paying taxes. You cannot be deprived admission just on the grounds of any discrimination, on the grounds of religion, language, that just because you don't speak a particular language you'll not be given admission. No, that's not going to happen. Secondly, the minorities, you have the right to establish your own educational institution if you want to, and the government is going to be neutral in granting aids, in ensuring that you are getting the right even under compulsory education acquisition. Okay, then we have right to constitutional remedies. What is it? We have Article 32, which tells us about this. If your fundamental rights are violated, then you have the right to move to Supreme Court, and Supreme Court is going to issue orders or directions. Supreme Court can order issues writs also. Writs are like orders only. Okay, now they may be in the nature of habeas corpus, mandamus. I told you everything, right? That means they may be instructed that you're not granting the license, you grant it immediately, right? Or maybe like habeas corpus may be instructed the jailer that you have detained somebody, produce him in front of the court and justify the detention, right? So there are different types of orders which may be issued by Supreme Court. Okay, now we move to the next topic, which is sources of law. Broadly, there are three sources of law: custom, judicial precedent, and legislation. Custom, that means what? Customs are basically which have been observed for a very long time, and sometimes customs get converted into law. Every custom need not become law, first thing, right? There are many laws which have been inspired from customs, but how to check whether a custom is a valid custom or not? There are four tests prima facie, and the four tests are antiquity, continuous reasonableness, and morality. Antique means what? Old. So something which you have started to do in the recent times in 1-2 months cannot be considered as custom. So it has to be something which has been in existence for a very long time. Continuous, that means there wasn't any interruption since then till now. It has been continuously observed by people, right? It shouldn't be something unreasonable or something which is causing a lot of inconvenience and harm to people, right? It should be justified, and then it should not be immoral or should not be opposed to public policy, right? Like child marriage. Now earlier child marriage was done, but it's not something which is moral, or it is something which is opposed to public policy, and that is why it did not turn out to be into a law. But we have seen a lot of customs which have been incorporated into law, especially when we look at Hindu Succession Act or Marriage Act. We'll find a lot of customs which have been enumerated as laws. The next is judicial precedent. Judicial precedent means what? Judicial precedent is basically the previous judgments. Okay, now previous judgments could be of High Court, could be of Supreme Court, right? Now if there is any previous judgment of Supreme Court, it is going to be binding on all the courts that are prevalent. If there is a previous judgment of High Court, it is going to be binding on the subordinate courts within its jurisdiction. And for other courts, it's only going to be persuasive. Whenever there are judicial decisions passed, they are basically divided into two components. One is the ratio decidendi and the other is obiter dicta. Ratio decidendi means the binding part of the judgment, and obiter dicta is general observations which do not have any binding authority. So if there is a Supreme Court decision, then some part may be obiter dicta, and sometimes Supreme Court itself says that please don't consider, right? This is not going to be a judicial precedent. So they may say like that. The third is legislation. Legislation as a source of law means legislation means making of law. Okay. Now, there is primary legislation and there is subordinate legislation. These are the two kinds of legislation. Two kinds of making law, you can say. Who makes law? There is one supreme authority, and then there is subordinate or delegated authority. Who has the law making power? If I talk about central laws which can be made for the entire nation, who has the law making power? Constitution has conferred the law making power with Parliament, right? So Parliament makes laws. So Parliament is the primary and the supreme authority to make law. So Parliament has made an act, let's say Companies Act 2013. Now, Parliament has made this is a primary legislation. Now, Companies Act gives power to central government to make rules. That means primary legislation has delegated some authority to make laws. That is subordinate legislation. The rules made by MCO, the rules made by central government, the laws made by executive, right? That is subordinate legislation. Okay, why do you think you need subordinate legislation? Is it something which is very important? Because there are local laws which are made by panchayats, municipal corporations. There are many rules which are made by ministries, right? Government. Primary responsibility of lawmaking is with the parliament or the state legislature, as we have read that, right? And the responsibility with central government is to get that law enforced, right? The executive. Because when we look at the organs or the wings of government or the functions of government are primarily three. One is legislative, that is lawmaking, then second is executive, and the third is judiciary, right? So basically, lawmaking power is with the parliament. Executive function has to be discharged by the ruling government. So it is their responsibility to discharge executive functions. However, they also have to make subordinate legislations. Why? Because of lack of time. All the legislature cannot be made by parliament because they do not have the time to go on and evaluate or experiment, right, or go in detail. Secondly, working details, they are not aware of the ground level problems, right? So delegated legislation is very important because they probably know what is needed, what is not needed, and because of multifarious functions of the lawmaking authority. So legislature, you just don't have the powers of lawmaking, but you are also representing people. You are checking on government, right? You are involved in budget, financial matters, etc., etc. So you have to discharge a lot of other functions also. Okay. Then we talk about legislative processes in India. We have already discussed about the primary source of law. We will basically discuss the stages of passing law. So first of all, any legislative proposal is drafted by the concerned ministry. It is kept in public domain for 30 days and the feedback from stakeholders is taken into consideration. And thereafter, the concerned ministry, you discuss it with the Ministry of Law and Justice for their view that do you think the need is there, it's going to be feasible, right? There is desirability. And after that consultation, if they agree to it, then you hand over the documents to that department and their legislative department actually drafts that bill. Fine. So you approve it and thereafter you give to the cabinet. Cabinet is that set of expert ministers that we have, right? So once they approve and after whatever suggested changes are there by the ministry, then the bill is going to be introduced in the House of Parliament. What is the House of Parliament? We have Lok Sabha, we have Rajya Sabha. Now we have different types of bills. any bill can be introduced in either house except for the money bill, which has to be introduced in House of People, that is Lok Sabha only. Then only it's going to go to Rajya Sabha. Once the approval of both the houses is accorded, then it's handed over to the president. And once you get the assent of the president, then it's notified in official gazette and it becomes an act. Of course, before that, it is being handed over to a lot of committees. There are a lot of deliberations, there are a lot of amendments, modifications, a lot of things are there, right? Now, sometimes it may so happen, sometimes it may so happen that bill is passed by one house but it is rejected by the other house, right? Or maybe they disagree to the amendments which are made, or maybe 6 months have elapsed but no bill is passed. So in such a situation, president may call for a joint sitting, and whoever is present, the majority, according to the majority votes, it will be deemed to be passed by both houses of parliament, right? There are some special provisions with respect to money bill passing, and they are that money bill is going to be introduced in Lok Sabha only, and Lok Sabha has immense power. Okay, so once it is passed, it is given to Rajya Sabha, and within 14 days they send it back with their recommendations. If they don't send it, it's deemed to be approved. If they send it back, we check the recommendations. If we agree to the recommendations, it is deemed to be passed with recommendations. If we do not agree to the recommendations, it is deemed to be passed without recommendations. Okay. Now, there is one more thing which is about the dissolution of Lok Sabha. Supposedly, Lok Sabha dissolves without the bill being passed. So, the bill is pending, right? If the bill is pending in Lok Sabha, or the bill is pending in Lok Sabha, the bill is passed by Lok Sabha, but it is pending in Rajya Sabha, then it's going to lapse. However, if the bill is pending in Rajya Sabha and has not been passed by Lok Sabha, then it's not going to lapse. And it's also not going to lapse just because the parliament is not in session. I mean, a bill is introduced but it has not been passed and the parliament discontinues to be in session, right? So just because there is prorogation of houses, it doesn't mean that it's going to lapse. Okay. Next, we have legal methods, including ADR. So basically, whenever there is any dispute, people resort to litigation. Litigation is a method wherein we involve courts. There is one party who's going to file a suit and the other party who's going to defend it. There are judges and the verdict of the court is binding. If we do not agree, we can appeal to a higher court. That is what litigation means, right? Now, not for all matters arbitration is available, but we have a lot of matters where arbitration is available, right? Arbitration is one of the sources, one of the methods of alternate dispute resolution, right? So we have arbitration, we have mediation, we have conciliation, we have lok adalats, right? Arbitration means what? We are going to go to a neutral third party and that particular person is going to decide, and that decision is going to be binding on us. That means it is adjudicative process, right? However, when I talk about mediation, when I talk about conciliation, they are consensual process, right? Where the two parties consent that, okay, I agree to a particular resolution. Just because of the increasing things, right, increasing burden on the judiciary, arbitration or any alternate dispute resolution, that means one option to resolve dispute is to go to the court, the other option to resolve dispute is to settle it outside the court, right? Which is way more speedy, which is way more cost friendly, which is way more flexible, because in courts you cannot ask the judge, today I'm not free, tomorrow I'll come, at this time I'll come. No, they give you a date. If you're not available, you have to go for an adjournment, or maybe if you don't appear, there will be ex parte decisions, right? Here you have a lot of flexibility. Okay. Now, arbitration and conciliation are governed by Arbitration and Conciliation Act. However, mediation is covered by a Code of Civil Procedure, and so are Lok Adalats. Okay. Now, when we talk about, we have to detail, we have to learn about arbitration only. So arbitration, basically you have to have an arbitration agreement which is in writing. It could be in the form of an arbitration clause, that is one clause in the entire agreement, or a separate agreement, right? Parties are free to determine the number of arbitrators that they want to have, but it's not going to be an even number. It could be a person of any nationality. Now, how do you appoint arbitrators? If you want one arbitrator, mutually you decide and come to a conclusion that, okay, Shivangi ma'am is going to be our arbitrator. You can decide that. If you want to have three arbitrators, both the parties are going to decide one arbitrator, and these arbitrators are going to come to a conclusion about the third arbitrator, and together these three arbitrators will act as your judge. If you fail to appoint within 30 days, supposedly one party has requested that this is the dispute, let's appoint the arbitrator, and there's failure to appoint within 30 days, then the appointment, you can approach High Court or Supreme Court as the case may be, and thereafter the appointment is going to be made. Okay. Now, what is conciliation? Basically, conciliation and mediation is close, right? But in conciliation, there's no bar as to how many conciliators should be appointed. There is again a neutral third party, and conciliation is again a voluntary thing where the parties settle down, where the parties agree. So it's like a win-win situation. In arbitration also, there is always a judgment. So one person may agree, one person may not agree, right? But when I say conciliation or when I say mediation, the parties have a win-win situation, because it is the decision is going to be not binding. The decision is not going to be binding unless they sign the agreement, right? So with mutual consent, they come to a conclusion, right? The only difference between conciliation and mediator is that mediation is more friendly, and the mediator is only trying to facilitate. He's not putting in efforts to bring in any solution, suggesting things, negotiating. No, not doing all of that, but just acting as a mediator to communicate things here and there, and finally writing down the things, right? We have lok adalats. What are lok adalats? Lok adalats are basically established by government, and they settle disputes in the same manner. So they have a conciliator, they're going to settle a lot of disputes. In fact, those disputes which have been pending in the courts from long, they can also be referred to lok adalats, and they can also be settled. So it is like a way of settlement, right, which are being established by government for the help, and they are governed by code of civil procedure, right? Now, after this, you have in this chapter legal terminology and maxims, which definitely I'm not revising over here. This was a super quick revision, yet I feel it's an effective revision that you'll find, right? But I'm not going to revise the legal terminology. That you have to revise on your own, right? And that is not even suggested, because there are so many legal maxims and you cannot learn all of them, right? So you can just go through it once. Okay. Thank you. Okay, now we are going to revise the chapter of Indian Contract Act. Now, Indian Contract Act came into being in September 1872, so it's a very old act, but still relevant, right? And knowingly, unknowingly, we enter into a lot of contracts every day, and this particular act is going to be applicable. Although it's a business law and it's applicable to business transactions, it does not apply to the social agreements. They are out of purview of this, because basically we don't have the intention in the social agreements to bind anyone legally, right? This particular act extends to whole of India, and most of the laws or this act is totally based on the principles of English common law. Now, the first thing that should come out to our mind is, what do you mean by contract? Contract is agreement enforceable by law. What is an agreement? Agreement is a set of promises forming consideration for each other. What is a promise? Promise is offer when accepted becomes a binding promise. The question is, what is offer? Offer is the willingness made by one person to another to obtain his assent. So when one person signifies his willingness to do something or abstain from doing something, right, to obtain the consent or assent of that other person, he's said to have made a proposal. Okay, proposal when accepted becomes a promise, right? Okay. So these were very basics which we have been reading with n number of examples and n number of funny examples, I would say. That is how everyone has learned the basics of Indian Contract Act. But here we are going to strictly revise our content through for exam perspective. Okay. So the first thing that should come to our mind is that what are the essential elements of a valid contract? To become a valid contract, there must be two parties. You cannot contract with your own self. There must be an agreement. Agreement means there should be an offer, there should be acceptance, and that is how the parties agree to something. There should be an intention to create a legal obligation, right? In social agreements, the parties presume there is no legal obligation, and in commercial agreements, the law presumes that yes, the parties had the intention to legally bind each other. There should be lawful consideration and lawful object. Like, you cannot say that, okay, fine. I am going to supply you drugs and you pay me payment of 50,000. That is the lawful, it is not lawful object. The object is unlawful. Why? Because supply of drugs or sale of drugs is prohibited under Indian Penal Code, right? Consideration means something that you're getting in return. So that consideration also has to be lawful. Like if I say you that I am going to teach you law, that is my promise for you, but in return what you have to do is you have to kidnap that particular person, right? So again, the consideration that I'm asking for is unlawful. Okay. Now, the parties should be competent to contract, that is, they should be of major age, they should be of sound mind, and they should not be disqualified from contracting. The consent of the parties is very important. What is consent? Agreeing upon one thing in the same sense. Okay, that is consent. And the consent should be free. That means it should not be caused by coercion, undue influence, mistake, misrepresentation, like. Okay. And the terms should be capable of performance. That means maybe I am entering into an agreement to discover some magic by some to discover some treasure by magic. Now this is a contract which cannot be actually performed, because it cannot be performed, it's not capable of being performed, right? Then the agreement must be certain. It should not be vague. Like if I call you and say that I want 100 tons of oil, which oil? So the agreement over here is vague and it is not enforceable. So it's not going to be a valid contract, right? Now we start with the very first thing. Okay, essentials of a valid contract, I have already told you. This is something that we need not discuss right now. Yes. Okay. Yes, when we are talking about offer, let's talk about offer first. So, what is offer? One person is making the offer. See, we have some types of express offer, we have some types of implied offer. What is express offer? Express offer, like you're clearly saying, will you carry my luggage? I will pay you 100 rupees. So, she is making an offer, and if the other person wants to accept, that other person can accept that offer, right? What is implied offer? Implied offer, we are not expressing our intention to enter into any agreement, rather he's picking up your luggage and walking. Now if you walk behind him, that means you have accepted the offer, so that is implied acceptance also, right? So implied offer, and implied offer, that means through your conduct you are showing some offer, right? There could be general offer and there could be specific offer. General offer is accepted or can be accepted by anyone. It is made to public at large, and it can be accepted by anyone. But when I say specific offer, it is not made to the public at large, it is made to a specific person only. It is made to a specific person only, and only that particular person can accept it, right? So we have two parties when we talk about offer. We have offerer and we have offeree. Offerer, who makes the offer; offeree, to whom the offer is made, right? There are some essentials of a valid offer, like it should be very clear, definite. It must be communicated. If it's not communicated and you have it in your heart, that's not an offer, my dear, right? It should be, it can be communicated orally also, in writing also, or in express terms also. So it may be express, it may be implied, it may be in writing, it may be oral, right? It may be a general offer, it may be a specific offer. Okay, fine. Now, when I talk about communication of offer is complete when it comes to the knowledge of the person to whom it is made. Very simple. So if I am making an offer to this particular person, when this particular person comes to know about the offer communication is complete. Like if I have dispatched the letter on 1st January and the letter reaches on 4th January, the communication of offer is complete on 4th January. Very simple. Okay. Now, we have something called as acceptance. What is acceptance? When a proposal is made, it is not made just to tell my intention, it is made to seek your assent, right? Whether you agree or whether you disagree. So basically we are trying to seek your assent. So when the other person signifies the assent, the offer is accepted. Now acceptance again can be express or implied. Acceptance again can be in writing, or it can be oral. If I tell you that if you accept the terms, mail me by tomorrow evening, that means I've specified the time limit and I've specified the mode of acceptance. So you have to accept through that mode only. Now acceptance, and you have to accept within that time limit only, because we have fixed a time limit, right? Now, if you're silent, I don't get any reply of yours. I'm like, okay, she hasn't said no, but she hasn't said yes either. So mere silence cannot be acceptance. Mere silence cannot be acceptance. Okay, now you have accepted the offer, but you're not communicating it to the person. Well, unless you tell it to the person that you have accepted the offer, how can this be treated as acceptance? So you must communicate. You must communicate. Now, acceptance has to be clean and unqualified. Like if you're putting in a condition, I told you that will you buy my mobile phone for 50,000? You said yes, I will buy your mobile phone, but for 45,000. So this is rejection of the offer. Now you're making another offer, so you're making a counter offer. So whenever you qualify the acceptance, that means you don't say yes or no, but you say yes, but this is going to happen. So you're putting in some condition. Conditional or unqualified or acceptance is not allowed. Okay, so if you're doing that, that means you're making a counter offer, and now if I accept your counter offer, then it will become a promise, then it will become an agreement. Okay, now where we talk about communication of acceptance. Communication of acceptance. Now, this particular person got the letter of offer on 4th, and he sent the letter of acceptance on 6th, which reaches the offerer on 10th. Okay, which reaches the offerer on 10th. Now, if you have made an offer to somebody, you can revoke the offer. Yes, you can revoke the offer. You can revoke the offer before he has accepted it. This particular person has accepted the offer on 6th, so you can't revoke the offer after 6th. That means communication of acceptance is complete against you on 6th only. However, this particular person, if you have given your acceptance, you can revoke it till he comes to know about your acceptance, that is till 10th. So communication of acceptance will be complete against you on 10th. Okay, we have discussed this in a lot of detailed manner. Now, communication of revocation of offer. Can the offer be revoked? Answer is yes, till the time it has not been accepted. Right? Till the time it has not been accepted. So it was accepted on 4th. Right? Sorry, it was accepted on 6th. So if you dispatch the letter of revocation on 3rd and it reaches on 3rd, then it is a valid revocation. It reaches on 5th, it is again a valid revocation. Why? Because the person has not accepted it yet. But if it reaches on 7th, then it is not going to be a valid revocation. Why? Because the person has already accepted your offer. Fine. Now, communication of revocation of acceptance. You can revoke acceptance before 10th. Yes or no? So if the revocation reaches the person on 9th, it is valid, because no contract is yet formed. But if it reaches on 11th, it's not going to be valid. You cannot revoke your acceptance now, because already a contract has been formed, because you communicated your acceptance and that acceptance has reached the other person. So there's already a valid contract which has been formed between the parties, and now acceptance can't be revoked. Acceptance can't be revoked. Okay, is that clear? Fine. Now, we have different types of contracts. Basically, we have something called as void agreement. We have something called as voidable agreement. We have something called as void contract. Okay, so when I say void agreement, basically it means you agree to do something which did not have any validity from the very beginning, right? And when I say void contract, it basically means that I agreed to do something which is valid, but later on it turned out to be invalid. Like, I agreed to give you 100 kgs of wheat which is there in my godown, but later on the wheat was destroyed by fire. So when I entered into the contract, it was a valid contract, but later on it turned out to be void. Why? Because it cannot be enforced now. Why it cannot be enforced? By because it is the destruction of subject matter. The subject matter is no more there. So it has become impossible for me to perform that particular contract, and hence it's going to be void. Okay, so there are valid contracts, there are illegal contracts which are forbidden by law, like sale of drugs. There are unenforceable contracts wherein it lacks the substance. Don't get into this right now. There are void contracts, which I already told you, and then we have something called as voidable contracts. What are voidable contracts? Voidable contracts are the contracts wherein one party has the right to rescind the contract and not the other party has right has this right. Okay, the other party does not have this right. How we get to know about do we have this later? How do we get to know that the other party, which party is going to get the right to resign? Well, if the consent of a party is not obtained freely, like if somebody comes and puts a gun at my head and says that sell your mobile phone for 20,000. Now the market value may be 30,000, but I agree to sell it for 20,000. Right now, I agreed. He gave me some advance also, and now he went. I'm like, I don't want to sell it for 20, 30,000, right? Now I am free. Now I can file a police complaint, etc., etc. So now I want to resign the contract. Can you do that? The answer is yes. Why? Because your consent was not free. It was obtained by coercion, right? So this is a type of voidable contract wherein you get the option to avoid the contract. Okay, you will get the option, the other person will not get the option. Okay, now listen to me very carefully. I have spoken to you about the void agreements. Void agreements means what? The agreement which cannot be enforced by law, and hence it is invalid, right? If the agreements at the time of formation are only void, then they are called as void ab initio. There are some types of contracts, or some types of agreements rather, which are expressly declared to be void. Like if you're entering into any agreement with a minor, it is void ab initio. It is void ab initio. It's not valid at all, right? So it's not that it can be enforced. You can file a suit against the minor, or you can drag him to the court. You cannot do anything. Any such thing cannot be done. Okay, now, so agreement with the persons incompetent to contract, you cannot do that. Agreements which are uncertain in meaning, they are void. Agreements where there is mutual mistake of fact, they are void. We read about this later. Wagering agreements are void. The question is, ma'am, what do you mean by wagering agreements or wagers? Wager is basically payment of a sum on determination of an event. Like, I will pay you 500 if it rains today. Now, raining is an event, and it is an uncertain event, not in the control of both the parties, right? If I say I will pay you 100 rupees if it rains today, and it actually rains, so I am supposed to pay you 100. But if I don't pay you 100 rupees, can you go to the court and file a suit against me? The answer is no. Why? Because wagering agreements does not have any validity. They are not enforceable in a court of law. They are void. They are void. Okay, however, there is certain exception. Like what? If there is a horse race for which the price is 500 or upwards, it is not considered to be the wager, and it's going to be allowed. It's going to be allowed. Okay, so this is something that you have to remember. Fine. Then the agreements whose consideration or object is unlawful. Okay, agreement whose consideration or object is unlawful, like I gave you the example that I am going to give you the drugs. It is void. It is void. If I hire you as an employee and I'm making you do two works, right? I'm paying you a salary of 20,000 and I'm making you do two works. One is the accounting and the other is supplying of drugs. Okay, that means there is single consideration you are getting for two objects. One of the object is unlawful, the other object is lawful. So the agreement is going to be void. The entire agreement is going to be void. Is that okay? Fine. Now, agreements in restraint of marriage. Agreements in restraint of marriage, you cannot stop anyone from marrying unless that particular person is a minor, right? So if you are entering into any contract that I will pay you 1 lakh rupees if you don't marry, or I will pay you 50,000 every month if you don't marry, right? And you have been paying 50,000 every month. Later on, the person goes ahead and marries, right? So is it like he was bound by the contract, and has he done some breach? No, he can still go ahead and marry. Okay, so you cannot stop somebody from marrying. Likewise, you cannot stop somebody from doing any trade or exercising his profession or occupation. That is, agreement in restraint of trade is also not is also void. That means if you stop somebody that you don't do any business, I'm going to pay you 50,000, it is void agreement. But many a times it happens, like in partnership. in partnership, if there is an outgoing, if you're in the partnership, like we are 4 partners, we will stop all the 4 partners that whatever we do, we are doing in the firm. We'll not go outside and compete with each other by doing something personally, right? So you're stopping the partner from exercising a profession or doing some business. Is it valid? Yes, this is valid. This is not considered to be agreement and restraint of trade. Okay. The other thing, we have 4 partners. One of the partners, that is the outgoing partners, goes out. Now we will stop him also that for 2 years you cannot do a competing business, right? Within these limits. So we can impose such reasonable restrictions, and that is also valid. That will also not be treated as void, saying that it is agreement and restraint of trade. No. Sometimes we also purchase someone's goodwill. So if I'm selling my goodwill, of course I'm not going to start the same business in the same name and do it like that, right? So of course in the sale of goodwill also we have certain restrictions, and that is also not going to be treated as an agreement and restraint of trade. Okay. Next is agreement and restraint of legal proceedings, right? So again, you cannot stop a party that I will do this if you don't file a suit against me, right? If I have murdered someone, I cannot say that I will pay you 1 crore if you don't file a suit against me. I paid him 1 crore and he filed a suit against me, so I went to the court and said we entered into a contract, he is breached. No, we cannot restrict anyone from enforcing their legal rights. So he can always enforce the legal rights under a contract, and we cannot stop him. If we do that, then any such contract is going to be treated as void. Okay. Then we also have agreements to do impossible task. Impossible task definitely cannot be done. Supervening impossibility, like I told you about wheat. If wheat is destroyed, we cannot do it. So it becomes void. It cannot be performed. It's not going to be enforceable. You cannot go to the court and say, why he did not give me the wheat? The wheat is already destroyed by fire. I cannot perform that contract. So it has void. It is void. Okay. Fine. We also have some contracts wherein the consideration is absent, right? So no consideration, no contract. If there is no consideration, there is not going to be any contract, and it's going to be treated as void. It's going to be treated as void. Is that okay? Clear? Okay. Now we come to the next part, which is consideration. Which is consideration. What do you mean by consideration? Consideration is something in return, quid pro quo. Right? What do we get in return? Like if I promise to teach you law, what do I get in return? Ma'am, that depends upon you. What do you want in return, right? So if I say, okay, I want 4,000 rupees, I want 10,000 rupees, I want 20,000 rupees, right? Or I want you to do this, or I want you not to use this particular space, right? Or this is your hall, I want these rights. Whatever I want, you may agree, you may disagree, but you cannot come to the shop and say that I want this particular shampoo and I'm only going to pay you 20 rupees for this. No, the promiser is going to decide what he wants. That means consideration is always going to move at the desire of the promiser, what I want. Okay. It can move from you or from some other person also, like maybe your father, right? It could be past, it could be present, it could be future. You have done something, you promised to do something, you are doing something, or you promised to do something. Like a normal sale is present consideration, future is like credit sale, right? And maybe past, you have done some past voluntary services or something like that. In the past, you have already done that, right? Consideration need not be adequate, it must be real. Consideration need not be adequate. We cannot say, because adequacy does not have any definition, right? You can sell a plate of fruits, a bowl of fruits for 20 rupees. You can also sell it for 200 rupees, right? So this is also consideration, and this is also consideration. It need not be something which the promiser is already bound to do. Okay, already bound to do, that means what? Like if somebody has to appear before the court and I tell that if you appear before the court, I am going to pay you 500. No, this is not a consideration because it is something which he is already obligated to do. Consideration must be real and it must not be unlawful or opposed to public policy. Like we cannot say that if I teach you law, you provide me these drugs, I'm really fond of it, right? So I'm asking for an unlawful consideration, which is not valid. Okay, which is not valid, right? Okay. Now we have a basic rule of called as nudum pactum, which means that if there is no consideration, there can't be any contract. There can't be any contract. However, it has certain exceptions which are stated in section 25. If there is an agreement based on natural love and affection and it is registered, because if it is a normal social agreement, it is, you don't have the intention to legally bind the other person, it is not even a valid contract. Okay, but if you have an agreement which is based on natural love and affection and you enter into any such agreement, it is duly registered, it is written, then that is going to be allowed even without consideration. Like maybe a husband is promising his wife that I'm going to pay you this much monthly, like till the time I am there out of India, some trip. Past voluntary services, which we also read under the topic of minor, right? So that is also compensation for past voluntary services. That means today time nobody is providing anything, but in the past they have rendered voluntary services, so the person has promised to pay you something. No consideration is required to make an agency, to do charitable subscriptions, to gift, right? And in case of bailment, we have read about bailment, gratuitous bailment. If you come to me and you want a book, I'm giving you the book, it is a kind of gratuitous bailment. I'll take back the book when the work is over, when you are done studying, right? But I don't want any consideration for giving you this particular book, right? Okay, then we also have something called as promise to pay time bar debt. Now time bar debt means what? I had to take an amount of 20,000 from you, right? Now I had 3 years to file a suit against you and recover that amount, but within those 3 years, I could not do anything. So now I don't have the right to recover any money from you. So ideally, like, there's no right and obligation between us, but you promised that okay, I will pay you that. You gave me a promissory note, so it is a valid promissory note, even though I am not giving you anything right now because you promised to pay a time barred debt, right? Okay, then we have you can strike this off, that's something which is not needed. Okay, now capacity to contract, I have already told you. No, I have not told you. Right. So, who is competent to contract? Somebody who is of the age of majority, who is of sound mind, and who's not disqualified, right? If I talk about minor, we have certain things about the position of minor. If you at all enter into a contract with minor, it's going to be void. The law of estoppel is not going to be applicable. So, even if he has said that he's a major or he has misrepresented his age, it doesn't matter. He can always go and say, I am a minor. He can always plead his minority and you can do nothing about it. Doctrine of restitution is not applicable. Doctrine of restitution means what? If under a voidable contract, like if somebody points a gun at me and asks him that you have to sell your mobile phone for 20,000 and I deny, but then I have to accept it, or I accepted it at that particular point of time. So he gave me an advance of 5,000. Later on, I resigned the contract. I have the right to resign the contract. I resigned the contract. Now I have this 5,000 advance. I'm supposed to give it back to him. That is doctrine of restitution. That means whatever benefit I have got under a voidable contract, or even in case of void contract, I have to return it back, but not if it has been given to a minor. So minor, there's no doctrine of restitution which is applicable to you. No ratification after attaining majority. If you have attained majority, it's not that you can ratify any contract that okay, now it's going to be valid, now I'm going to be liable. No, still any contract which is beneficial for minor can be entered, and there won't be any problem. Minor can also be an agent. but he cannot become the principal. And if he becomes the agent, he's not going to be personally liable. Minor cannot be declared as insolvent. Minor can hold fully paid up shares. He can be admitted to the benefits of partnership, right? And if you have supplied necessaries to a minor, then minor is not legally bound. But you can always claim necessaries, and minor's estate is going to be liable to for that payment. Minor will not be personally liable. If you enter into a joint contract with the minor, then the person who is major is going to be liable, but the person who is minor will not be liable. Okay. Now, persons of unsound mind. Persons of unsound mind, you are not liable. You can enter into a contract when you are at your sound mind during that lunatic intervals. And the persons who are of sound mind, they can enter into a contract only when they're sound. Like if they're half drunk and they cannot make a rational judgment at that particular point of time, you cannot enter into any contract. Then we have other people who are disqualified by law, like alien enemies. Alien enemies are who? They are citizens of or body corporates of foreign countries, and they are enemies because India is at war with that particular country. Now your existing contracts will be suspended. You cannot enter into any new contract except with the approval of central government. And if there is any contract which is against public policy, then it will be dissolved. Okay. Then we have foreign sovereigns and ambassadors, like the persons who are from different countries. They're working in embassies over here. Our laws are not going to be made applicable to them, and we cannot sue them. Convict, somebody who has been found guilty and is sentenced to imprisonment, right? He cannot enter into a contract except with the approval of central government. Company, you can enter into a contract only those contracts which are permitted by your memorandum of association. Insolvent, as soon as you're declared as insolvent, you cannot enter into any contract, right? Okay. Now, what do you mean by e-contracts? Okay, there's one more thing. Before flaw in consent, I would like to discuss this. Lawful object and consideration, right? Consideration or object is going to be unlawful if it is something forbidden by law. That means you are doing something which is not allowed under any act. Okay. Or consideration defeats the provision of law, or when the consideration is fraudulent, right? That means you are entering into an agreement to defraud somebody, right? That means you're stealing somebody or smuggling, anything like that, right? When consideration involves injury to the other person, injury means you are trying to harm my copyright which I have on my book, right? Or when the consideration is immoral. Immoral means you are letting your house on rent to run some prostitute business, right? Not allowed. Agreement which is opposed to public policy, like marriage brokerage, right? Or sale of public offices, like you're offering somebody bribe to give you the tender. So it is an agreement which is opposed to public policy, and it is going to be unlawful, and it's going to be void. Okay. Not supposed to read this. This we have already read. Then we also have a concept called as e-contracts. I don't know where have I written it. Okay, what do you mean by e-contract? It is a contract which is created, stored, and signed electronically. So they are like paper contracts only, but here you don't need physical signature. Right here, all the essential elements of a valid contract will be applicable also to e-contracts. That is, offer has to be made, offer is to be accepted, consideration, intention to create legal obligations, competency to contract, free consent, object must be lawful, everything, right? There must be certainty, there must be possibility of performance, everything. Okay, the advantages are that it can be speedy, and because digital signature are involved, the parties need not be physically present in front of each other, so it's going to have that speed, accuracy, and reliability. Okay, then we have something called as flaws in consent. Flaws in consent, that means we talk about the concept of free consent. What is free consent? Consent is going to be free if you agree upon the same thing, and that consent is not obtained by coercion, undue influence, misrepresentation, mistake, or fraud. Okay. Now, if the consent is obtained by coercion, undue influence, misrepresentation, or fraud, the contract is going to be voidable. However, if it is obtained by mistake, we have to check what type of mistake, and accordingly the contract, there will be consequences of contract. The question is, what do you mean by coercion? Coercion means threatening somebody to commit an act which is forbidden under IPC, like I will do suicide, or I will kill you, I will kidnap you, etc., etc. Undue influence is when one party is able to influence the will of another party. Why? Because they are in such a relationship, right? Like we have parent and child, like we have doctor and patient, like we have guardian and ward, solicitor and client, trustee and beneficiary, religious advisor and his disciple, right? So they all are in a position when they can exercise or dominate the will of another person, and they use that advantage to make that person enter into a contract. Okay, then we have misrepresentation and fraud. Now representation may have the effect of being innocent or fraudulent, right? If it is innocent or unintentional representation, then that's going to be called as misrepresentation, and if it is intentional, then that is fraud. Mere silence will not amount to fraud. However, mere silence will amount to fraud if you had the duty to speak. When you have the duty to speak, when it is a contract of insurance, when it is a contract of marriage, like in marriage you should tell everything, you cannot remain silent. In an insurance contract, you must tell about the chronic diseases, you cannot stay silent, right? So here you have the duty to speak. In a fiduciary relationship, if your father is doing something, you must tell your father, because we have a relation of trust. You cannot remain silent. Go check, now you know. So you cannot do that, right? So here the silence will amount to fraud. Okay, here the silence will amount to fraud, and in fact many cases when silence itself is equivalent to speech. That means you go and sell somebody that I want to buy this, is it sound? If you don't say anything, I will presume that it is sound, right? It is good in condition. So now you have to say, no, no, it's not a good in condition. If you remain silent, that means your silence has said a lot. So it will amount to fraud. It will amount to fraud. Okay. So in all these cases, the contract is going to be voidable. Now, when we come under mistake, mistake means what? We are under an erroneous belief. We believe this. We believe this. Now, this mistake could be of law, it could be of fact. Law means I feel that GST is not applicable. That means it is a mistake of law of your own country. You don't know that there is a particular type of tax for every remittance which is being deducted by a particular country. So, this is a mistake of law of foreign country. Mistake of law of foreign country is treated as mistake of fact. Mistake of law of own country, the contract is going to remain as valid, and you cannot avoid the contract on the ground that I didn't know that GST is also applicable. I didn't know this is the rate of GST. No. So mistake of Indian law, the contract is not voidable. Everyone is supposed to know the law of their own country, but mistake of law of foreign country, it is treated as mistake of fact. Now, when we come to mistake of fact, there are two types: bilateral mistake and unilateral mistake. Unilateral mistake, that means you are under a mistake. You went to a fake market and you are saying that I bought this thinking that it is original. Come on, you are under a mistake. I never said this to you, right? So you cannot avoid a contract. Unilateral mistakes are not void. They are going to be valid in most of the cases. Okay, so unilateral mistakes, they are going to be valid. This is going to be valid, right? Now, if there is a bilateral mistake, bilateral mistakes, that means you are also under a wrong impression and I am also under a wrong impression, then that is going to be treated as void. That is going to be treated as void, not voidable, but void. Like, we don't know the subject matter exists. I don't know the wheat is there. You also think that the wheat is there. I also think that the wheat is there, but wheat has already been destroyed, right? We are not sure about the identity or the title of the subject matter. I am trying to sell you this mobile phone, but I don't know that this mobile phone belongs to you only. I thought that it has been given to me by my mother, so it is mine, but ideally it belongs to you only, right? We are not sure about the quality. I think something else, you think something else. We're not sure about the quantity. I said something else, you said something else. We're not sure about the title. Okay, title is already the identity. We are not sure about the price. Like I have quoted the price to be 51,000 and by mistake I wrote it to be 41,000, right? Or maybe one zero was missing or one zero was extra, right? So we have a mistake. You had an erroneous belief about the price of a particular product, and I believed the price of the particular product was something else. So this particular contract is void. It cannot be made as a valid contract. It's going to be void, right? The next one is that there is mistake as to possibility of performance. I think that it is possible, but it was not physically possible. Like maybe the goods have been destroyed, right? Or maybe within this time this cannot be done, or there is legal impossibility that we are trying to do something which is illegal. Like maybe I told you that I will provide you 100 packets of cigarette, but then cigarette manufacturing is being banned by the government, so I cannot provide you the cigarette now, right? So such an agreement is going to be void. So what are the effects of these type of agreements? If an agreement is caused by misrepresentation, fraud, or undue influence or coercion, it's going to be voidable. But if it is caused by mistake, then it is going to be void or valid, as the case may be, right? Okay. Clear? Now we have something called as CASI contracts. Something called as CASI contracts. What are CASI contracts? CASI contracts are not contracts wherein you have like offer, acceptance, consideration, consent, but these are the contracts which are being implied by law, which are being inferred by law. So we have certain obligations which are being arised by law. What am I showing you and what am I revising? I think I am. Yes. So, law creates and enforces legal rights and obligations under special circumstances. Like the first one, we have claim for necessaries to be supplied to minors, which I already discussed. Then we have payment by an interested person. So, we have a landlord and we have a tenant, right? The landlord is supposed to pay certain taxes, but the tenant pays it on behalf of the landlord because he is unable to pay. So, if the taxes are not paid, the entire premises have to be vacated. So, he will also suffer. So, he is a person who is an interested person and he has made payment. So, when he has made payment, the landlord is supposed to pay to the tenant. Okay, if you are enjoying a non-gratuitous act, that means you got somebody's packet of fruits, it wasn't sent to you as a gift or something like that, right? But you have enjoyed it, you're bound to pay for the same. Responsibility of finder of goods, then we have something called as finder of goods. If I'm going on the road and I found a mobile phone and I picked it up, it is my responsibility to take care of it and return it to the true owner, right? Then if I have got any money under coercion, right, I am bound to return it. I am bound to return it. Okay, then we also have something called as contingent contract. What are contingent contracts? They are contracts to do something or not to do something if some collateral event happens or does not happen. Like contract of insurance, I will pay you a sum of 10 lakh if there is a fire occurred in the godown. So occurrence of fire is some collateral event which is not dependent upon our wish. It is a collateral event. It may happen, it may not happen, right? And what are we promising? I promise to pay you 10 lakh and you promise to pay me the premium. So these are our set of obligations, right? I promise to give you that risk cover if something happens. Now, there are certain things that the event, it must be uncertain, it must be collateral, it must not be our reciprocal promises, and it must be something which is not in our control, right? And it need not be some external event only, it could be your act also, like accidents, right? If you're going on the road and you hit a particular car, so it is caused by your act only, then also you will get the cover. Okay, now there are some rules relating to enforcement of contingent contracts. If the contract is contingent on happening of an event, that if this happens, if the fire occurs, it will be enforceable when the fire will occur. It will become void if occurrence of fire becomes impossible. Like maybe if it is said, if ship sinks, then if ship comes back, that means it is impossible that this event is going to happen. Or expiration of time, that maybe I have given the risk cover for 2 years and 2 years have expired. Now if it is contingent on not happening of an event, like if I say that I will pay you 10 lakh if the ship does not return, so ship has sank, that means it is enforceable. Expiry of time, if the ship does not return within 2 years, so within 2 months, the 2 months period has expired, so now it's going to be enforceable. Or it becomes void, that means ship has returned. When ship has returned, then you will not be getting this, so it becomes void. Okay, fine. Okay, now we have something called as discharge of contract. Discharge of contract, right? How do you discharge the contract? Contract can be discharged by performance, if you actually perform or you attempt but the other person is not ready to accept your performance, right? You have made an attempted performance but the performance has not been accepted. Discharge by agreement. Agreement, like you had agreed to certain terms, now you alter the terms, so you are agreed to now new terms, or you change the terms, you substitute the contract and you enter into a fresh contract, maybe with the same party, maybe with the other party, so that is called as novation, right? So that is the difference between novation and alteration. You resign the contract. You resigned the contract, like you placed an order for 100 bales of cotton, the next day you call and say I don't want the 100 bales of cotton, so you've rescinded the contract. Now if it is a valid rescission, the other person can claim the person who has validly resigned the contract can claim damages also. And if you have got any benefit under this, then you're supposed to pay back the benefit. Pay back the benefit. Okay, then if the contract becomes impossible to perform, it becomes void and you are discharged. If the time is over, you are discharged. If by operation of law you are discharged. Operation of law means what? Mr. X promised to paint a picture, Mr. X died. Can this contract be performed? The answer is no, the contract cannot be performed, right? Because the promiser has died. Okay. When a person is declared insolvent, he is discharged from his liability up to the date of his insolvency. Obviously, if you materially alter any contract without the approval of the other party, the contract comes to an end. The contract comes to an end. Okay. Now, when the promiser becomes the promisee, maybe there are two companies who have contracted with each other and they are merged. Or maybe A has given a negotiable instrument to B, B to C, C to D, and D to back to A. So A is supposed to make the payment, A is supposed to receive the payment, the contract is discharged. Nobody is going to do anything. So that is by operation of law. Okay. By breach also it is discharged. If one party has breached, then also it is going to be discharged. So these are the cases of discharge of contract, right? Okay. Now we also have something called as assignment. Assignment means transfer of the rights from one person to another, like transfer of right to receive payment, transfer of right to sell this, right? Whatever it is. Now many a times transfer of right takes place, assignment is valid, and in some cases assignment may not be valid. Like when we read about the directors, we get to know that under the chapter of directors there's a section called as section 166 which talks about the duties of directors, and it says that a director is not uh, allowed to assign his office. That means he cannot transfer his rights, that a director will be responsible for this or director will have this obligation. Here you are transferring your rights or you are transferring your liabilities, right? You're transferring your rights or you're transferring your liabilities. You can do that. Many a times even banks do that. Banks, when they have the right to receive or recover the amount that they have given on loan, they give it, they sell their NPAs, they give it to then under surfacey, they give it to the asset reconstruction companies. Now asset reconstruction company, you get the right to recover that money, right? Right. So that is what is called as assignment. Now, we also have a unit called as representations and warranties. Basically, representations, misrepresentations, we have already discussed. And when we talk about warranties, they're not defined over here. And basically, warranties means indemnifying the person, and that we read as a contract of indemnity. Then we also have a unit called as impossibility and force majeure, right? Again, we have read this. We have read that if a contract becomes impossible, then it becomes void, right? So you cannot do an impossible task, that is going to be void only. Then we also have something called as force majeure clause, right? Force majeure clause maybe is entered into the contract, which means that you identify these events. If this happens, the contract will be discharged and we will not be liable to do this, to do that, right? Like example, COVID, right? When the pandemic hit, there was complete lockdown, the parties were not able to perform their obligations. So it is not that it is going to arise a lot of remedies, breach, compensation. No, it is a case where it becomes impossible to perform the obligation. So we put force majeure clause where we identify the events that if this happens, then this would apply the force majeure clause, and we will not be responsible to perform our obligations, and the contract will become void. Okay. Then we also have something called as tender procedure of government contract. Okay. So we have the procedure of tender. What is tender? Tender is like an invitation to offer, which the government releases, and government tells its specifications that these are the things I need. Now all the suppliers can actually apply for that tender. They can bid, right? They say that I am ready and I am willing to supply this to you for this particular price and this quality, right? So the government is going to analyze, and the best suited tender is going to be given. Now, because it is talking about government contracts, because we are talking about public finance which is involved over here, we have to be very careful and cautious. So under Ministry of Finance, we have a Department of Expenditure which has issued some general financial rules. Okay, in that general financial rules, we have rule number 145, which talks about the authorities which are competent to purchase goods. We have rule number 144, which simply says that every person who has the authority to buy goods, to procure goods, that to make public procurement out of public funds, you have to be responsible, you have to be transparent, you don't have to be biased towards a particular supplier, and maintain that fair procurement system. Okay. In fact, when you are making public procurement, you should satisfy yourself to certain things and follow certain things, like whatever you're procuring, please procure not in very large quantities but in normal quantities, right? Not in excess quantities. Always in your RFT is the request for tender, which is a document. Please specify what quality you need, what brand you need, what is your technical specification, what is the quantity you need. Everything should be clearly specified so that suppliers can actually fill correct tender and the comparison becomes easier, right? This offer should be made in a fair and transparent manner. In fact, we have a government e-portal for the same, through which this public procurement is done, right? And whenever you're selecting an offer, please keep noting why you're selecting an offer, what are the considerations that you have done, right? And please satisfy that the price they are charging is in accordance with the quality that they're delivering or not, right? The complete cycle should be actually recorded, and every ministry, every department, you must prepare an annual procurement plan. Okay. Okay, next we have the special types of contracts which we need to revise. So the first that we are going to revise is the bailment and pledge. We have the contract of indemnity and guarantee, bailment, pledge, and agency. Okay. So the very first one, bailment. We have two parties. One is the bailer, one is the bailee, right? The goods are delivered from one person to another for some purpose. When the purpose is accomplished, it is given back, returned, or disposed of according to the directions of the person who is delivering them. For example, I give you my book. Why do I give you my book? Why? Because you want to read it for one day, right? So you have taken my book. That means my book has been delivered from me to you. And when you read it, you will return it back. Or I may say that you can keep the book, or you can give the book to somebody who's needy. So you can dispose of according to the instructions which I am giving it to you. So I am the bailer. That is, I am the person who is delivering the goods to you. You are the bailee. That is, you are the person to whom the goods are being delivered. Right now, delivery is the most important thing when we talk about bailment, and delivery can be actual, it can be constructive also. Constructive includes symbolic for our purposes. Okay, that means even if I'm giving you the car keys, it's as good as delivering the car. That is what it means, symbolic, right? Symbolic or constructive, whatever you may say. Although there's a thin line of difference, but it's okay. So now, what there are certain essential elements required in a contract of bailment. That is, bailment can be only for movable goods. It can never be for immovable goods. It can never be for money. The possession has to change, and the goods must be delivered for some purpose. Like if I am selling the goods, it is the transfer of ownership, and that is not covered here in the case of bailment, because in the contract of bailment, the transfer of possession is there, not the transfer of ownership. I continue, and bailer continues to remain the owner of that particular goods, right? Okay, now bailee, it is your duty to return the goods in the same manner. That is why when we keep or deposit money in a bank account, it is not treated as bailment. Why? Because if I'm depositing 50,000 and I can take back 50,000 when I want, no, it is not bailment. You're not going to get the same identical currency notes, right? Likewise, if I go and put my things in a locker which is maintained by the bank, that is again not bailment. Why? Because it is, the possession is not changing. I'm not handing it over to the bank. In fact, the keys are with me only. So it's just kept in the bank's premises safely, right? It is not in their possession. So possession must change, right? So bailee, you can always have to return the same goods. You cannot return some other goods that, okay, he has given this, I will return goods of higher value. No, no, no. It's the same goods which are being returned. We have the bailment of two types. One is gratuitous bailment, the other is non-gratuitous bailment. Gratuitous bailment means it is, we are not charging anything. It's not commercial, it's not for hire, it's maybe for help, it may be for benefit of somebody else. Like you wanted the book, I gave it to you, so it is for exclusive benefit of the bailee. I am going out and I want my pet to be taken or care of, so I give my pet to my neighbor. It is for my benefit, so for the benefit of bailer, right? When we talk about non-gratuitous bailment, it is for mutual benefit of both, because both are doing something. Like if you take a taxi on hire, right? So the taxi person, what is he getting? He's getting the price, I'm getting the taxi, so it is for mutual benefit of both, right? So that is called as non-gratuitous bailment. Now all we have to read is about the duties, right? So first of all, we will read about the duties of bailer. Now duties of bailer are as good as rights of bailee and vice versa. Okay, now, the first thing is duty to disclose faults in goods. Right now, there are two types of bailment, gratuitous and non gratuitous. If I am giving you gratuitous bailment, like you want my car, I'm giving you my car. Well, maybe there is some defect in the car which I do not know. The defects that I know, I will disclose it to you. But the defects that I not know, I do not know that the brake is failed, right? So I am not liable for that. If it is a gratuitous bailment, liable to disclose known faults only. But if it is a non-gratuitous bailment, that is, you are taking a taxi on hire from somebody who's doing that taxi business, I don't care whether you know the brake was fail or not. You're supposed to know this, and hence you're liable to disclose all the faults, whether they were known to you or they were not known to you. If you do not disclose, then bailer is going to be liable for the loss. Bailer, whoever is giving. The second case, duty to pay necessary expenses. Necessary expenses means, again, we have two types of expenses, ordinary and extraordinary expenses, right? Extraordinary expenses, like you have taken a taxi and it breaks down, then you have to change that engine oil, etc., etc. So there are heavy repair charges. And normal expenses like the petrol, toll, etc., etc. Okay. So if it is a case of gratuitous bailment, it is going to be paid by the bailer. If it is a non-gratuitous bailment, then it is going to be paid by the bailee. Okay. In case of extraordinary expenses, bailer is liable to pay. You take my car, what usually happens, the ordinary expenses, of course, we will not ask you to get that done, right? So this is how it has been structured. Now, if the goods are lent gratuitously and bailor does any premature termination, then he must compensate Bailey for the loss or the damage. What do you mean by that? For simple thing, if I have given you the book and tomorrow is your exam, right? And I tell you that, okay, you can take the book for one day. Now, after 1 hour only, I call you and I take back the book. That means you would suffer losses, right? You got very less benefit, but you have suffered huge losses. So, whatever loss you have suffered in excess of the benefit, that I will compensate to you. Okay. Next is if the defective title of the goods. Now, I gave you a car which is defective and somebody caught you and you had to pay some penalty, right? So I will indemnify you for the same, because the defective, there was the title of my goods was defective, and because of which you have sustained the loss, right? Duty to receive back the goods on termination. Of course, if I have given you the books, I have to take it back also, right? Now we come to the duties of bailey. The duties of bailey, or let's first go to the rights of bailey. Get the goods returned. It's the duty of the bailier to return the goods, and it's your duty to it's the duty of the bailier to take back the returned goods, and it's your duty to return the goods. To claim indemnification if there is defective title of goods, to receive compensation if the faults are not disclosed, to receive ordinary expenses and extraordinary expenses, to file suit for the for deciding the title against the wrongdoer. You get this right to exercise right of lien. Right of lien means what? Like supposedly you open a garage company and somebody has given his car for repairs. You repair the car, but that particular person is not paying you the repair charges. What you'll do is retain the car till the charges are not paid. So you have this right of lien, right? We have right of lien, which is can be general, which can be particular. General lien is against a general balance which we have, like the banks. There has to be an agreement for the same, then only you can exercise the, then only general lien can be exercised by the bankers. And we also have the case of particular lien. Particular lien, that means the case just I told you, if I am a tailor, I have sewed some good clothes. Unless you pay the charges, I'm not going to return you the clothes. Why? Because I have exercised some skill or labor on those goods and I have the right to retain it till I am being paid for the same. Okay, so that is right of lien. Now we go to the duties of bailey. Bailey, your first and the foremost important duty is to take reasonable care of the goods. If you take care of the goods, then you're not liable for the loss if it happens without your fault or negligence. Okay, okay, fine. Now, you're not supposed to make unauthorized use. Like if you have got the car for repair, just repair it and give it back. You're not supposed to lend it on hire. So you are making unauthorized use. And if you do that, then you are going to be responsible for the loss. It's your duty not to mix the goods. If you have mixed with bailor's consent, fine, no problem. The parties are going to have proportionate interest. Even if not mixed with bailor's consent, then also the parties can have proportionate interest. But if it is mixed without consent and it's separable, then bailey, you are going to pay for the expenses of separation, if any. And if it is not separable, then you have to compensate for the loss. Okay, then it is your duty to return the goods. Duty to return the goods when the time period is over, when the time period is expired, or when the purpose is accomplished, or within a reasonable time, right? If you do not return the goods within a reasonable time, then beyond that reasonable time, even if you have exercised due skill and care and without any fault or negligence, there is some loss which happens to the goods, you will be responsible. The bailey will be responsible later on, right? So if not returned, the goods are at the risk of bailey now, and bailey is going to be responsible for any loss, damage, even if without negligence. Okay, it is your duty to return accretion to goods. Accretion means addition. Like if I have given you the cow and cow gives birth to a calf, then I am entitled to both cow and the calf. Okay, bailey, you have no right to allege that bailor had no authority to bail the goods, right? That is, you cannot set up adverse title. You cannot say that, oh, these goods belong to me only, right? No, you hold it on behalf of the bailor, and you cannot deny his title. Fine. Then we come to the rights of bailor. Rights of bailor. If bailey does anything inconsistent, terminate the bailment. Demand back the goods, like I gave you a car on hire, I cannot demand it back. But if I have given you a car gratuitously, I can demand it back. But then we have to assess the cost and benefit. If the loss is more than the benefit, then I have to compensate. Okay. Right to sue third party who does any damage. See, there are two things. Whenever a third party is going to interfere and says that this is my property, it could be wrongful intervention or correct intervention. If it is correct intervention, that means you had defective title, you need to compensate the bailee. But if it was wrongful intervention, right, wrongfully they are trying to cause any injury, or they are trying to say no, these goods are mine. So in this situation, bailee as well as the bailer, they both get the right to sue the third party. Okay. You can get the bailie's duties enforced if he's not doing his duties properly, right? You can also claim damages from unauthorized use. You have the right to get accretion of goods, and you also have the right to claim damages if the goods are being mixed by the bailee and they cannot be separated. Okay, is that okay? So all the rights are clear. Now we have the case of termination of bailment, when the bailment comes to an end. When there is a fixed period and that period expires, if the bailment is for a particular purpose and that purpose is accomplished, if it is a gratuitous bailment and you have asked to return the goods, if the person makes inconsistent use and you terminate the contract, or either of the parties die in case of gratuitous bailment, or the goods bailed are destroyed. Right? So in all these cases, there would be termination of bailment. Now, we also have something called as the finder of goods, which is a kind of bailment only, right? It is, although it is a quasi-contract, which is not a contract which is made by us, but it is a contract which has been inferred by law and implied by law, made by the law, right? Now, what happens? He has the same rights and duties as of the bailee and is also entitled to the following rights. Okay. If you are walking on the road and you find a mobile phone, what you can do is just look at the mobile phone and walk ahead. You don't become the finder, but if you pick it up, you become the finder. And now what you can do is, if there is any specific reward announced that if you find this, I'll give you 20,000, and you go, the person does not give you that reward, you can do two things. One, keep the goods with you unless the reward is being paid. Second, file a suit for the reward, right? So you can do both these things, right, to recover specific reward. Okay. Now, many a times it happens that you pick up the mobile phone, you found that the mobile phone screen is broken, so you go to the repair shop, get the mobile phone repaired, right? So if you have incurred any expenses voluntarily just to preserve the goods, maybe just to preserve the goods, then you have the right to recover the same from the bailer, from the person who is the true owner, right? From the true owner. Now, what if he denies? He says, I'm not going to give it to you. Then you can keep the goods. Then you can keep the goods, but you cannot sue him for recovering expenses. Okay, you can sue him for specific reward. You cannot sue him for recovering expenses. Now, in some cases, you get the right to sell these goods. When you tried to find the true owner, he cannot be found, or you found him, but he's not ready to pay your expenses. So in both these cases, if the goods are of perishable nature, or if your charges have already amounted to 2/3 of the value of the goods, that means the value of the goods is 9,000 and you have already paid more than 6,000. Okay, so you can sell and you can keep the proceeds, right? Okay, fine. Next is contract of pledge. Pledge is nothing but a special type of bailment. So we have exactly the same things which we have read in bailment, and it's extremely easy to revise. Okay. So bailment, we had two parties. Pledge also, we have two parties. We have pledger and pledgeor, pawner and pawnee, right? The only thing is that it is a special type of bailment where the purpose is specified. In bailment, we read that the goods are delivered from one person to another for some purpose, for security. That is it. That is the only difference. When goods are delivered from one person to another for security, for payment of debt or performance of a promise. Like if you're taking a loan from the bank and I want to pledge my gold, right? I'm giving gold as a security. This is a contract of pledge. Why? Because gold is going to be delivered from one person to another as security. And when that purpose is accomplished, it's going to be returned back to me. Okay, so like we have the duties and liabilities of bailer and bailee, we also have it of pawner, pawnee, right? So what is it? The rights of pawnee. That means basically the bank maybe. He can retain the goods till the debt is paid, retain goods till subsequent advances are paid off, receive extraordinary expenses for preservation. Maybe you have given the goods which needs a lot of expenses for preservation, so you're entitled to get that. Sell goods if there is default and sue the pawner. Okay. What are the rights of the pawner? I will recover the goods. I will enforce pawnee's duty if they're not taking reasonable care of my goods. Receive increase, that is accretion. Get the goods taken care of. Receive notice of sale of goods. If there is default, you cannot sell the goods just like that. You have to give the notice of sale. Okay, thereafter you can sell the goods. Okay. Duties of pawnee: to take reasonable care of the goods, no unauthorized use, return goods, not to mix you goods, and return the increase. Duties of pawner: you have to pay the debt, pay deficit on sale. Supposedly you had given the security of 5 lakhs and your loan was 6 lakhs, so there is a deficit of 1 lakh which has to be paid even if the goods are sold. Pay extraordinary expenses. Disclose the faults in the goods. If you have given a horse and that horse is unsound, you must disclose it. If you are not disclosing it and the bank or the bailey or the pawnee suffers losses because of you, then you have to compensate. Okay. Also indemnify pawnee for the defect in title, right? Next we have the contract of indemnity. What is the contract of indemnity? Indemnity is like an insurance contract. Okay. We also have different pledge. Like pledge can be usually made by the made by the owners only. However, in certain cases pledge by non-owners is also allowed. What is that? Like if a pledge is made by a mercantile agent means he's an agent in the ordinary course of business and he has the goods given to by the principal to him, and he is taking loan against those goods, etc., etc. He's pledging, so he can do that and it's going to be a valid pledge only, right? Sometimes we have got a mobile phone under a voidable contract, right? It may be resigned, but till the time it's not resigned, if I pledge it, it's fine, right? If I am a co-owner, right, and I have the goods in my possession, I can make a valid pledge and it's going to be liable and it's going to be a valid pledge, right? If I have purchased certain goods but I could not carry those goods to my home, so I've kept it at the shop only. Now the seller, though he's not the owner of the goods are in his possession, he has pledged those goods, he can do that and it's going to be making a valid pledge only, right? Now when we talk about contract of indemnity, we have two parties. One is the indemnifier, one is the indemnified or the indemnity holder. What happens is basically indemnity means making good the loss, right? So when you are promising to save the other party from the loss which is caused by the conduct of promiser or by the conduct of any other person, like you're walking on the road, you're taking a car and you hit the footpath, right? There is accident. The accident, we have an insurance company who's going to give you the cover. This is an act which has been causing you loss and this is your act only. So this is loss caused to the promiser by the conduct of promiser himself, right, or by the conduct of any other person. Okay. Indemnity can be express or implied. And we have one section, that is it. We have just to have one section, section 125, which talks about the rights of indemnity holder, right? Indemnity holder, that means I am entitled, like maybe I am a director in a company and the company has taken insurance that if my director is made liable, then the insurance company will bear that, right? So somebody files a suit against a director. Now you have to defend that suit. In defending that suit, there will be a lot of cost which might be involved, right? When I defend the suit, I may enter into any compromise and I have to pay certain things, right? Or maybe the judgment is final and I have to pay the damages, right? So whatever I am compelled to pay in a suit, then that I can recover from the insurance company, then I can recover from the indemnifier who has promised to save me from the loss. So right to recover damages, right to recover cost of suit, and right to recover the sums which are being paid in a compromise. Okay. Then we have the contract of guarantee. What is a contract of guarantee? Here basically we have prima facie three contracts. One is the contract between surety and principal debtor, one is the contract between principal debtor and creditor, and one is the contract between surety and creditor. This is the main contract of guarantee, whereby one person is taking guarantee of the other. This person wants a loan, This person wants a loan, or this person wants goods on credit. This is the creditor who is not ready to give the goods on credit. So he steps in and says that I guarantee you give the goods on credit. If he doesn't make the payment, I will. So the person who has taken the guarantee is called as surety. The person in respect of whom the guarantee is taken is called as the principal debtor, and the creditor to whom guarantee is given. Okay, so it's like to perform to discharge a liability or do something in case the third person does not do or does not pay. It should have all the essentials of a valid contract. The consideration is going to be according to section 127, which basically means although you are not getting any direct consideration, like if I am taking a guarantee of somebody, what am I getting? I'm not getting anything, but because the other person is getting goods on credit or he's getting a loan, that is sufficient consideration for me also. Okay. The parties should be capable to enter into contract. Principal debtor can be incompetent to contract, but the surety has to be competent to contract only. It could be oral, it could be written. The debt has to be legally enforceable and not time barred. If it's time barred, there is no obligation. Why will I take the guarantee? There is no obligation, right? The primary liability will always be of the principal debtor, that is, he has taken the loan or he has taken the goods on credit, so he is supposed to return the goods, he is supposed to make the payment, right? But if he does not pay, then on that condition or the secondary liability, surety will be liable. Okay. If you obtain the guarantee by misrepresentation, it is not going to be valid. It is not going to be valid. Like if there is a creditor and he wants that, he wants to know, or there are three parties. Okay, one is the person who wants to get employed in the company of this creditor. Okay, so we have this principal debtor, we have this creditor, and I'm the surety, right? So this particular person has to be employed in this company, and this creditor says, I will employ you if Shivangi gives the guarantee. I say, okay, fine, I'm ready to give the guarantee. Now, this employer doesn't tell me that in the past also he has employed this particular person 3 times and he has done theft every time. So there is a material circumstance which the creditor is not telling me. He's keeping silence to it, right? So in such a situation, what happens? The guarantee which I have given has been obtained by misrepresentation, because you have not told me something or you have incorrectly told me something, right? So this guarantee is not going to be valid. Okay. Now, if there is another condition, I may say that I will act as a surety if the other co-surety also joins. So if the other co-surety does not join, then again the guarantee is not going to be valid. Now we have two types of guarantee. One is specific and the other one is continuing. Specific means only for a particular transaction, and continuing for a series of transactions. Like I may say that provide him goods for doing business and on credit, and I take his guarantee. So every time the goods are being provided on credit, I am the guarantor, right? So it is not extended to just one transaction but to a series of transactions. Now what happens if it is a specific guarantee? I can revoke it anytime before the liability has accrued, right? Like if I say that you give him the mobile phone, I will pay you if he doesn't, and you haven't given the mobile phone yet, I can come and I can revoke the guarantee, I can take back my guarantee. But if you provided the mobile phone, that means liability has already been incurred, he's already obligated, and then I cannot take back the guarantee, right? But in case of continuing guarantee, I can revoke the guarantee in respect of future transactions and not in respect of the transactions which have already been done. So for that, I'm going to continue to be liable, right? Now surety's liability is coextensive with that of the principal debtor. That is, whatever is principal debtor liable for, the surety is also liable for that. Okay. Surety's liability arises when the principal debtor defaults. As long as he's making payment, surety is not liable. But as soon as he stops making payment, the surety becomes liable, right? So creditor, you can sue the surety directly. You don't need to sue the principal debtor first. And if he does not pay, then you will sue. No. If he's not paying, fine, you can sue the surety directly. That is not a problem. Now, when we talk about the rights of the surety, he has certain rights against the principal debtor, certain rights against the creditor, and certain rights against other co-sureties. What are the rights against the principal debtor? Principal debtor, I have the right to indemnity. Indemnity means if I have paid some sum to the creditor on your behalf, then you're liable to pay that to me. Yes? Okay. I also have the right of subrogation. Right of subrogation means what? It means that I get all the rights which the creditor had. You had given some rights to the creditor, like you had given your security, right? You had given other things. Now, if I am making the payment on your behalf to the creditor, I become your creditor, right? So like step into the shoes of creditor. That is what it means, right of subrogation. Then right against the creditor. Creditor, I am entitled to claim set off if there exists between you and the debtor, or you and me, right? And I'm also entitled to claim the securities. If I'm making the payment to you and you have the securities, then that securities are now mine. Right against the co-sureties. Now, co-sureties, if there are three co-sureties, everyone is liable to contribute, yes or no? Now, the co-sureties may be individually as well as jointly liable. So if I'm individually liable and the entire amount has been taken by me, then I have the right to call other co-sureties and say that you are also liable to contribute. Like if the amount due is 3,000 and there are three co-sureties, unless otherwise agreed, they are going to bear it in the equal ratio. And the right to share benefit of security. So if I get the security, I have the right to share that benefit with all of them. Discharge of surety. When the surety is going to be discharged? Surety is going to be discharged if revocation happens. Revocation, that means the guarantee has been revoked. I have given the notice to the creditor that I revoke the guarantee. How can the guarantee be revoked? We have discussed about both the types of guarantee, that is specific and continuing, right? If the surety dies, right, so continuing guarantee will automatically be revoked for future transaction, and the guarantee which has already been invoked, the estate is going to be liable. Okay. Then by novation, if the parties have entered into a fresh contract, then obviously I'm discharged. Obviously I'm discharged, right? If you obtain the guarantee by misrepresentation, it's going to be invalid. If the guarantee has been obtained by concealment, it's going to be invalid, right? If you have obtained the guarantee, or you have said that I will become the surety only if the other co-surety joins, then of course it is going to be invalid, right? So these are invalidation. If misrepresentation, concealment, non-joining of co-sureties, right? Okay. Now, if the variance in terms of contract, that means you both, that is the principal debtor and creditor, you change the terms of contract without informing me, I am discharged, right? I am discharged. Okay, this has a point. In fact, we discussed a case law also. Then comes by release of principal debtor. If principal debtor is released, that means you have discharged him by entering into a new contract, or you have discharged him by entering into any composition, right, without taking my consent, or you have agreed that you will not sue him, or you have extended time without my consent. So in all these cases, principal debtor is discharged, so am I discharged. So am I discharged. Okay. If the creditor loses the security, then I am discharged to the extent the security is lost. You were being given gold as a security and you lost the gold worth rupees 50,000. Now I'm not liable for that 50,000. My liability will also be reduced accordingly. Now, if you do anything which is inconsistent with my rights, or which impairs my eventual remedy, then also I am discharged, which means that I had told you to lend the money in installments and not in one go. You had lent the money in one go. Now he took the money and he ran away, right? So I am discharged. Why? Because you impaired my eventual remedy, right? Now we have the contract of agency. What is agency? Agency basically means, agency, the term has not been defined, but we know what an agent is. Agent is somebody who has been employed to do something for the other person or represent someone else in front of the third persons, right? So we have two people involved over here. One is the principal, one is the agent. Okay. Now, agent can be anyone, even a minor or unsound person who is employed to do any act on behalf of the other person. But principal, you can be only major and sound person. No consideration is needed for creating agency. Agency can be created by many ways: by express agreement, oral or written; by implied agreement through conduct and behavior; by estoppel, which is as good as implied agreement, when you let yourself be represented in front of third party that he is your agent, then you're bound by that agent and you become his principal by estoppel, right? By necessity, sometimes I hold your goods and I'm unable to communicate to you that goods will be lost or the goods will perish, and as a man of ordinary prudence I feel to take action on your behalf, then I become an agent by necessity. Operation by law, partnership. Every partner is an agent of the other partner. It is created by law only, you can do nothing about it. Okay. By ratification, like if I go and buy goods on your behalf and later you accept those goods, that is an agency which is created by ratification. Okay. Clear? There are some essential elements of a valid ratification of agency. That is, ratification could be express, ratification could be implied, but you should have full knowledge to make it a valid ratification. If your knowledge is materially defective, it's not going to be a valid ratification. You can either ratify the whole transaction or reject the whole transaction. You cannot do that part ratification. You cannot ratify an act which is causing injury to third person. Like if I want my flat to be vacated and somebody goes and vacates this is causing injury to the tenant, and despite the fact that I want to accept your act and make you my agent for this purpose, I cannot do that. Okay, the ratification has to be done within a reasonable time and you must communicate the ratification. And moreover, ratification can be done only for lawful acts. Only for lawful acts. If the acts are not lawful, you cannot do the ratification. That means if somebody has done some kidnapping, you cannot do that ratification. Okay. Now, extents of agent's authority. Agent, you can do all the lawful acts in the normal circumstances which you have been told to do. In emergency, you can do beyond that which an ordinary man would do to prevent the losses. Okay. What are your duties? You have to conduct business in accordance with the directions of principal. Okay, so that means whatever directions you're getting, if you're getting the directions to sell the goods not at below cost, don't sell it at below cost. Okay, you have to work with reasonable diligence, skill, and care. That means if you're taking care of the goods, take care of the goods. If it is raining, keep the goods inside, etc., etc. Not to deal on his own account without knowledge of principle. That is, you are being told to go and do a deal of land. Now you went there and you thought that the deal is really good, let me buy the land myself. So you are dealing on your own account, which you're not supposed to do that, right? If you do that, the principal can repudiate the contract and also claim benefits from the same. Okay, you have to render proper accounts. You are not supposed to make secret profit in this situation. Also, the principal can repudiate the contract and claim damages, right? Not to make secret profit means what? I told you to sell my mobile phone, you sold my mobile phone for 45,000, but you kept 5,000 in your pocket. That means you have made secret profit and kept it in your pocket, right? To remit all the sums which is received in principal's account. So whatever you have collected on behalf of the principal, you are supposed to give it back to the principal. Not to delegate authority. Ideally, it is not allowed to appoint a sub-agent. However, there are cases when you can lawfully appoint a sub-agent. Okay. Not to use information against the principal. Against the principal means what, ma'am? See, whenever we are doing work for anyone, we get a lot of insider information. We're not supposed to use it. We're not supposed to disclose the trade secrets, etc., to anyone. Okay. Now, rights of an agent. Agent, you get the right to retain money out of the sum. Supposedly, of course, you are entitled to remuneration. You are entitled to the expenses that you have borne on behalf of principal. So if you have collected and made sale for the principal for an amount of 5 lakh and you have incurred expenses 1 lakh and there is a commission 50,000, so you can deduct that 1,50,000 and remit the balance. So you can retain money out of sums received in agency for the principal. You have the right to receive agreed remuneration. If no remuneration is agreed, the usual remuneration which is there in the custom. If you are guilty of misconduct, then you will not be entitled to remuneration. Okay. You also have the right of lien. If you don't get the remuneration, let's say I gave you certain goods to open an agency, okay, to sell the goods. So you have sold like goods worth rupees 50,000 on which commission is due of rupees 10,000. Now you still have my goods. I tell you, give my goods back. right? So you will not give the goods back until that 10,000 remuneration has been paid to you. Okay. If you give back the goods or the goods are being stolen, then you lose this right, of course. You can claim compensation if any injury is caused to you because of principal's neglect. He was supposed to do something he didn't do, and that is the reason you have been caused some injury. Then you can claim compensation for the same. To be indemnified by the principal against consequences of lawful acts done in the authority, right? Let's say you provided goods to a customer and the customer filed a suit against you. You have done everything lawfully. You are going to be indemnified by the principal. Okay. So whatever acts are done in good faith that caused injury to third party, for that also the principal is going to indemnify you. But if you have done any criminal act, like you have fought with the person, you have kidnapped with the person, then the principal is not going to be liable. Okay, then the principal is not going to be liable. Now we have something called as irrevocable agency. What is irrevocable agency? The agency which cannot be revoked, like agency coupled with interest. Now here what happens, there is interest of agent also involved. That means if I say that I have taken a loan from you and I have to pay you 50,000, now I'm not paying you 50,000 since a long time. I have a car, I tell you that okay, you come sell this car, and from the sale proceeds of this car I'm going to pay you back the 50,000. That means if you sell this car, there's another interest of you which is involved, right? So it is an agency which is coupled with interest, right? And that interest exists at the time when we are creating the agency. So you cannot terminate this agency to the prejudice of such interest. That means either pay his 50,000 or make some arrangement for the same and then terminate the agency. Otherwise this agency is not going to be terminated. Okay, fine. We have another type of irrevocable agency where the agent has incurred a personal liability. That means what? I told him to buy some goods and he has got the goods in his own name. Now I am supposed to make the payment. I cannot leave him like that. That okay, you see that you have, because he has done it for me only. So he has incurred personal liability in his own name. Now the person will come and sue him only, but he has actually got the goods for me, no? So I cannot revoke the authority like that, right? Now we talk about the liability. First of all, we are going to talk about principal's liability to third parties. When agent is acting within the scope of his authority, principal is going to be liable. When he exceeds his authority, we will see whether it can be separated. If the task can be separated, then principal is going to be bound for the acts which have been done within the authority and not for the acts which are done outside the authority. But if cannot be separated, then principal is not bound for the whole. Okay, principal is not bound for the whole. Okay, now this I have already told you. Now we come to agent's liability. Agent is not personally liable. That is one simple thing. But in certain cases, agent becomes personally liable. If the principal is foreign, we are going to make you only liable. When you do not disclose the name of the principal, when the principal does not extend, when you are a pretended agent and your agency is not being ratified by the principal, so he disowns you, so you are only going to be liable. When you exceed your authority, then you become personally liable. When it has been expressly provided in the contract that you are going to be personally liable, or when you sign the negotiable instrument in your own name, then you are going to be personally liable. The third parties also have certain rights. What are the rights which are there with the third party? Third party did not know about the principal, right? So when they got to know, oh, you are not the principal, you're the agent, who is the principal? Then, oh, this is the principal. Had I knew that this is the principal, I would have never entered into a contract. So you get the right to resign the contract. Okay, you don't know about the principal. Now the principal wants the performance to happen. Fine, the performance will happen, but it will be subject to the rights and duties that the agent and the third party have decided. Okay, when the agent is personally liable, the third party may make the agent or principal personally liable. They have this right. Okay, and they will have limited right if it is clearly communicated that if something happens, he is going to be liable, I will not be liable, right? So exclusively that particular person will be liable, then you can make only that particular person liable. When the termination of agency takes place, that is when agency comes to an end, when you revoke the agency. When you revoke the agency, there are cases when the agency cannot be revoked, and these are called as irrevocable agency, which we have already done, right? Okay, now if the agency is revoked before a fixed period, right, then you must make compensation and must do it after giving a reasonable notice. Okay, now Principal, you can revoke the agency. Agent, you can also renounce the agency, let it go, that I don't want it anymore, right? But you also must give reasonable notice, and you also must compensate if it is a premature termination. When you were being appointed as an agent and that leads to the completion of business, when the principal or agent dies or becomes insane, when there is insolvency of principal, when the period expires, when there is mutual agreement between the parties to terminate the agency, or when there is destruction of subject matter. Like I told you to sell my mobile phone, that is destroyed, right? What will you sell? The agency ends. Now we have some concept called as sub agent and substituted agent. Sub agent means agent appointed by the agent under the agent. Substituted agent means agent appointed by the agent under the principal, right? So for the acts of substituted agent, agent is not responsible, but for the acts of sub agent, agent is going to be responsible. Now ideally appointment of sub agent is not allowed, but if he is properly appointed, the principal is going to be bound to third parties. Agent will not be responsible to the principal. Sorry, agent will be responsible, sub agent will not be responsible. Okay, and sub agent is responsible to agent for his acts. I think I wrote this somewhere where you'll understand it clearly. Right. So for all those who do not remember this well, you can just take a screenshot and you will know it well. So if properly appointed, this is going to be the liability. If not properly appointed, then this is going to be the liability. If not properly appointed, agent will be liable to the third party. Agent will be liable to principal also. Principal will not be liable to third party. Sub agent will be liable to agent, and sub agent will not be liable to principal in any case. In any case. Substituted agent, he's just like another agent, and agent is only helping the principal appoint another agent. So his role is no more there. He's not going to be liable for his acts. Principal is going to be liable. However, he just has to exercise some reasonable skill and care in actually selecting that person. Okay, so that was a super quick revision of the entire chapter of ICA. Let's now revise the chapter of Sale of Goods Act 1930. This particular act has 7 chapters, 66 sections, right? This came into force on 1st July 1930. And when I say about this act, this extends to whole of India, right? But it's applicable only on movable goods, because the definition of goods clearly state that every kind of movable property is going to be goods except for actionable claims and money. In fact, stock, shares, growing crops, grass, anything attached to earth which is agreed to be severed before the contract of sale, right, that is going to be treated as goods. Okay, we have different types of goods. Prima facie, we have 3 types of goods: existing, future, and contingent. Existing goods, that means the goods which are in existence when the contract of sale is happening, right? Which can further be classified into 3 types of goods, that is specific, ascertained, and unascertained. When I say specific, that means you have identified that, okay, this is the product that I want out of many products that may be existing, right? Like specifically, you could say that I want iPhone 15, right? Or I want this particular machine, right? When I say ascertained goods and unascertained goods are the ones which are not specifically identified or ascertained when you are making the contract. Like maybe you have 100 kgs of tomatoes and you want that 2 kgs of tomatoes, right? So out of that those 100 kgs are unascertained goods. When you ascertain and select and appropriate that, okay, these are the 2 kg of tomatoes that I want, these are called as ascertained goods. That means they are identified in accordance with the agreement. Okay, then we have future goods which are not in existence right now, but they are going to be manufactured later, produced later. So they're not in existence right now. That means maybe somebody has entered into a contract that I want 1000 kgs of potatoes. You are going to grow it on the field, right? So that is something which is future goods. And then we have something called as contingent goods. Maybe you want a painting which I had earlier, but now I've sold it to someone else. So you come and ask for that particular painting only. I say, okay, fine, I'll sell you that particular painting for this much price, provided I get it from that particular person. Okay, so there's a contingency. The sale or the acquisition of that particular goods is dependent upon happening of a certain an uncertain event, right? So happening of an contingency. Okay, so these are called as contingent goods. Then we also have some rules of delivery. What do you mean by delivery? Voluntary transfer of possession from one person to another. There could be an actual delivery when the goods are actually delivered. There could be a constructive delivery when the goods are not, the possession is, the goods are not actually delivered, but yes, there is no change of custody, yet the goods are delivered. Like if somebody is holding the goods on my behalf, I ask him to hold it on the other person's behalf now, right? That means seller had kept the goods in the warehouse and seller has sold it and asked the buyer that you take it from the warehouse. But the buyer goes to the warehouse and says that you please hold it for 10 more days on my behalf. So that means the goods are there only, the custody has not changed, but the goods have been delivered from seller to the buyer. And then there is symbolic delivery, which is being symbolized by a token or something like that. Like you hand over the keys, right? That means the goods have been delivered, that means the car has been delivered. Okay, now when I say contract of sale, it includes two things. It includes sale as well as it includes agreement to sell. Okay, sale is what, whereby you are transferring or you are the property, and there's an actual sale. But when I say about agreement to sell, when we have read about future goods, we know that for future goods we cannot have a sale, we always have an agreement to sell. That means the parties have decided that okay, the sale is going to happen at a future date, or maybe on fulfillment of certain condition, right? So a contract of sale may be absolute, it may be conditional. It is absolute, then it's sale. If it's conditional, that means it is an agreement to sell, right? So property in goods is transferred, that means it's a sale. When the property in goods is going to be transferring at some future date or subject to fulfillment of a certain condition, then that's agreement to sale. When I say contract of sale includes both sale as well as agreement to sell. Okay, it includes both sell as well as both sale as well as agreement to sell. But when I'm talking about a contract of sale, because it is a contract, it must prima facie have all the essential elements of a valid contract. There must be two parties, one seller, one buyer. You must be contracting to sell the goods, then that is movable property. There must be a price in money. That means you cannot do a barter, you cannot give something in kind and tell it as a contract of sale. No, it will not be called as a contract of sale. But often it happens that we are exchanging our old mobile phone and buying the new one. So we are giving the mobile phone and taking the new one, but we are also paying something in money. If we're just exchanging, then that's not going to be covered over here. It's not going to be called as a contract of sale. But if you are paying something, right, so partly in kind, partly in cash, that is allowed, but there has to be some payment in money only. Okay, so you have to understand the difference between sale and agreement to sell. Now, when I say the contract of sale, it is also distinguished from other types of things like hire purchase, right? Like we have bailment, like we have contract for work and labor. So, accordingly, you have to understand those differences also. Okay, now, although that's not something which you really want to get into and learn in detail, right? So you just should know that, right? Because that's not prima facie covered, but then you should know that, right? Okay, next we move to that ascertainment of price, right? So, how the price is going to be fixed in a contract of sale? The price could be fixed by the contract, that is, by the agreement between the parties. It may be said that it's going to be fixed in a particular manner provided by the act, like maybe they say that it is going to be ascertained by a particular valuer, or it may be determined in the course of dealings between the parties, that as and when we go, right, we will see what price has to be paid according to the dealings, right? So it may be agreed in whatever ways are given. If it is not determined and the goods have been given, then it is going to be paid at a reasonable price. Fine. Whenever what happens, whenever we have decided that okay, we are entering into a contract of sale, I am ready to give you the product goods, you are ready to pay me the price, but you have to pay me the price which that valuer sets or decides, right? So we have agreed to this. Now the valuer is not able to determine the price, so what will happen? The contract becomes void, it is rescinded. But what if the goods have already been delivered, but after that the valuer is not able to decide the price? So whatever is the reasonable price will be paid, okay, fine. Next we move to the conditions and warranties. Both conditions and warranties are like the promises in a contract, right? A stipulation or more like a promise. Some promises are the essence of the contract, the main essential element of the contract, that if this doesn't happen, then then probably it's the end of the contract, right? If I want a car for sports purposes and you give me any car, then this is like breach of condition, breach of the main thing. And if there is a breach of main thing, then of course the contract cannot be working. Like it is not that okay, you pay me some damages, right? This has broken down, so you repair it, or you give some damages and it will work. No, it will not work like that, right? So aggrieved person get the chance to repudiate or terminate or resign the contract, whereas warranty is again a promise, some type of promise, which is collateral to the main contract. That means, see, this should go on for 2 years. So if it doesn't go on for 2 years, you cannot resign the contract and send it. You said it's going to go on for 2 years. No, that was not the main essence of the contract. That was collateral to the main contract. So if that is not fulfilled, if there is breach of warranty, then the aggrieved party can claim damages only. Okay. But sometimes it happens, supposedly I wanted a sports car, but you gave me a normal car, and that's a breach of condition. But I feel that okay, no problem, I anyways wanted a car, so I will keep this one. So I have decided to treat this breach of condition as breach of warranty. So you pay me some damages and I'm okay with it, right? I'm not repudiating the contract. So if I don't want to repudiate the contract, I may treat the breach of condition as the breach of warranty. Okay, now there are some promises with respect to the payment and delivery, right? With respect to time of payment or time of delivery, these are not as such the condition or warranty. Okay, so if there is like the payment, I will make the payment in 1 week. If somebody has not made the payment in 1 week, that means that contract is terminated. No, this is not the condition, right? Okay, so this will not be treated as like condition or warranty, something like that. This is not the main essence of the contract, I should say. However, there should be a timely payment, there should be a timely delivery. That is in general. Okay, now we have stipulation with reference to goods. That means the promises that you make with reference to goods. Some are implied promises, some are express promises. Express promises which form the part of main essence of the contract, they are treated as condition, and some promises which are like collateral, they are treated as warranty. Okay, fine. Now you know that when condition can be treated as warranty also. If you treat the condition as warranty, then you lose the right to rescind. And when do you treat the condition as warranty? Maybe there could be the cases of voluntary waiver, there could be cases of compulsory waiver. Voluntary waiver, that is the buyer is waiving the performance of condition, that fine, okay, you don't need to do this, right? So I myself have waived that you don't have to perform this, or you don't have to do that, right? That is underperformance, I am waiving it, right? I am telling you fine, it's fine if you give this much only, or if you give this, or if you give that, right? The second is when I am electing to treat the condition as warranty. That is, I have been supplied something wrong and I say okay, I am not going to treat it as a condition, but I accept it and I'll treat it as warranty, and you just pay me the damages, right? The second situation is the compulsory waiver. What is compulsory waiver? Compulsory waiver are the two situations where the contract is non-severable. That means the goods have been mixed and I have accepted part of the goods. Now they cannot be separated. right? So I have to accept whole of the goods. So this is something that I am not left with any option. So when I accept it, obviously I'm letting go the breach of condition, right? Second is, it is impossible to fulfill the conditions. What type of conditions? Sometimes it happens that the contract uh, becomes impossible to be performed because of law, right? So in that case, I have to treat it as warranty. I cannot treat it as breach of condition. Okay. Now, there are certain conditions which are express and certain conditions which are implied. Likewise, they goes for warranty also. Okay, so express conditions or express warranties are the ones which have been expressly agreed between the parties, and then we have some implied conditions and implied warranties. So this has to be remembered by every student. The first one is condition as to title. That means I have the right to sell the goods. If I am the buyer and I am getting some goods, I should also get the right, I should also get the ownership, I should have the right to sell this or pledge this to somebody else, right? The second is sale by description. If I have described the goods that this is how I want the goods, right? So whatever goods you're supplying, that should correspond to the description. Okay, and it should be free from defects, and I should get an opportunity of comparing, right? The same goes for sale by a sample also. That means if you have shown me some sample and then you are delivering the goods, the goods should correspond to the sample, and I should get a reasonable opportunity of comparing that yes, these goods are the same, and that goods should be free from any defect. Now, defect means the prima facie defect which can be discovered by an ordinary examination. Okay, the defects which cannot be discovered by an ordinary examination, the seller is going to be responsible if they are not merchantable. Otherwise, the buyer is responsible, because buyer, like supposedly I go to a shopkeeper and I ask for a black pen, and he gives me a blue pen. Obviously I can see that it's a blue pen, right? So when I come back home, I cannot again go back to the seller and said that you did not provide me the goods as I described, you have provided me some other goods which are not fit enough. No, you cannot say that. Why you cannot say that? Because on an ordinary examination, you could have identified the defect. Okay. Next is sale by sample as well as by description. So you club both of these. Then next is condition as to quality or fitness. Now, condition as to quality or fitness, one thing has to be understood is that there is no implied condition, no implied warranty about the quality or fitness. However, there are three things. If you tell that is, you tell the seller the purpose why you want the goods, right? The seller, you rely upon the seller's skill and judgment, and the seller is actually dealing in those goods, right? So if these three conditions are fulfilled, then if the seller provides you goods which are unfit for your purpose, then the seller will be responsible and you can resign the contract. Otherwise, there is no implied condition about the quality. There goes a rule of caveat emptor which says let the buyer beware. So let the buyer see, let the buyer check the quality, let the buyer find out what is the purpose and whether it's fit or not. Okay, seller is not going to be responsible, but in this case, if the three conditions are fulfilled, the seller is going to be responsible. Okay, then comes conditions as to merchantability. Merchantability means what? That the goods should be of merchantable quality. That means they can be sold, they are fit for, they can be used for consumption. They're like, as a man of ordinary prudence would accept those goods. Okay, then comes condition as to wholesomeness, which is for eatables, that the goods should be eatable. Okay, then you have implied warranties. The first one, warranty as to undisturbed possession. Now this is different from condition as to title. As to title, you have a condition, but undisturbed possession, you have a warranty. Like if somebody has given you stolen goods, right? So you have that implied warranty that nobody is going to take those goods from you, right? If somebody comes and tries to take that goods from you, that means your possession is being disturbed and you're entitled to sue for breach of warranty. Then you have warranty as to non existence of encumbrances or charges. That means whatever goods you are giving it to me, they should be free from any charge, right? There should be it shouldn't be that these goods have been provided as security to someone, right? So it should be free from any charge. Then comes warranty as to quality, which I've already explained you. There cannot be any implied warranty about the quality or fitness, because the rule let the buyer beware operates. But if these three conditions are provided, then there exist. Okay. Lastly, you have warranty as to disclosure of dangerous nature of goods. So whenever the seller is selling any goods which can cause a probable danger, then that must be intimated, and the seller is going to be liable for damages if there is this breach of warranty. Okay. We have the concept of Kevi tempter, which I clearly told you. Let the buyer beware. That means, buyer, you are responsible for your own choices. You cannot make the seller responsible if you make any wrong choices. You should examine the goods. You should see whether their quality is good or not, whether they're fit or etc. or not. And seller cannot be held liable if the goods later on are found to be defective. However, there are certain exceptions. First exception, which I just told you, that if you have told seller the purpose, the seller, you rely on seller's judgment, and the seller deals in that goods, then seller is going to be liable. The rule of Kevi tempter says that buyer will be responsible and liable for his own choices, but in these cases of exceptions, the seller is going to be liable. Okay. The second case is if you purchase the goods under a brand name. So if the goods are purchased under a brand name, there is no implied condition that the goods shall be fit for any particular purpose. Okay. The third is if the goods are sold by description. Now, when the goods are sold by description and you provide the goods which are some other, then seller, of course, you're responsible. Goods of merchantable quality. Now, you must provide the goods which are merchantable. That means which any ordinary man of prudence would accept. There goes another situation that the buyer should get an opportunity to examine the goods, and it should be free from defects, and if the defects can be identified on an examination, on an ordinary examination by the buyer, then the seller will not be responsible. Otherwise, the seller will be responsible. Okay. Then we have sale by sample. If it does not correspond with the sale by with the sample, the seller will be responsible. Sale by goods by sample as well as description, a combination, the same goes. Then we have trade usage and fraud, the last two cases. So if there is a case of misrepresentation or fraud, or the seller is actively concealing the defect, okay, making some false representation, fraud, or actively you are concealing a defect, then you are going to be responsible if the defect cannot be identified on a reasonable examination. And seller, you must not deviate from the customs of trade or the trade usage. That is, if in this particular industry this is how it happens and you're doing something else, then you will be responsible. Okay. So hence in the above cases, the rule of Kevi tempter shall not apply and the seller is going to be liable. Then comes the situation of transfer of ownership or transfer of property. First thing is, what do you mean by transfer of property? It means the transfer of ownership. One thing you have to understand, which is established in section 26, that the risk passes with the property. So whoever has ownership has the risk. So if there is any destruction of any goods, then whoever has the goods, it is their loss only, whether it's the seller or it's the buyer. So it's very important to ascertain and identify that at what point of time the goods are actually being the property or the ownership is actually being transferred. So we have two types of goods, ascertained and unascertained goods, right? When I ascertained or specific goods, right? So in case of ascertained goods, the property is going to be transferred at the time where the parties intend to transfer. Like if you have come to buy this particular sofa and I tell you that, okay, the sofa will be all yours if you make a payment of 1 lakh, right? So that is when I intend to transfer it, right? Okay. But we have to keep in mind one thing, that if the goods are in deliverable state, right, that means whenever we are making the contract of sale, the property is transferred. But if the goods are not in deliverable state, that means you have to do something to put them into deliverable state. Like if I want a particular garment and there are some security tags on that, so they have to be removed before I can take it, right? So once they're removed, then only the property is going to be transferred, right? The third is seller to ascertain price. There are many cases, like maybe I went to buy some oranges or a particular watermelon, and I've ascertained that this is the watermelon I want, right? You have also told me the price, but you have to weigh it to tell me the exact price. So until you weigh that, it cannot be the property cannot pass in me. I cannot become the owner of that watermelon until that goods are actually weighed. Okay, so these are the three rules that you have to keep in mind. Now we come to ascertained goods. There is going to be no transfer until the goods are actually ascertained. So you cannot transfer unascertained goods. There is one thing about appropriation, that for ascertaining the goods, that means appropriating the goods. What is appropriating the goods? Selection of goods, and appropriating them or setting them aside, that okay, these are the goods which are going to be used in this particular contract of sale. Like if I go out to buy 5 kgs of oranges, there are hundreds of oranges which are kept. We select that these 5 kgs of oranges I want. So that is appropriation. Now this appropriation is going to be unconditional. It's going to be with the consent of both buyer and seller. It may be express, it may be, the assent may be expressed, the assent may be implied, and the assent may be before or after appropriation. Okay. If I give unascertained goods to the carrier boy to get it delivered, that means I have appropriated the goods to the contract. Okay. We also have something called as goods sent on approval or return. Now, if I am sending the goods on approval or return basis, now in this case, the property or the ownership will not pass, because what is happening in this case, that if I am the seller, I have said the goods that okay, you use the goods for 3-4 days, and if you find the goods are okay, then you keep it, otherwise you return the goods. That is how it is, right? So how can you become the owner if I have just given you the goods for approval or sale or return basis, right? It can turn out into sale, or it can turn out into return also. So when the property passes to the buyer, when he signifies his approval, or if he does not signify his approval within a reasonable time, that means he has not given any notice of rejection also, and he has kept the goods, right? And some reasonable time has expired, or he does anything which is equivalent to accepting the goods, like maybe he has sold the goods to some third party, or he has pledged the goods to some party, right? That is goods sent on approval or return basis, right? Okay, now we have, I have already told you section 26. We'll straight away go to the sale or transfer by non-owners. Ideally, there is a simple rule that buyer doesn't acquire a better title from non-owner. That means only an owner can pass a good title to somebody else. A non-owner himself doesn't have the ownership, himself doesn't have the title. How can he pass on a good title to somebody else? But there are certain exceptions. Exception number 1, the mercantile agent. Who is a mercantile agent? Your agent of business, your business agent, who is helping you or who is acting on your behalf in the business trading or in the business transactions. Okay. Now, if there is a mercantile agent, you have given him the goods to sell. Maybe he doesn't have the authority now, but you have given. So he is in possession of the goods with the consent of the seller or the owner, right? He has made the sale in the ordinary course, and the person to whom he has sold has no idea that he doesn't have the authority or anything like that. That means he has purchased in good faith. So in that case, whatever sale is made by this mercantile agent to the buyer is going to acquire a good title. Okay, then we have sale by joint owners. So if they are co-owners, there are 3 co-owners of a particular property, and this property is in the possession of one of the co-owner with the consent of other 2 co-owners. Now this particular person, even if he doesn't have the authority to sell, sells it to somebody, and the person acquires it in good faith, then that particular person is going to get a valid title. Okay. Then sale by a person under a voidable contract. Supposedly I have got a particular product under a voidable contract. That means I have forced someone, I have used coercion on someone, and I have got that particular product, that particular goods, right? Now that particular person hasn't resigned the contract yet, and I am in possession of that good, and I have sold it to some third party. Can I do that? Yes, I can do that. The third party who is obtaining that particular goods is going to get a good title. Okay. Next is what? Yes. Person who sold the goods but continue to be in the possession. So I am a seller. You come to me, you buy a TV from my shop, and I sell the TV to you. So this TV belongs to you, but you haven't taken the delivery. You are going to take the delivery 2 days later. Somebody else walks in and wants the same TV. Although this TV is belonging to you, I can still sell the TV to that particular person. Okay, because I am in the possession, and that particular person doesn't know that this TV is already sold. So he's acquiring it in good faith. So he's going to get a good title. Okay, fine. Next is sale by the buyer who has obtained possession before the property has actually been transferred to him or vested in him. That means maybe you come to me and I have given you some goods, right? You are yet to make the payment. I said, fine, you take the goods. Once you make the payment, then the goods can be used. That means the property hasn't been transferred to you. Um, Also the case of sale or return or approval basis, right? So I have given you the goods are in your possession, the goods don't belong to you, but you can sell it to some third party, okay, even though the goods are not yours, but you have got the possession of the goods with the consent of the seller, okay. Then owner is stopped by conduct from denying the seller's authority to sell. That is the effect of estoppel. Now there are three parties involved. Let's say I am the owner of this particular mobile phone. There is you and there is some third party. You tell to the third party that how is this mobile? This mobile is mine and I can sell it to you for 20,000. I'm right there, but I'm not denying the fact that this mobile does not belong to you, but it belongs to me, right? So I'm not saying anything like that. So I am by my conduct showing that yes, this particular person has the authority to sell the mobile phone. So if the mobile phone is sold to that person, I cannot later on say that this is my mobile phone and the sale is not valid. The sale is going to get valid and that particular person is going to get a valid title, okay. Then we have sale by unpaid seller. Unpaid seller, we have read the concept of unpaid seller. So unpaid seller, you get the right to resell the goods. And then sale by official receiver, sale by finder of goods, sale by pawnee. Like if I have taken a loan from bank and I have given security gold to bank, but if I don't repay the loan, the bank has the right to sell my gold. So sale by the pawnee, they are not the owner of that goods, still they get the right to sell the goods, and to whoever they will sell the goods, that particular buyer is going to get a good title. Likewise, it goes for the finder of goods and also for the official receiver. Okay, fine. Now, in a contract of sale, the seller has to deliver the goods and the buyer has to accept and pay for the price, right? We have certain rules regarding delivery. What is delivery? We have read that there are three types of delivery, right? Now, delivery means voluntary transfer of possession by one person to another person, right? So, whatever you are doing has the effect of putting the goods in the possession of the buyer is delivery. Okay. Now, part delivery has the same effect as full delivery unless there is some other intention. What will be the place of delivery? The place of delivery will be like if the contract has, at the place at which the contract has been, the contract has been executed. Okay, the place at which the contract has been executed, or if the contract is about the future goods, then the place at which goods are manufactured. Okay, the place at which future goods are manufactured. And otherwise, in general, it depends upon the parties what is going to be the place of delivery. Okay, time for delivery within a reasonable time if no time is fixed. If the goods are in possession of some third party, the goods won't be delivered until the third party acknowledges that yes, I'm holding the goods on your behalf, that fine, I have got the instructions to give these goods to you. Okay. Then expenses of delivery are also going to be borne by the seller. Supposedly there is some wrong quantity which is delivered by the buyer. There could be two situations. I have ordered for 10 kgs, I got 9 kgs. I may reject that 10 kgs, I may accept that 9 kgs, and accordingly I will be paid the compensation, right? It may so happen that I've got 11 kgs. So I may reject that 11 kgs. I may accept that 10 kgs. I may accept 11 kgs. In case I accept 11 kgs, I'll be bound to pay the difference, right? So that is very clear. Now, if the delivery is made in installments, the buyer is not bound to accept it. What do you mean by that? See, if I have ordered like 10 packets, I should get all the 10 packets at once only, right? Maybe I've ordered 10 pens and I've got 2 pens today. I'll be like, no, I ordered 10 pens. How can you give me 2 pens? You take it back, right? So I have that right to reject. You cannot do that. Okay, I'm sending 2 pens today, then after 2 months I'll be sending 8 pens, unless it is agreed. If it is communicated, it will be agreed, then there's no problem at all. But if it's not agreed and suddenly you're doing this, the buyer is not bound to accept that. Okay. If the delivery is made to the carrier person, it will be deemed to be the delivery to the buyer. Okay. Now, if during transit, if there is any deterioration, that loss will be borne by the buyer. And buyer will certainly have a reasonable opportunity of examining the goods on delivery. Okay. So you have to accept the delivery, and uh, one more thing is there, that supposedly the goods come which do not correspond to the sample or the description, they are defective goods, then you have the right to reject the goods. But when you reject the goods, you are not supposed to collect the goods and deliver it to back to the seller. No, you just intimate the seller that I refuse to accept these goods, and that is sufficient. That is sufficient. Okay, fine. Now, sometimes there is a wrongful neglect by the buyer in accepting the delivery of the goods. In that situation, because the seller has given the delivery or attempted a delivery, but the buyer is refusing to take delivery, and seller suffers some losses, the seller is entitled to claim for damages. Okay. Next concept we have of the unpaid seller. Who is an unpaid seller? The unpaid seller is the seller who has not been paid full payment, okay, or who has been received a negotiable instrument, but his negotiable instrument has been dishonored. That means you gave me a check, but the check has bounced, okay, or you gave me only 80 rupees where I am entitled to receive 100 rupees from you. So even if 1 rupee is pending, I am an unpaid seller, and the unpaid seller gets broadly certain rights, broadly two rights, but broadly three rights, I should say. Right of lien on goods, right of stoppage in transit, and right of resale. Lien on goods means what? Lien on goods means what? The right to retain the goods. Stoppage in transit, right to regain the goods, and right to resell, make somebody else the buyer, right? And these are the rights you have against the goods. Till the time goods are with you and you have not received the payment, don't give the goods. If the goods, you are delivering the goods, they are in transit, but you get to know that the person has become insolvent, that means now my payment is not going to come, take the goods back. Stop the goods in transit and take the goods back, right? If you have delivered the goods to the buyer, now they are in buyer's possession, now that means you can do nothing about the goods, right? So what you can do is, now you get the rights against the buyer, that is, you file a suit and recover your price, get the damages, get the interest, whatever it is. So you have the right against the buyer. Okay, so what is seller's lien? If you have made a cash sale but the person has not paid, if you have made a credit sale but the credit period has expired, or if the buyer becomes insolvent, in all the three cases you have the right to retain the goods. Maybe the goods have become, the owner is now the buyer, so the property in the goods has passed to the buyer, it doesn't matter, the goods is in my possession and you have not paid the price, I have the right of lien. Okay, I have the right of lien. Even when it is a part delivery, then also I can exercise the right of lien with the remainder part. Okay, the lien terminates when you deliver the goods to the person, to the buyer, or when you deliver the goods to the carrier without reserving the right of disposal, or when you have specifically waived the right of lien, that it doesn't matter, or by estoppel. By my conduct, I have conveyed this, that okay, I'm not going to exercise any right of lien, you're free to make the payment when you want to, you take the goods, right? Okay, then comes your right of stoppage in transit. Stoppage in transit means what? Seller, you are unpaid, you have parted with the goods are in transit, and buyer becomes insolvent. So if these four conditions are satisfied, then what you can do is you can take the actual possession or give notice to the carrier that okay, don't deliver the goods, give it back to me, right? Okay, the transit comes to an end when the buyer obtains the delivery, when the carrier acknowledges to the buyer that he's holding the goods on his behalf, right? The seller has not reserved the right of disposal, that means you have given the goods and you don't know how to take it back, right? We have read this reserve to right of disposal under section 25. Carrier wrongfully refuses to deliver, so the transit comes to an end. Delivery to carrier hired by buyer. Now, I am not sending the goods. The buyer has hired a carriage and they have taken. So, immediately the goods have been delivered to the buyer. So, there is no transit like. Okay, part delivery. Part delivery ends the transit for remaining. This is something which is in general. However, like see, If there is a buyer who has taken a few goods and the other goods he has asked to send it through some carrier, that is not a part delivery. Part delivery is like, I've started with the delivery, some goods have already been delivered, some are in transit, and the delivery is going on. That is part delivery. So even if partly the goods have been delivered, it's like all the goods have been delivered. Okay. Then comes effects of sub sale or pledge. What do you mean by that? See, if um, I have sold the goods to Mr. X, right? Mr. X has sold the goods to somebody else. Now, he was supposed to obtain the delivery of the goods and then provide the goods to somebody else. But because he has not made by payment, I am not going to leave my right of lien just because he has sub sale, he has done a sub sale. No. So, unpaid seller, my right of lien or stoppage is not going to be affected by any sale or pledge by the buyer. Okay, unless I have assented to it. Then I also have the right of resale. What is the right of resale? When the goods are of perishable nature, so I know that if I don't sell them, they will be destroyed, so I can sell it without informing anyone. But otherwise, ideally I should inform. Okay, but I can sell even without informing. Okay, so what I can do is, if I inform the buyer that I am reselling the goods, if you do not pay within this reasonable time, I'm going to resell the goods, then you can go ahead and resell the goods. You will also be entitled to claim for any loss that you occur. Maybe you had sold to the buyer at 100 rupees, but now because he's not buying the goods, or he's not making the payment, so I am reselling the goods, and I am reselling the goods at 80 per kg. Now I am suffering a loss of 20 per kg. I'm entitled to recover it from the original buyer, because I have also given him a notice. Now, if I don't give him the notice, I can still resell, but I will not be entitled to claim these damages. Okay, fine. Now, if the property of goods is mine only, that means the ownership is still with me. I have the right to withhold the delivery. Simple. Rights of unpaid seller against the buyer. You can file a suit for the price. You can file a suit for damages for non acceptance of goods. You can resign the contract and suit for damages if the buyer repudiates the contract before delivery date. That is, if the buyer calls you that, yes, I had placed the order for 10 kgs of mangoes, but now I don't want it. Don't give it to me. Right? So I have suffered some damages. I can resign the contract, undoubtedly resign the contract. That means now I'm not liable to send the mangoes to that particular person. And moreover, uh, I am also entitled to claim the damages. I'm also entitled to claim the interest at the rate at which the court thinks fit, if it is not agreed upon between us. Now, there are also certain rights of the buyer. Buyer has the right to get the goods delivered. Supposedly the seller is not delivering the goods. He placed an order and the seller same day says, no, I don't have the goods, I cannot deliver. That means the buyer has suffered some damages. So the buyer is entitled to suit the seller, file a suit against the seller for non-delivery. Suit for specific performance. Sometimes it may so happen, under Specific Relief Act we have that provision also, that I wanted a specific painting, and now you're saying that you cannot provide me that. There are two options. I can claim damages for the loss I suffered because of your non-delivery of that goods. Secondly, I can say that no, I want that painting only. That means I want specific performance to be done. So that is also suit that can be filed. The third is suit for breach of warranty. Okay, which we have already read that you cannot reject the goods, but yes, you can sue for damages. And also suit for anticipatory warranty. Okay, maybe you have sometimes repudiated the contract before delivery. That means I told you that I want the goods on a particular date, maybe 10 days before you said that no, you'd see somebody else. So, in that case, also, there may be some damages which I have suffered, and that also I will be entitled to. And I'm also entitled to the interest. Okay, then we have the last concept in this particular chapter, that is auction sale. So, what is auction sale? Auction sale is basically a type of selling the property where you invite the bids and the property is sold to the highest bidder, right? There are certain rules. Rule number one, if the goods are sold in separate lots, each lot is going to be a separate contract. The sale completes when there is a fall of hammer. Okay. Third is right to bid is going to be expressly reserved, and it has to be notified by the seller. So if the seller is going to bid himself, or somebody on his behalf is going to be a part of that bidding process, then it is going to be informed. He has to notify that there may be a reserve price. Reserve price, that is the base price. Okay. And pretended bidding is not allowed. That means somebody who's just trying to raise the prices, if that is discovered, then the sale will become voidable. Okay. Lastly, we have a section called as 64A, which simply tells that a sale is subject to taxes, right? Like maybe you have a price quoted as 5,000 plus GST. If there is an increase in GST, the buyer would have to pay the burden of that increased taxes. If there is a decrease in taxes, which rarely happens, then the burden will enjoy the benefit of the reduced taxes. Okay, without any dispute, right? Thank you. Let's now revise the chapter of Negotiable Instruments Act. So basically, Negotiable Instruments Act means written instruments or written documents which are transferable from one person to another. However, this particular act recognizes three types of negotiable instruments which have been used and which are widely used in the commercial world for carrying out the activities of trade, like making payments, etc., etc. Right? What are the three types of instruments which are being recognized by the act? Are bills of exchange, promissory note, and checks. Now, we have to read a lot of things in this Negotiable Instruments Act chapter. We have to read about the meaning, the features of these instruments, how they are being created, that is the process of making, the process of negotiating or transfer. Thereafter, how they are going to be discharged, that is the presentment discharge. Okay. Um, we have to read about a lot more things also, that is what are the different types of instruments that we have, who is capable to enter into negotiable instruments, right? There is something called as crossing of checks, so we need to understand that also. Bill, promissory note, bill of exchange, check, who makes it, how it's being negotiated, what happens at the maturity date, what is required, what is not required, if it's paid, if it's not paid. Then there are some other things with respect to the rights of holder in due course, the liability of parties, the protection to paying banker, collecting banker, etc., etc. So there is so much on the plate. Now, when I say that there are three types of instruments which are being recognized by the Act, I also mean to say that bill of exchange, promissory note, and check could be either order or bearer. That means these could be paid to order or paid to bearer. Paid to order means what? If I say promissory note, I promise to pay to Mr. X or order. That means I will pay to Mr. X also, and I will also make the payment if Mr. X orders me to pay to somebody else. So this is an order instrument, right? If I want to transfer such an order instrument, I need to do endorsement plus delivery. Endorsement is I need to sign on the instrument. I need to give the order that, okay, pay to Y. Now I know that Mr. X has ordered me to pay to Y. So when Y comes, I will pay to Y. Y has ordered to pay to Z. When Z comes, I'll pay to Z, because that is ultimately I agreed, I promised to pay to X or his order, right? The second situation could be I agreed to pay to bearer. Bearer means what? Whoever is the holder of the instrument. So it doesn't matter. You don't need to sign. You don't need to write anything. You just need to give the instrument. Okay, you have to take the payment, take this instrument. From this instrument, you can collect the payment. So that is what we mean by bearer. Okay, so all these instruments could be order or could be bearer. However, we have certain restrictions which we will eventually discover in the act. Okay. Now, there are certain presumptions to negotiable instruments. Of course, it is presumed that they're always for consideration. It is presumed that it has been made on the date which is the date written. It is presumed that it is accepted. And before maturity, it is presumed that the all the transfers were made before maturity, it is presumed that the order of endorsements is the same which is written. It is presumed that the instruments are stamped. It is presumed that the holder is actually the holder in due course. It is presumed that if we have that proof of protest and everything, yes, there's proper dishonor, etc. Okay, now what are the features or characteristics of negotiable instruments? Before we go on to the types of negotiable instruments, we have read about these presumptions. There are also some basic features. It is always going to be written, it is always going to be signed, it is free, and there could be n number of transfers. That means it can be transferred indefinite times, may have more than one pay. We may say that I am going to pay to X and Y, so there are two persons who are going to be entitled to payment, so there may be more than one pay, and it's going to be free from defects. Okay, free from defects basically means, it could be defective also, but it basically means that holder in due course is going to get a good title even though his previous holder might not have a good title. That means he gets a good title even though the title of transferor is defective. So that happens, and that we have read under holder in due course. We'll be revising today. Okay, now the first type of instrument, that is promissory note. Promissory note is given in section 4. It says that it is an instrument in writing, of course. It contains an unconditional undertaking. That means unconditional undertaking or unconditional promise signed by the maker to pay a certain sum to a certain pay. Okay, that means there is somebody who is making the instrument and he is making an unconditional promise. I promise to pay you a sum of 10,000, specified sum, to Mr. X, specified person. Okay, that is what actually you mean by promissory note. Now, one thing we have to understand, that because RBI Act has a restriction, and that is why you cannot issue a promissory note payable to the bearer. Okay, so you cannot have bearer promissory notes basically. Okay, you cannot have bearer promissory notes, and you cannot even issue bills of exchange payable bearer to on demand. Okay, so these are the restrictions that you have to keep in mind. Now, essentials of a promissory note, from the same definition we extract all the essentials. What are the essentials? A promissory note is going to be in writing, it is express promise to pay, it is definite and unconditional, you cannot put a condition, it is going to be signed by the maker, there's promise to pay certain sum only, and that is going to be money only. It cannot be a promise to pay something in kind. The pay has to be certain, that is to whom you're going to make the payment, that particular person also has to be certain, and it must be stamped. So basically, if I sum it up, in promissory note there are two parties, maker and pay. Maker is the person whose liability is primary, he is making the promissory note, and pay is somebody to whom the money has to be paid, right? Okay, now mere acknowledgement of debt is not going to be promissory notes. So we have done a list of examples that whether they are promissory notes or not. Okay, now before I move to other types of instruments, that is bills of exchange and check, first of all, we will understand what are the different types of instrument that we have. Order instrument and bearer instrument, I've already explained you. Then comes your time and demand instrument. Now, if nothing is written, if no period is specified, it's a demand instrument, first of all. Time instrument means you specify the time for payments, like you specify a particular date, you specify a particular period, like the payment is going to be made after 3 months or on this particular date, right? Or maybe 3 months after sight, or maybe when this happens. So in all these cases, an instrument is going to be a time instrument. When I say certain period after sight, it means once you show the instrument, let's say it's written 1 month after sight, that means you have to show the instrument. Once you show the instrument, 1 month after that, it will be paid. Now, whenever I'm saying time instrument, you add 3 days of grace. You add 3 days of grace to the time instrument. Okay. To calculate the maturity date. What is maturity date? The date on which the instrument is actually going to be payable. Demand instrument means there is no time which is specified, and it's just payable on demand. So you show the instrument and instantly the payment has to be made. So there is no way we can fix the maturity date. We don't know the maturity date. It cannot be fixed. It cannot be fixed, right? However, in time instrument, you can clearly fix the maturity date. Okay, how can you fix the maturity date? Supposedly it's written that on 3 months after this particular date. So after the 3 months end, add 3 days of grace, that is the third day will be the maturity date. Okay, now we have inland instrument. Inland instrument means any instrument which is drawn in India or made in India and payable in India, or drawn in India or made in India and drawn upon PRI. So if these two conditions, any of these two conditions are satisfied, then it's going to be an inland instrument. Otherwise, it's going to be a foreign instrument. Okay. Then we have ambiguous instrument. Ambiguous instrument which you cannot decide whether it's a promissory note or a bill of exchange. And then we have inchoate instrument, which is kind of important. What is inchoate instrument? Which is incomplete. Prima facie, if you make an incomplete instrument, it should not be allowed, right? But this is an allowed instrument. How is it allowed? There are three conditions which need to be fulfilled. Whoever is giving an inchoate instrument, you must sign the instrument must be stamped, and the instrument must be delivered. Then even if you give an incomplete instrument, it's a valid instrument. Now you are giving an incomplete instrument to somebody, that means maybe you have given the instrument which is signed, which is stamped, which is delivered, but you haven't filled the amount. So the other person is now going to fill that amount. Yes or no? He gets the authority to fill that amount. Yes or no? Yes. He gets the authority to fill what amount? The amount that he's authorized to fill. Supposedly we haven't calculated the bill, so he's authorized to fill, maybe calculate the amount of the bill and fill it and take it, right? But then now the problem comes that you have stamped the inchoate instrument. That means maybe if you have, example, a fictitious example, maybe if you have fixed a stamp of 100 rupees which covers the value of 20,000, so you can fill only up to 20,000. Yes. If you fill over and above 20,000, then that's not allowed at all. Okay, now you were having the authority to fill only 5,000, but you filled 10,000, which is well within the stamp value, but still you exceeded your authority and you gave it to a holder in due course. Now that holder in due course doesn't know that he had the authority to fill only 5,000, wherein he had filled 10,000. So he comes to me and asks for the payment. What am I supposed to do? I have to make the payment to to holder in due course. So holder in due course, you can recover the whole amount which is stated in the instrument, but of course your value also cannot exceed the stamps. Okay. Maturity of negotiable instruments, I already told you. Demand instruments are not entire. Oh my God, what is this written? Time instrument is entitled to 3 days of grace. Not entitled. Demand instrument is not entitled to 3 days of grace. Okay. Now, rules of maturity, maybe you add the 3 days of grace, but then that comes to be a public holiday. So what you'll do is it will mature on preceding business day. If it's an emergency holiday, succeeding business day. And if maybe it's written 1 month, 29th January is the date, and it's written 1 month after this particular date. So 1 month after will come out to be 29th Feb. If we don't have 29th Feb, it will be 28th Feb. Okay. So period to terminate on the last day of such month. Fine. The next type of instrument that we have is check. Check is nothing but a type of bill of exchange, and which is drawn on a specified banker only, and it's always payable on demand. Can check be an order instrument? Can check be a time instrument? The answer is no. It is always going to be a demand instrument. It can be order, it can be bearer, but it's never going to be a time instrument. Okay. What is check? Bill of exchange drawn on a specified banker, payable on demand, includes electronic and truncated check. There are three parties basically in a check. One is the drawer, one is the drawee, and the other is the payee. Drawer means I have bought goods and I have to make payment, so I draw a check, right? I draw a check and give it to you. I draw a check in your favor. You are the payee. That means you are entitled to receive money on that. You are the payee. So you become the payee. I become the drawer. I have drawn the check, right? So my liability is primary. I have to make the payment of the check, right? But I instruct the bank to make the payment. That is, I have drawn this check upon the drawee, who is always going to be a specified banker only. He is going to make the payment to of the check. So there are three parties prima facie. Okay. Now, when I say electronic check, that means a check is created, signed electronically only. And when I say truncated check, it means it's just the electronic image of a normal check. What are the essentials of a check? The check is again going to be in writing. It is not a promise to pay, but an order to pay. I am ordering the bank to make the payment. It is an unconditional order. It is signed by the drawer. It is to pay certain sum, and that sum of money only, nothing in kind. The drawer, drawee, pay, everyone must be certain. It's always drawn on a specified banker, and it's always going to be payable on demand. Okay, so check may be order or bearer. Now we have a beautiful concept called as crossing. Now, crossing is not something which affects the negotiability of the check, but it makes the check safe. We can have an open check, we can have a cross check. Open check, that means anyone takes the check to the same home branch and collects payment at the counter. Cross check, that means you cannot go to the bank and collect payment like that. It has to be presented through a banker only. So when I get a check, I go to my bank, that is where I have an account. I give the check. Now they will present the check to that particular bank, and they will collect the payment and credit it in my account. That is what is happening. That is what crossing means. So crossing means giving the direction to the paying banker not to make payment otherwise through a banker. That means you cannot make counter payments. Who is the paying banker and who is the collecting banker? Paying banker is the banker of drawer, and collecting banker is my bank, right? So he's going to collect and they are going to pay. Okay, so we have different types of crossing. Crossing can be done by the drawer. I have crossed by the holder or by the banker also. Okay, now we have different types of crossing. The first one is general crossing. General crossing is just putting two parallel transverse lines. And what does it mean? It means you will not pay this check at the counter. If some bank comes and asks to you, you give it. Okay, you give it. Then we have special crossing. Special crossing means any bank cannot come. Whichever bank has been specified will only be the collecting banker. Like maybe I have put two transverse crossing lines and I have written SBI bank. That means only SBI can be the collecting banker. If you get the check through any other bank, you are not going to make the payment. Okay, then comes your account pay or restrictive crossing. Now this affects the negotiability. That means now this check cannot be negotiated. Whoever name is written, the amount will go to the account of that particular person only. You cannot negotiate this now. Okay, you cannot transfer this now. Then we have not negotiable crossing. Not negotiable crossing is not affecting the transferability, but it means that whatever title this particular person has, the other person will not get a better title. So if this particular person has got a check stolen, then this particular person is also the same. Okay, so that is not negotiable crossing. Fine. Now, protection to paying banker and protection to collecting banker. Paying banker means what? The person who is making the payment, the banker who is making the payment on behalf of the drawer. Like the drawer has instructed me to make the payment, so I will be making the payment. Okay. Now, if I make the payment in due course, then I am not liable. Like if I got the order check means what? It's written pay to X or order. Okay, now X has endorsed it, pay to Y, X sign. Pay to Z, Y sign. Pay to A, Z sign. Right, so they have made this endorsements, they have transferred the check from this to this to this, and finally, who is the holder? Mr. A is the holder. So Mr. A goes to the bank. He presents the check. Check is paid by the paying banker to Mr. A. Is the paying banker liable? The answer is no. Why will anyone be liable? We get to know that this particular person has forged Y's signature, or this particular person has obtained this from fraud. There was one endorsement which was not correct, etc., etc. Well, the paying banker is not liable, because paying banker has made the payment in due course, right? In case of bearer check, whoever who is holding the check comes and takes the payment, paying banker is not liable. If it is a generally cross check, any bank may come and take the payment, paying banker will not be liable. If it is a specially cross check, that specified banker comes and takes the payment, the paying banker will not be liable. Okay, will not be liable. Fine. So if you're making the payment in due course, you're not liable, right? In all these cases, however, you will be liable in one case. In what case? When the drawer's signature has been forged, because you are responsible for checking the drawer's signature, that he's your customer. If his signature has been forged by somebody and somebody presents a check and you give the payment, then you are responsible. So in that case, only the paying banker will be responsible. Likewise, we also get a protection to collecting banker, that if you're collecting payment in due course in good faith without negligence, that you're not responsible for anything. Okay. Now we have some concept called as assignment, which is different from negotiation. Okay, negotiation is transferring of instrument, whereas assignment is just transfer of a particular right. Negotiation, we transfer the instrument. Assignment, it's just some right has been transferred and the title remains the same with the person only. Okay, so we have read about the differentiation between negotiation, assignment, and everything, so you can get into that. The next type of instrument is bill of exchange, which is covered in section 5. Bill of exchange is again an unconditional order, just like check. So you are giving an unconditional order to somebody to pay a certain amount to either me or to some other pay. Okay, now check and bill of exchange, what is the difference? There also it is an unconditional order, here also it is an unconditional order. Here you are giving an unconditional order to a person, there an unconditional order is given always to a specified banker, that is the drawee is always a specified banker. Here drawee could be any person. Okay, so bill of exchange is what? Again, an instrument in writing, unconditional order signed by the drawer, directing a person to pay a certain sum to order or bearer. There are three parties. We have drawer who gives the order. He is not liable for payment. We have drawee to whom the order is given for payment and he is personally and primarily liable. And then we have payee to whom money is to be paid. Usually this drawer and payee are the same person. Like I could say pay to Shivangi or order. Okay, I am instructing Mr. X to pay to Shivangi or order a sum of 10,000 on such and such date. It is a bill of exchange. Now, he may agree to this, he may not agree to this, right? Once he agrees to it, he becomes an acceptor and he becomes liable. If he disagrees, then he's not liable. Okay, so drawee is not liable, acceptor is liable. What are the essential features or characteristics of a bill of exchange? It is again going to be in writing. It is an express order to pay, money only, certain sum only, definite and unconditional, signed by the drawer, certain pay, drawer and drawee, and stamped. For check, you don't need any stamping. Okay. For check, you don't need any stamping. Now, I told you when we're talking about bill of exchange, we also have to talk about acceptance, because bill needs to be accepted. You don't need acceptance primarily in all the cases, but I'll tell you that later. Fine, when we talk about presentment of acceptance and presentment for payment, etc. Now, what is acceptance? Drawee, you have been instructed by the drawer to make the payment. You agree, you disagree. So you sign the bill and give it back to the drawer, right? That is acceptance. Sign the bill and give it back to the holder. Sign the bill and give it back to the holder. Not specifically drawer, but give it back to the holder. That is acceptance. Now, acceptance has to be general. That means without any qualification, without any conditions. It has to be in writing, it has to be signed on the bill only, and delivered. So these four things are requirement to make an acceptance a valid acceptance. Thereafter, there has to be an unconditional acceptance. If you put in the conditions that, okay, I accept to make this payment, but you have written an amount of 20,000, I accept to make the payment of only 15,000. Now, all the parties who disagree to this acceptance will be discharged. Okay. Next, we have Section 26, which talks about who is capable, right? So anyone who is capable to enter into a contract can also sign, can also draw, can also endorse, transfer, negotiate, whatever you may call a negotiable instrument. As regards as minor is concerned, minor, you are also allowed. You can draw a negotiable instrument, you can endorse it, you can deliver it, but you will not be bound. You can make other parties liable. You will not be bound by that particular instrument. Okay. Next, we come to negotiation. Negotiation means transfer of instrument. Of course, this is a negotiable instrument and can be transferred n number of times, right? But how? We have two types of instrument. One is order, one is bearer. Order instrument can be transferred or negotiated by endorsement plus delivery. Bearer instrument just by delivery. But in both the cases, you have to deliver the instrument. Even when you're making the instrument, then also you need to deliver the instrument. If you don't deliver the instrument, then it does not create any rights, any liabilities between the parties. So delivery is very, very, very important. Now, when I say if it is an order instrument, it has to be negotiated by endorsement plus delivery. There are different ways of endorsement. Endorsement means in writing, signing, and by the holder. In writing, signed by the holder. In writing, signed by the holder. That is what endorsement means. Okay. Now we have different types of endorsement. Now, don't be confused. Like we have general crossing also, we have special crossing also, we have restrictive crossing also, but now we're reading endorsement. Okay. So, general endorsement basically means that you have not written anyone's name, right, without writing the name of the endorsee. That means basically an order instrument is getting converted into a bearer instrument. Special endorsement, when you specify the particular name, that okay, the payment now has to be made to this particular person. Restrictive endorsement, when you restrict the right of negotiation, that this cannot be negotiated further. Then you have partial endorsement, which is ideally not allowed in law, but it means that if the bill or if the instrument is of 1,000, you are endorsing it only for 500, right? Then we have some other types of endorsements, which are like sans recos. Sans recos, that means you are endorsing it to somebody else, but you refuse to take the liability if it's unpaid, right? If it is disordered, that means you're clearly saying that I decline to accept the liability to any other subsequent party, right? Then you have sans frais endorsement, which means that I'm not going to incur any expenses, loading, etc., etc. Facultative, that I'm waiving a certain right, like maybe notice of dishonor. And conditional, that this is going to be paid only upon fulfilling of certain condition, right? So, or I'm going to be liable only on certain condition, right? Now, these are the different types of endorsements. Now we have something called as negotiation back. Negotiation back means like A to B, B to X, X to Y, Y to again A. Okay. Or you can also say it like this, maybe A to B, B to X, X to Y, Y to B. So B now has these subsequent parties and also a prior party called as A. So when the endorser, after negotiating, becomes the holder again, then he's not going to be liable to all these subsequent parties or all these intermediate parties, but the prior party like A is going to be liable to B. Okay. So here you can't sue the subsequent or the latter parties, but of course you can sue the prior party. Okay. Now, conversion of blank endorsement into full. If you have a blank endorsement, like it's a bearer, so if it goes to anyone, that particular person is entitled, you don't need any signing. And now if you want to make it into a full endorsement, then whatever is the sign, you just write the name, you don't need to sign. Okay. Thereafter, we have the instruments obtained by unlawful means or by unlawful or for unlawful consideration. That means you have got the instrument by fraud or for an unlawful consideration. Then in such a situation, you cannot receive the amount. You cannot receive the amount. Okay, except for the holder in due course. Can instrument be negotiated after maturity? The answer is yes, uh, but only till the instrument is not satisfied. Instrument, once it is satisfied, then you cannot negotiate it. Okay. Now, yes, but the title of transferee depends on the title of transferor, of course. Like if you have obtained any instrument before maturity for value in good faith, you are a holder in due course, right? So you get the right against all the prior parties. But supposedly you have received any instrument after maturity, then you don't become a holder in due course. So you will have the same right as you have as your holder, as the person from whom you have got the instrument has. Okay. Now, we have something called as accommodation note or bill. Now, this is a bill which is made by one person just for the help for raising money, for anything like that. That means A has given a bill to B, maybe. They do not have to pay anything to each other, but still they have drawn the bill and the other person has accepted the bill for helping, right? This can be given to the third party. Now, person who has acquired accommodation instrument after maturity in good faith for consideration can recover the amount from any prior party. So that is the exception that we have. Okay. Now we come to the concept of holder. Who is a holder? Now, holder is not somebody like if I am walking on the road and I found a check on the road and I picked it up. So do I become the holder? The answer is no. Although this check is in my possession, but I do not become the holder of this check. Why? Because I'm not entitled to this check. I'm not entitled to receive money from the parties who are mentioned in this check, right? So that is why I do not become a holder. That means who is going to be called as a holder? Holder is somebody who is entitled to possession of the instrument in his own name and receive the amount due from the parties. Okay. Now, we also have a concept called as holder in due course, which is an elaborated concept of holder. But before that, I want to explain you what happens when a negotiable instrument is made without consideration. So if a negotiable instrument is made without consideration, it creates no obligation between the parties. It's not that you are not entitled to the payment. You are entitled to the payment. You are the holder, but you cannot make the other party liable if he does not pay. There are exceptions, accommodation bill, which I have already explained you. Okay. Even accommodation bill, there's no consideration, but yet you are liable to the other parties. Okay. Now, there is also exception to HDC. If I have given you any instrument which is like a gift, I gave you a check which is a gift. So there is no consideration involved. I gave you the gift. You gave this gift to a holder in due course. Now that holder in due course can come and sue me, but you cannot sue me. That is what it means. That is what it means, right? Now, if there is partial failure of consideration or partial absence of consideration, then what happens? Like if I have given you a check of 10,000 and you have provided me goods worth rupees 5,000 only, so I said you are entitled to 5,000 only, so accordingly there was partial absence of consideration. Accordingly the amount will be reduced, proportionately reduced. Okay, is that clear? Fine. Now we have holder's right to duplicate bill. If bill of exchange is lost before it is due, then holder, you can go to the drawer and apply for a duplicate bill, give the indemnification and security, and thereafter the drawer will give you the duplicate bill. He can be compelled, in fact, for giving you that duplicate bill. Now we have the concept of holder in due course. What is a holder in due course? To become a holder in due course, first of all, you need to become the holder. Secondly, you have to obtain the instrument for consideration. Thirdly, before maturity. And fourthly, in good faith. Okay. So this is important, this is required. Now, if you have become a holder in due course, you get entitled to a lot of privileges. What are the privileges? First thing, you can sue any of the prior parties. Whenever any instrument passes through you, it gets cleansed and free from all the defects. Okay. In case of inchoate instrument, you can claim amount up to full stamp value. In case the bill is fictitious, still the acceptor will be liable to you, and he cannot deny that the person is fictitious, that the drawer is fictitious. Even if delivery happens upon happening of some event, you get a good title. That means it doesn't matter whether it was a conditional instrument, you get a good title, right? If somebody has obtained the instrument by unlawful means and given it to you, it doesn't matter, you get a good title and you can claim, you can file a suit. Nobody can deny the original validity. Nobody can deny the pay's capacity, that he is not entitled to receive payment and he has given the bill to you. How are you entitled? No, it doesn't matter. It doesn't matter. Okay. All the subsequent parties who acquire title from HDC also get a good title. I told you it gets cleansed, right? And you get the right to sue all the prior parties in case the instrument is dishonored. Okay. Next topic, we have the presentment of negotiable instruments. Now you have to understand, in three cases, the presentment is required. One, when you issue a promissory note for sight, that means maybe you have said, I promise to pay you a sum of 10,000 2 months after sight. Unless you show that promissory note, you cannot fix the maturity date, which is 2 months later, right? So you have to show, you have to present this instrument, this promissory note. So promissory notes needs to be presented for sight. Some bills of exchange need to be presented for acceptance, and all the instruments need to be presented for payment. Unless you present it, you cannot be paid, whether it's check, whether it's promissory note, or whether it's bills of exchange. Okay. Now, you need to present bill of exchange for acceptance, but what bills of are need to be presented? Like if I have given you a bill of exchange which is payable on demand, you don't need to present it for acceptance. You just go and take the payment. What acceptance is needed, right? You don't need to present it for acceptance, right? It will directly be dishonored by non-payment because it was on demand, right? But if it is a bill payable after sight, or maybe there is a condition that it needs to be accepted, then you need to present it for acceptance. If it's after sight, that means what? After you show me, then we'll fix a date of maturity, right? So once you show it, we get to know whether it's accepted or not accepted. So that is presentment for acceptance. Okay. We have different rules for presentment of payment and different rules for presentment of acceptance. Presentment for acceptance is required only and only in case of bill of exchange, right? So what are the rules? Who will present it? Holder or any person on behalf of holder. To whom will you present it? Of course, the drawee, because we need to make the drawee liable, and when he accepts it, he becomes the acceptor and becomes liable. Where? If the place is specified, the specified place. If not, reasonable place and time. Maximum time allowed, you will give 48 hours to consider whether you want to accept or not. If you allow more than 48 hours, then all the parties who do not consent to this are discharged, and then you will be liable. Okay. When it says not required, when presentment will not be necessary, when the drawee is not found, or he's dead or insolvent or is fictitious or incompetent to contract. Okay. Now, fine. Now, presentment for payment. All the instruments you need to present for payment. Okay. Whether it's bill, whether it's check, whether it's promissory note. Where? By whom? By the holder. To whom? If it is a promissory note, you will take it to the maker because he is liable for making the payment. If it is a bill of exchange, you will take it to the acceptor or drawee because he is liable for making the payment. If it is a check, you will take it to the drawee bank because he is liable for payment. When? Usual business hours, a reasonable time at maturity. Where? Now, where we have these three things, basically, sometimes in the bill, it is specified that the bill is going to be payable at this place. So that place only you have to present. Okay. Sometimes it is drawn at a particular place. So that place. If it is not so, then his shop or his residence, that means his place of business or his residence. of the acceptor or the drawee. Okay, how will it be presented? Even post is if such mode is authorized. Okay. Now, presentment can be made to the agent or legal representative also, and when presentment will not be necessary, when presentment will not be necessary, if the maker or acceptor prevents presentment, he says that presentment, you're not supposed to do that, right? Or maybe there is nobody found in the usual place of business during the business hours, or maybe you gave a special place but nobody attends that special place, or maybe we could not find you even after a lot of search, or you have given a part payment and have promised to give the whole payment, you waive the right. So in all these cases, the presentment of the instrument for payment is not necessary. Is not necessary. Okay. You were supposed to make the payment on 2nd January. You did not make the payment. That was the maturity date which was fixed, but you did not make the payment. Now what will happen? Interest. What interest? Interest, whatever has been agreed. If no interest has been agreed, it will be 18% per annum. Okay. Now, we have some concept called as acceptance of bill in fictitious name and acceptance for honor. What is acceptance of bill in fictitious name? Bill drawn in fictitious name of the drawer, but signed on bill and endorser in same handwriting. Bill is accepted, negotiated to HDC. Acceptor is liable towards HDC. I explained you this when we were reading about HDC also. Now, acceptance for honor. Bill has been noted for non-acceptance. That means we read about noting, we need about protest. Noting is basically creating an evidence. If I go to the drawee, take the bill, and the drawee says that no, I refuse to accept it, that means it has been dishonored for non-acceptance. So we go to the notary public, we get this fact recorded on the bill, that bill dishonored due to non-acceptance, that is, bill is noted, right? Okay. Now somebody else, that means a person who is not a party to the bill, with the consent of holder, accept by writing that I am accepting it supra protest, or accepting it for this particular person, and that particular person is called as the acceptor for honor. Okay. Now, acceptor for honor, you by accepting bind yourself to all the subsequent parties, and all the prior parties become bound to you. Okay. Lastly, we have the concept called as dishonor. Dishonor of instruments. Dishonor of bill could happen by non-acceptance also. Otherwise, the dishonor will happen by non-payment. Okay. So if the drawee doesn't accept within 48 hours, refuses to accept, gives qualified acceptance, and you don't consent to it, drawee is not found, or one of the drawees doesn't accept, that means the bill has been dishonored due to non-acceptance. If it is dishonored due to non-acceptance, the holder, you can go and sue all the prior parties that you want to. Okay. Give notice and sue. Okay. Now, if it is dishonored due to non-payment, that means the promissory note maker has not made the payment, or the acceptor has not made the payment in case of bill of exchange, or the drawee has not made the payment in case of check. When we talk about dishonor of checks, there is an absolute different topic and different section that we read about. So here we are not going to mix it. Okay. Now, when it is dishonored, you need to give the notice of dishonor. If you don't give the notice of dishonor to any of the party, that particular party will be discharged. So what is needed is the notice of dishonor has to be given to all the prior parties, right? Except for somebody who has said that I don't need the notice, right? That facultative endorsement, right? You don't need the notice, then you don't give the notice. Otherwise, you need to give the notice to everyone to make them liable. Okay. How you will, how it is going to be done, right? Party who doesn't receive such notice is discharged. Notice is not necessary in case the notice is dispensed by the party, that I don't need the notice, or the party is not to be found, or it is the case of countermanded payment, right? The drawer has stopped, couldn't give notice without your own fault, right? So in that cases, the notice is not necessary. Okay. Now, just a second. Noting and protest is very simple concept. Noting is just getting the fact recorded. So you take the instrument to the notary public, and on that bill, it is being recorded that this has been dishonored. Now, if you want to obtain the certificate of it for more authenticity, that is called as protest. Okay. Now we have dishonor of checks. Dishonor of checks. As I told you, we're going to read a different concept called as dishonor. Now, banks, paying banker, it is your liability, it is your duty to honor the check whenever it is being presented to you, right? But in certain cases, you can refuse to honor, you must refuse to honor when your customer has instructed to stop payment, when there's a garnishee order, that is the order by court, when there is death or insolvency of the customer or insanity of the customer, when there is defect in holder's title, when the check has been lost and reported and somebody brings you the lost check, you're not supposed to honor that check. If it is altered, maybe the amount has been made from 10,000 to 20,000, it's mutilated, there are different signature, that means the draw signature is, there's mismatch, right? Irregular endorsement is there, maybe it is a stale or post dated or undated check, there is doubtful validity, and somebody has applied for closure of account and then you receive a check, so you must confirm. Okay, so in these cases you can refuse to honor. Otherwise, whenever a check is issued by the drawer, it has to be paid. But if it's presented within a reasonable time, but there is no balance in the account of the customer, that means there are insufficient funds. The check is presented, but it is dishonored because of insufficiency of funds. That means there is dishonor or bouncing of checks. This attracts penalty or punishment. But the punishment will not be like, okay, dishonor, this is the punishment, or we'll throw you in the jail. No. Whenever there is dishonor, the holder, you are supposed to give notice to the drawer, whoever has given you the check, the drawer. So you give the notice to the drawer within 30 days, the notice of dishonor. Within next 15 days, he is supposed to make the payment. If he does the payment, great. If he does not do the payment, then you can start with a course of action, a legal course of action against him. What is that? You can sue him, file a complaint in the court within 1 month. Within 1 month. And thereafter, the court will award or reward or punish with the penalty twice the amount of check maximum and 2 years of imprisonment maximum, or both. Or both. Okay? Clear? Now, supposedly, I gave you a check, but you did not present it within a reasonable time. I had sufficient balance when I gave you the check, but it was not presented and the bank failed. Bank failed means what? Like the bank has become insolvent. So you cannot come back to me and claim the money again. I am discharged. If the check has been issued by the company and it's bounced, then it will not be the company, but it will be every person who was in charge of the company will be liable and will be subject to the penalty. Where do you complain? You complain to metropolitan or first class magistrate, right? In writing, you give this a complaint within 1 month of course of action. And where will it be tried? What will be the jurisdiction? Supposedly, it is a crossed check. That means I can collect payment through a specified banker only. So it will be like where my branch is situated, because I give the check to my branch, and wherever that my branch is situated in that jurisdiction, whichever court is existing, the trial will be happening in that particular court. However, if it is a, an open check, so I have to go to that particular bank of the draw to collect the payment. So that particular jurisdiction, the trial will be happening. Okay. Now, They also have the power to try the cases summarily, summary trial. But in summary trial, the maximum punishment that you can give is 1 year imprisonment and fine 5,000. If you feel that it cannot be tried summarily or the punishment will exceed, then you will record this fact and start to proceed in a normal manner. There could also be interim compensation, which may be avoided by the court in the trials, but the interim compensation will not exceed 20% and has to be paid within 60 days from the date of order. Okay, the offenses are going to be compoundable, right? Then you have certain liabilities of the partners, which I have not mentioned over here. Okay, liabilities of the partners, because we have over the period of time established that liabilities, and that you can of course revise. Then we have a concept called as alteration. What is alteration? Material alteration, or I should say material alteration, means any change which changes the character of negotiable instrument. That means maybe you are making a demand instrument, a time instrument, or something like that, or the rights and liabilities of the parties. Okay, now, like you change the date, you change the amount, you change the time, you change the place, you change the rate of interest, you add some party, you change that stamp value, right? You make any other alteration. Uh, so, all this is treated as material alteration. And if you do this, the parties who are involved, all the parties to negotiable instrument, either they agree. If they do not agree, they do not consent, they do not know, they're discharged. Okay, they are discharged, right? However, there are some material alterations which are allowed or authorized by the act, like crossing. Crossing means what? General crossing into special crossing, or crossing of checks. Then conversion of blank endorsement into full, filling the blanks of inchoate instrument. Write this: inchoate instrument, and bearer to order. Okay. Now we have discharge. Discharge of negotiable instruments or discharge of parties. If the instrument is paid, it discharges the negotiable instrument. Negotiable instrument means all the parties are discharged. Party discharge of party means maybe this particular party has been discharged, or these three parties have been discharged, something like that, right? Okay. Now, when you make the payment of the instrument is discharged, all the parties are discharged. And if any party makes the payment, see, if like you have A has given to B, B to C, C to D. Okay, now if A has made the payment, then all the parties are discharged, and it means the discharge of negotiable instrument, because A was primarily liable to make the payment, but supposedly A has not made the payment has been made by C. So C is discharged, D is discharged, right? Subsequent parties are discharged, these two parties are still continue to be liable. Okay, then we have cancellation. Holder has cancelled the name of primary party, then all the parties are discharged. But if you cancel the name of just one party, the subsequent parties will be discharged. If you release the party primarily liable, then all the parties are discharged. But if you release one party, then subsequent parties will be discharged. Negotiation back. If A to B, B to C, C to D, D to again A, all the parties are discharged. It is discharge of negotiable instrument. But if it happens that A to B, B to C, C to D, D to again C, that means only these are discharged, they continue to be liable. So subsequent parties are discharged, but the prior parties will not be discharged. Lapse of time. If instrument becomes time barred, the debt becomes time barred, the instrument is discharged, right? If you allow more than 48 hours for acceptance, then the parties who do not consent are discharged. The instrument is not discharged, but only some parties who do not consent to that, they are discharged. If you give qualified acceptance, if you disagree to the qualified acceptance, then it's like dishonor due to non-acceptance. But if you agree to qualified acceptance, there may be some parties who do not agree to it, so those parties are discharged. If there is material alteration, the parties who are not agreeing to it, they get discharged. If you do not give notice of dishonor, the parties who have not got the notice of dishonor are discharged. If there is insolvency, then the party who is being declared as insolvent is discharged, right? Lastly, we also have something called as hundi. Hundi is what? It is a bill of exchange in local language. That is what you need to remember. That is what you need to know. Of course, there are some distinctions or differentiation which is required and which you must know from examination perspective also. It's a big chapter. You have, I would just say that uh, there could be technical questions also, there could be easy questions also, right? There is a huge scope of learning, so much more. We have tried to take a lot of examples and cover and understand the entire gist of this beautiful chapter, but uh, still, if you find this difficult, please try to recall it 2 3 times. Don't skip the chapter at all, and try to at least cover the important questions or the important aspects which are involved in the chapter, right? Don't forget to learn the differentiation between holder in due course, right? Then we have like negotiation and assignment difference is important. Then we also have the difference between bills, checks, right? And then we have promissory note and bill of exchange. So all these differentiations should also be known, right? Okay. Let's now revise Indian Partnership Act 1932. The first thing is that what do you mean by partnership? When I say partnership, although it's defined in section 4, and it means the relation between those persons who have agreed to share the profits, and this is going to be carried on by all or any one of them acting for all. That means a partner is both a principal and an agent. A partner is an agent of the firm and of other partners also. That means by his acts he can bind the firm as well as other partners, right? When we elaborate this particular definition and go deep inside, we get the elements of partnership. The first one being association of two or more persons. You cannot form a partnership with your own self, right? Partnership firm, we have different partners and collectively they are called as a firm. So whenever we are talking about a partnership firm or partnership, that means there has to be at least two persons. The persons could be artificial, the persons could be natural. Okay. However, a partnership firm cannot be a partner. Why? Because a partnership firm is not recognized in the eyes of law. Moreover, minor cannot become a partner. He can be admitted to benefits of partnership. Okay. We know that to form a partnership, minimum you need persons, right? So minimum two partners. What is the maximum limit? Although we don't have any maximum capping given in Partnership Act, but when we read Companies Act, we have a section called as Section 464, which clearly tells that you cannot form any association or partnership of persons more than 50. So that is the maximum capping we have. It excludes the professional partnerships, of course. Okay. Now, the second element is that there has to be an agreement. Agreement necessarily does not mean you have a written agreement signed by everyone. No. The agreement could be oral, the agreement could be in writing, the agreement could be expressed, the agreement could be implied, anything is fine. But then there should be agreement. That means, moreover, the people have consented, the people have agreed to do this. Okay. So that is what agreement means. Agreement to do business. Now, business doesn't mean only trading, but it could mean any profession, it could mean any occupation, anything, right? And moreover, when we're talking about partnership, the intention is to share the profits. That means the intention is to acquire gain. The intention is not to do charity. Okay. So, agreement to share profits. Now, this is a little tricky thing because when I say agreement to share profits, although profits prima facie includes losses, but there could be a partnership wherein you are sharing only the profits and the losses. That could be a very well valid partnership because in the elements of partnership, we have that there must be an agreement to share profits, not losses. Okay, not losses. So loss borne in profit sharing ratio is there unless otherwise agreed. But there may be a situation that a partner is going to be admitted to partnership and he says that I'm not going to bear the loss. So is it a valid partnership? The answer is yes, it is a valid partnership. And lastly, it's mutual agency, which is actually the true test of partnership, right? That is, the business must be carried on by all or any one of them acting for all, which I basically told you. Okay. Now we have different types of partnership. Okay, the first one is partnership at will. You also need to understand and you also need to revise. Okay, let me briefly say that also. There is a difference between partnership and company. How is partnership different from company? Well, we have Companies Act, we have Partnership Act, right? In partnership, we have the concept of mutual agency, but in company, we don't have this concept of agency because a member is not the agent of the company. Okay, when we talk about distribution of profits, here the profits are distributed according to profit sharing ratio. Here the profits will be distributed as dividend and as and when declared. There is no fixed ratio in which is just to be distributed or anything like that. The most important difference, that liability of partners is unlimited, however the liability of members is limited. The properties firm is a joint property of partners, but the company's property is only the company's property. Why? Because company is a separate legal entity, right? A partnership gets dissolved whenever the partners agree. However, to dissolve the company, you need to follow the entire procedure. First, it has to be wound up, then it will be dissolved, right? Partnership registration is not mandatory. However, you cannot form a company without it being registered or incorporated under Companies Act. So that is also the difference. In partnership, there are just two partners. Maximum is 50, minimum 2, maximum 50. In company, minimum 1, 2, 3, maximum 1, 200, and no limit. If I go by OPC, private and public, right? And that's it, right? Partnership is also distinguished from HUF. Partnership is also distinguished from LLP, right? So when we read about LLP, we see that distinction, right? But it is also different from HUF. How it is different from HUF? Again, HUF is governed by Hindu law. Partnership is governed by Partnership Act, right? Um, Partnership is being managed by all the partners. HF is being managed by Karta. In partnership, all the partners are responsible. In HF, Karta is responsible. Okay. In partnership, the liability of all the partners is unlimited. In HF, the liability of only Karta is unlimited. Okay. A minor cannot become a partner of partnership firm, but a minor is very well a member of HUF. As soon as he is born, he becomes that member of HUF, right? In HUF, there could be n number of members, there's no limit, but in partnership, there's an upper capping limit of 50. Okay, so there are a lot of differences. Of course, you have to keep in mind the differences because straight away this question can come in examination, that distinguish between partnership and a company or partnership and HF, right? So you have to very well answer that. Okay, now moving to the types of partnership. The first one is partnership at will. The name itself suggests at will, at my pleasure, right? So there is no fixed period that we have agreed upon that, okay, our partnership is going to be for 4 years. No, we have not agreed something like that till the time we want, right? Like the relationships of today's time, right? So it is going to go on till we like. The day we don't like, we'll just call and say break up, right? So that is how it is. There's no provision about deciding that if this happens then our partnership will break. No, no fixed period, no provision of determination, nothing, right? It is at the pleasure. Partnership for fixed period, of course, the duration is clearly fixed, that maybe we are partnering for a tenure of 2 years. Once that ends, either we'll again partner or the partnership will end, or if we continue, then it will be a partnership at will, right? Because our fixed tenure has already expired. Third is particular partnership, which is for a particular purpose or particular adventure. That means maybe I have got like 100 kgs of tomatoes and I partner with a friend and I for just selling these 100 kgs of tomatoes. So once these tomatoes are sold, the particular partnership that we had ends because that partnership was for this particular adventure only. And then we have general partnership, which is for business in general. That is how what we are talking about, right? All the partnerships which we are talking about are formed for that purpose only. Next, we have partnership deed. Although, let me tell you, partnership deed is not mandatory. It's not mandatory. What is partnership deed? The agreement written in the written agreement. Okay, so all the terms and conditions of partnership that you have agreed upon, they have been boiled down to writing. It's very important to have, because there will be n number of disputes if we don't have an agreement, right? So it's very important and suggested that every partnership must have an agreement, and that is called as partnership deed. However, it's not mandatory. So what are going to be the contents? The name of the firm, the name of partners, nature of business, place of business, when your partnership has started, the duration, the profit sharing ratio, capital contribution, how a partner will be admitted, retired, right? The salary or remuneration, if it's going to be paid, how can you add or delete any provision. Of course, you can add or delete a ground, that is not interest on drawings, interest on capitals, interest on loans, etc., etc. Types of partners. The first one is active partner. What is an active partner? Who is very well active, like he has joined the business to do the business, right? So he's actively participating in the conduct of partnership, whatever has to be done, whatever decisions have to be taken. He every day comes to the office, and so he's a partner. Every partner becomes a partner by agreement only. So when he agrees to be a partner, then only he will become a partner. Otherwise, he'll not become a partner. So a person who has become a partner by agreement and who is actively participating in the conduct is an active partner. Second is sleeping partner. He has become a partner by agreement only, but he does not take active part. Maybe there are a lot of people who are like doing side business, so they have invested their money, they're not actively taking part, right? Right? So their sleeping partner, when they retire, they're not required to give any public notice. Okay, I've made you a chart. Whenever you are revising this, please keep in mind that chart, right? Okay, which clearly says which partner has to give public notice, what he participates or not, he's responsible to third party or not, etc., etc. That full chart. Okay, next is nominal partner. Nominal partner means he does not have any interest in the firm, yet he has lent his name. Now, because you have lent your name, you're going to be liable for third parties, but you do not contribute to that firm, right? You're not participating in that business. Then why have you lent the name? Maybe you are, of course, sharing some profits. There are 4 students of mine who want to start a partnership firm, and they are like, ma'am, you please lend the name. If we write that you are also a partner, we'll get more business. So I said, fine, take my name, but I will take 2% of the profits. I'll not share the losses. So I'm not interested in anything else. I'm just taking the profits, right? I'm not so ruthless, but just an example. Okay. Now, partner in profits only. The next one, the partner who does not share the losses, right? So he's not going to be liable for the losses. He's only going to share the profits. Fine. Then we have incoming partners, outgoing partners. Incoming partners who is admitted with the consent of other partners. Outgoing partners who leaves the firm, retires, right? He has to give public notice. Then only his liability will end. And then we have one important partner called as partner by holding out, section 28, an important one. What is it? Partner by holding out. So he has not become a partner by agreeing directly, but he has agreed, or basically he holds himself as a partner in front of a third party. Or if somebody is holding himself as a partner in front of the third party, he allows himself, and he does not stop that person that no, I am not the partner. So he lets the third party presume and believe that he is also a partner. Now, because of his conduct or because of his words, he has made a third party believe that he is a partner. He is also going to be liable to that third party, despite being the fact that he is not a partner. Okay, so because he has held himself out as a partner in front of the third party. Clear? Okay. Now, if you become a partner of a firm, what should you do? Of course, you should carry on the firm's business to get maximum profits. You should be faithful to each other, because your actions are going to make others also liable. You have to render true accounts, and if you are keeping any accounts, if any account is kept by any one of the partner, then he has to explain it, what he has written, what he has not written, what it is, and everything, right? So these are in general the duties of partners. Okay. Otherwise, the mutual rights and obligations are decided by the agreement. The agreement may be express or implied, and it can be changed with the consent of all the partners. So these are the duties I have already told you. What are basically the rights of partners? He has the right to take part in conduct of business, that what business is going on, he can always go ask, he can take part. To be consulted, the decisions of partnership are going to be taken with the consent of majority. That means everyone is going to be consulted, and let's say there are four partners and three agree to something, so that particular thing will be done. Okay. But whenever you're changing the business, then it requires unanimous consent. Then you have to ask everyone, and when everyone agrees, then only you will change the nature of business. Otherwise, you whatever you have agreed upon, that you will continue, and whatever routine decisions have to be taken, they will be taken with simple majority. Okay. Every partner will have the right to access the books, whatever books are being maintained. Okay. You will not have any right to remuneration unless they have been agreed in the agreement, right? So of course, if there are four partners and they all are doing business, they're doing business to earn profits, and they're getting profits, right? So that is what you all are active partners, you're doing business. Supposedly there are three sleeping partners and only one active partner is doing everything, so he says that apart from the profits, I should also be entitled to remuneration. So if that has been agreed upon with the partners, then of course you will get remuneration. Otherwise, you're not entitled to remuneration. Okay. Right to share profits. That is what partnership is here for. That is what the business is here for. But in what ratio? If there's partnership deed, according to the deed. If there's no partnership deed, then equal sharing. Interest on capital not payable unless the agreement says so. Interest on advances payable even if no profit at 6% per annum. Okay. He has the right to be indemnified for the liabilities incurred in the ordinary conduct of business if any there is any partner, and he has done that. Other rights, he has the right to retire, he has the right not to be expelled, an outgoing partner to carry on competing business, dissolution of firm with the consent of all. There are a lot of things to make you understand. First, when I say there is any fraud which is being done in the firm, now the fraud is done by one of the partners. Although partner's action, if a partner does anything, he is making other partners also liable. But if you have done some fraud, don't you think it's his duty to rectify that fraud? And because of this fraud, the firm has suffered a loss of 5 lakh rupees, so that should be recovered from that partner only. Then only ideally a good partnership shall continue, right? So you have to indemnify the firm if there is any fraud which is being caused by you, right? So I hope that is absolutely clear. Okay. Now, I think I have written over here, right to be indemnified, right? So if you are a partner and you have done something like what? Because you are doing business every day, you are making so many payments, you are being attracted to so many liabilities, right? So maybe on behalf of the firm you have paid because this was an urgent payment to be done. Don't you think you should be indemnified for that payment by the firm? Of course, ma'am. So whatever payments we are making in the ordinary course of business, we will be indemnified for that, right? Now, it is our duty to indemnify the firm in case of fraud, in case of willful neglect. So if there is any loss which has been caused to the firm because of our willful neglect or our fraud, we will indemnify the firm. If we have made any payment on behalf of the firm will indemnify us. That is how the indemnification thing goes on. Okay. Is that clear? Okay. Now, we also have something with respect to the property of the firm. When I say property of the firm, it means the joint property, and basically the capital contribution which has been brought by the partners, any property which has been purchased from that pool money, right? The goodwill, all that is going to be called as the firm's property. And just because there is a partner who has a car and that car is being used for business purposes doesn't mean that that becomes the property of the firm and it becomes a joint property. No, it's his individual property only. Okay. So you are not going to use that. That is also one of your duty, you can say, that the property of the firm has to be used for firm's purposes only. You cannot use it for your personal uses. Next is, you're not supposed to derive any personal profit. If you derive any personal profit by doing a competing business, then you are liable to pay all that profit to the firm only. Let's say we have a professional partnership firm, right? We have a CMA firm, we have a CA firm, we have CS firm, right? Anything like that. So we are doing business together. All the clients are supposed to be brought on the table by all the partners to the firm only. Now I have taken a client and I have done some work and I made a profit of like 50,000, right? Which the partnership firm doesn't know, and I'm not supposed to do any business, any dealing outside the firm, but still I did it. So that 50,000 which I've made profit, that is going to come to the firm, right? So I'm accountable for that and I have to give it. Okay. Now we have the change. A partnership gets changed because of admission, that is, a new partner comes in, existing partner goes out, maybe you change the nature of business, or maybe you made the partnership for 2 years, but then after that also you're continuing partnership, so now it becomes a partnership at will, right? So there could be a change in a number of in a lot of cases, not a number of cases, but yes, of course, a lot of cases. What happens to the rights and duties after change in the firm? See, if there is change in constitution of the firm, the rights and duties remain the same as before. If you formed a partnership for a fixed period, but now you're continuing the partnership at will, the rights and duties will remain the same as before expiry. If you start an additional undertaking, then the rights and duties will be same as those of original adventures, right? Okay, this I already told you. Right? Okay. Now, partner, you are the agent also, as well as you are the principal also. You're both the agent and principal. I have already explained you the concept of mutual agency, right? Now we have something called a section 19, which talks about implied authority of a partner. What is implied authority? When you become a partner to the firm, it is obvious. There is no need to say such things. It is obvious that whatever you do in the ordinary course of business is going to bind the firm, right? If you are doing a normal mercantile business, then in that you have an implied authority to pledge or sell goods. Obviously, ma'am. To buy goods, yes. To borrow money, yes. To draw or make negotiable instruments, yes. The partners, don't you think they have the authority to sign a check? Of course, they have. So, in general, this is the implied authority. This need not be said anywhere, it is implied. It is implied. But when I say that you become a partner, that means you do not get this authority. This is not implied authority. This has to be expressly given to a partner. So it is not that a partner cannot open a bank account on behalf of the firm, but you don't have an implied authority. It cannot be said that, of course, I am a partner, I can open a bank account. No, you cannot. You need to get that express authority, right? So what is it for which you do not get an implied authority? That is, in the absence of any express agreement or any customs, the implied authority does not empower you to submit a dispute to arbitration, to open a bank account on behalf of the firm in your own name, okay, to withdraw suit or admit liability in a suit or acquire any immovable property, transfer any immovable property, enter into partnership, you cannot do all of this. You cannot do all of this, right? Now, your implied authority, supposedly you have the implied authority in general, because if you have a general business, then you have the authority to sign a check, right? You have the authority to make negotiable instruments, promissory notes, checks, etc., etc. Now, because you have this authority, let's say this is the implied authority, a partner has an implied authority to sign a check. But we don't trust this partner. This is a new partner which has joined, and we are like, no. Because many a times you will be seeing that when you want to join any firm as a partner, you won't get this authority. This authority will be restricted. This is an implied authority which exists in general, but this authority will be restricted. So can implied authority be restricted? Of course. Can it be extended? Of course. Right? So it may be extended, it may be restricted by contract between the parties. Now, supposedly, I am a third party and you are a partner, right? So you sign a check and give it to me. I don't know that your implied authority is restricted, but you have given me a check. So is it going to bind the firm? The answer is yes. So the restrictions will be effective if the third party knows about the restrictions, because I didn't know about the restriction. Your restriction are of no use and it's going to bind the firm. Okay. Or maybe I think that you are not a partner. So definitely I feel that you don't have the authority. So in that case, the restrictions are going to be effective. Otherwise, the restrictions are not going to be effective, right? Partner also has the authority, an extended authority, you can say, in case of emergency. Because if emergency hits, there is no rule book which comes along. There are no instructions which comes along. And a partner has to do all that a man of ordinary prudence would do. Okay, fine. Now, a very small point that notice to partner operates as notice to firm. So if you have informed a partner, that means you have informed a firm. Clear? Okay. So very, very, very simple. Notice could be actual, notice could be constructive, no problem at all. The only exception would be a case of fraud. Fine. Okay. Now we move to liability. Liability of partner and liability of firm. Partner, you are going to be liable jointly with other partners and severally for acts of firm's business. That means individually also you are liable and jointly also you are liable. Okay, that means if firm is unable to pay any debts, then you can be sent notice individually also. Firm has a debt of 10 lakhs which the firm is not able to pay, then you can be sent notice for entire 10 lakhs also, and you have to pay. Of course, you can take it from other partners later. So you're liable jointly also and you're liable severally also. Okay, that is what is partner's liability. Now when we come to the liability of the firm, liability, the firm is liable for acts of his partner. So if there is a partner and he has done anything wrong in the ordinary course of business with his authority, then the firm is going to be liable to that third party. However, if you do anything beyond the authority, any fraud, then you are supposed to indemnify. Okay. Next is rights of transfer of a partner's interest. See, just like when you become a member in a company, you can transfer the share. Yes or no? Shares are transferable property and you can transfer it from one person to another. But when we talk about partnership, you cannot transfer this partnership. You cannot make like, today I am the partner, I have given this partnership to you, so you become the partner. No, that doesn't happen. But of course, we can transfer the right. Okay, we can transfer our interest. We cannot make somebody else a partner in our place unless other partners agree and all that, right? But there could be share and partnership can be transferred. Like the share in partnership means what? The right to receive profits that can be transferred. And maybe like there is a partner who has taken loan from bank and is unable to repay that loan. So he says to the bank that, okay, I am transferring you that share in partnership. So you get the right to receive the profits and all that. But that doesn't make you the partner. You only become the transferee. You're not supposed to interfere in conduct of the business. You're not supposed to get the accounts of the firm, inspect the books of the firm. No, you cannot do all of that. Okay. So rights of transferee in general, rights of transferee on dissolution, then you will get the share of assets, and then you can see that yes, this is only the share that you are entitled to. So for that, you will be getting the books. Okay, now we talk about minor. Can minor be admitted to partnership? The answer is no. Minor cannot become a partner. However, he can be admitted to the benefits of partnership. Okay, he can be admitted to the benefits of partnership. Now, he has a right to share the profits. He has a right to inspect books. He can sue the partners for accounts or his payment, and he's not entitled to take part in day-to-day affairs. That is simple. Liabilities. When he attains majority, till the time he hasn't attained any majority, he does not have any personal liability and he cannot be declared insolvent. Okay, he will only get the share of profits. That is it. But when he attains majority, he will be given a span of 6 months to decide whether he wants to join this firm as a major partner or not. Right? So he can become a partner and he may decide not to become a partner. If in 6 months he's unable to decide, then automatically he becomes a partner, because if he doesn't want to become a partner, he has to give a public notice that he's not going to be a partner of this particular firm. Okay. So if he elects to become a partner, he'll be personally liable to the third parties. And if he does not elect to become a partner, then his rights and liabilities continue up to the date of giving public notice. That is it. After that, you are absolutely free. Clear? Okay. Now we have reconstitution or a change in firm. That is, first is admission of a partner or introduction of partner or incoming of a partner. That is given in section 31. Whenever you want to admit any new partner, you can do it only with the consent of all other partners or according to the partnership deed. Right? Now his liability will begin from the day he joins as a partner. He will not be liable for the old acts. However, sometimes he may say that I want to be liable for the old act, so I assume liability for the existing debts also. And it has been intimated to the creditors and creditors agree to it, then he's going to be liable, right? Otherwise, he's not going to be liable. Fine. Okay. Next is retirement of a partner. So how can a partner retire? According to the agreement or with consent of all the partners or by giving notice. Right? Now you retire, fine. But you will be discharged from the liability when you give the public notice, if you're required to give the public notice of your retirement, so that everyone knows that you are no more a partner and they're not going to give any debt or do any contract on your trust or relying on you, right? So you have to give the public notice. Public notice means what? If your firm is registered, of course you inform it, right? Otherwise you give it. Okay. So you will be discharged from previous liability when you give the public notice. Clear? Okay. Next is expulsion of a partner. Expulsion means you're removing a partner. Now, this you can do only and only if the power is there. Power to remove a partner is there in your contract. Point number 1. It is exercised by majority of the partners and it has been exercised in good faith. Good faith means what? You are, it's not that you have some personal grudges against a partner, so you have convinced other partners and you have removed the third partner. No, or fourth partner, whatever it is. No, that shouldn't be done. Whenever you are removing a partner, it should be for the best benefit of the partnership. He should be given a notice that we are removing you and he should get an opportunity of being heard, right? Then only you can remove him. Okay, so these are the conditions which must be fulfilled, then you can remove a partner. Okay, then we have insolvency of a partner. When a partner is adjudicated as insolvent, the same date he's no more a partner, he ceases to be a partner. he ceases to be a partner, there's no need of giving any public notice, and he's not going to be liable or responsible for any future thing. The firm will not be responsible for his acts, and he will not be liable for the firm's acts. Okay. Next, the deceased partner, right? So, when a partner dies, the existing partners may decide to continue the business, right? Yes or no? So, is he going to be liable? No. After his death, he is not going to be liable for any act, and he is not required to give any public notice. Okay. When an outgoing partner goes, like of course there may be a retiring partner, there may be a deceased partner whose legal heirs are supposed to get that share, because you are moving out of the firm. There might be a lot of accumulated profits, there was your capital contribution, there were a lot of things. Maybe the land that you bought at 20,000 is now appreciated at 20 lakhs, right? So you are also entitled to all that share as on date, right? So what is your right? Two things are basically given. One is section 37, which we actually read in partnership accounts and all that, that outgoing partner, if you have died or maybe you are retiring, then there could be two situations. One, your accounts have been properly settled and everything, you have agreed that okay, I'm entitled to this, and this has been paid to you. If your final accounts are not settled, that means you are leaving the firm without final settlement, then you get an option to either take this or take this. That is your share of profit after death or retirement. Also, whatever the firm is earning, you will get that share. If your amount contributed or your total amount comes out to be like maybe 1 crore, so you will get, in that proportion you'll get the share of profits. Or you can take interest at the rate of 6% per annum on that amount, right? So this is your option if you leave without final settlement. Apart from that, you have the right to carry on competing business, but there are some things. Outgoing partner, you can leave the firm and do a competing business, okay, but you cannot use the firm's name. You cannot represent that you are this is some branch of the firm or something like that. You're carrying the business of the firm, you cannot do that, and you will not solicit the customers of the firm. Okay, so you have to build and develop your own customers. Clear? Okay. Then we have something called as registration of firms. Now, registration is not mandatory. Registration is completely optional. So, if a firm wants to get themselves registered, they can get themselves registered. How? By making an application. By making an application to whom? By making an application to registrar of firms. How do you make an application? You can send that application by post and in the prescribed form. The contents have to be the firm's name, place of business, when your partners have joined, the full address of partners, the duration of your partnership. It is going to be signed by all the partners. You're not supposed to use the names like Crown, Empress, Queen, Royal, etc., etc. And within 1 year, you have to go for that registration. That is, of course, that can be deferred. There is a delay also, which is allowed in everything. Okay, so that is not a problem. And when you submit these documents to the registrar of firms, and if they are satisfied that yes, all the conditions have been complied with, they will issue you a certificate of registration. Okay. Now, because registration is optional and it's not mandatory, you can do it, you may not do it. But yes, if you do not register the partnership firm, there are some effects or some consequences or some disadvantages basically. What are the disadvantages? Firm or any other person can't bring action against third party. That means firm or the partners, you can't file a suit against the third party, but third party can file a suit against you. Neither firm nor partner can claim set off. If you have to take like 50 rupees from the firm and pay 100 rupees, you cannot say to the court that let me pay only 50 rupees. No, you have to pay entire 100 and you cannot bring right? However, when I talk about claim, if the suit is valued for more than 100, I have taken a wrong example. I should have taken an example of more than 100, because that is something which is allowed. Okay, you cannot bring legal action against the other partners or against the firm. So these are the disadvantages. Fine. Okay. Next, we have the dissolution of the firm. How the firm is going to be dissolved. The firm can be dissolved voluntarily also, or by the order of court also. Or I shouldn't say voluntarily, I should say without the order of court and with the order of court. Okay. So, what is without the order of court? When we all agree. So, we partners have agreed with mutual consent, they're dissolving the partnership. Can they? Of course, they can, right? They started the business to do something called as maybe manufacturing tobacco, which has now been banned by government. So, whatever your business was, it has now become unlawful. So, it's like compulsory dissolution, right? Unless you agree to some new adventure and form a new partnership, right? Because change in a business means new. Okay. Then dissolution and happening of certain contingencies like what, maybe there is a death of partner, or maybe you started or you formed a partnership for a particular partnership and that has happened, so of course the partnership is now dissolved. Or dissolution by notice. If the partnership is at will, like the most partnerships are, and somebody gives a notice that we want to dissolve the partnership, then you have to dissolve, right, from the date mentioned. So these are the cases when there is no intervention by the court. Now these are the cases when the court intervenes and court instructs to dissolve, right? First is when the partner becomes of unsound mind, or when the partner becomes incapable to perform his duties, permanently incapable, not a temporary disease, like maybe somebody has got typhoid, jaundice, temporary sickness, nothing like that, right? When there is any partner who is guilty of misconduct, maybe you have formed a partnership and your partnership agreement doesn't have any option to expel a partner, right? So you cannot remove a partner, so you are like what to do? This particular partner is continuously breaching our agreements, and it's not like maybe he is doing some theft in the partnership, we cannot even remove him, he's not following the conduct, maybe he's window dressing the accounts, right? Or maybe he is taking a lot of cash from the firm, etc., etc. So you can approach to the court and the court will order this. Okay. Next is when a partner has transferred his interest to a third party, and for recovery, like I hope you understand the recovery of areas of land revenue. If your debt is not paid, the government can recover that debt as they recover areas of land revenue. That is by appointing a recovery officer, the entire process is done and it can be taken, it can be recovered, right? If you transferred your interest to maybe a bank and then they are applying this, then the firm has to dissolve. Okay. If there is continuous losses in the firm, then how will you continue? And then you have the just and equitable grounds. What are just and equitable grounds? Maybe there is complete deadlock in the management, there was a partnership firm, or maybe a family partnership firm, but the family members are not talking to each other, right? So maybe gambling, loss of substratum, not in talking terms, deadlock. So in all these cases, there is no other option than to dissolve the firm, right? So these are the cases when the dissolution is going to take place by the order of court. Okay, fine. What are the consequences of dissolution? What will be the consequences of dissolution? See, when the firm is dissolved, the partners will continue to be liable until public notice is given. Every partner is entitled to have their property, um, entitled to have property of firm applied for payment of debt. See, there are two things. One is you have your personal property and then you have a joint property in the partnership firm. Supposedly, a partnership firm has a liability of 1 crore. Then whatever is the joint property, that is going to be used for payment of that liability. Your personal property shouldn't be first applied for payment of that. Although you are also liable, you have unlimited liability, but that shouldn't be used first. That is how it is, right? So I hope this is clear. Okay. Now, when you settle the accounts, first you will take care of the losses. That is, settle the losses. Thereafter, the debts of third party, due from capital, due on account of capital, and then whatever residue is left, that is going to be distributed amongst the partners. Right? Okay. So that is about settlement of partnership. And this I have already told you, that payment of firm's debts and separate debts, how it is going to be paid. Now, you will be binding the firm even after dissolution, so long it is necessary for the completing the process of winding up. That is it. Otherwise, thereafter, you will not be binding the authority. You will not be binding the firm. You, once the dissolution order is passed, thereafter, your acts are not going to bind the firm. However, they are going to bind the firm till and whatever is needed only for the purpose of winding up and not later. Okay. Let's now revise the chapter of LLP, right? So, LLP Act. Basically, when I say LLP Act, it's LLP Act 2008, but ideally it was passed or it's effective. The bill was passed on 12th December. It got the precedent assent on 7th January 2009. Okay, so the majority of the provisions actually came into force from uh, 31st March 2009. So this is the considered to be the effective date of starting of LLP Act. This LLP Act has 81 sections and 4 schedules. The schedule numbers are important because all the 4 schedules talk about something. The first schedule talks about the mutual rights and duties of partners when there is no formal agreement. Second schedule talks about the conversion of firm into LLP. Third, conversion of private company into LLP. Fourth, conversion of unlisted public company into LLP. Okay. The question is, what is LLP? LLP is a hybrid of partnership and company. Basically, LLP is a limited liability partnership. That is a partnership which is formed and registered under LLP Act becomes LLP, right? A partnership has many disadvantages. The most important one is that in partnership, the partners have unlimited liability. So this disadvantage has been made an advantage by giving it one of the features of a company wherein you have limited liability. So this is a partnership formed with the limited liability and hence it's called as a limited liability partnership. There are some features of LLP, like it is going to be treated as a body corporate undoubtedly. Perpetual succession, because it's a body corporate, it will have all the features of being a body corporate. So perpetual succession, separate legal entity, which is not in case of partnership. Mutual agency is not exactly like partnership because under LLP, the partners can make LLP liable, but they cannot make other partners liable because there's concept of limited liability, of course. This LLP agreement, this is an artificial legal person. They may choose to have common seal. There's limited liability. The partners can manage the business. At least 2 partners are needed. There's no maximum limit on number of partners of LLP, right? One partner has to be the resident. There are going to be 2 partners who are going to become the designated partners. You cannot form LLP for charitable purposes. So LLP, whenever you're forming, it's going to be for profit motive only. Central government will have the investigation powers. There will, if you want to merge, it's going to be according to LLP Act. If you want to convert, like if any firm, private company or public company wants to convert itself into LLP, then also the conversion is going to take place according to LLP Act. Fine. Okay, you can also convert yourself into the company, but that is going to happen according to the Companies Act. E-filing of documents on MCA portal, we all know that. Foreign LLP can also become partner in Indian LLP. The advantages of LLP, although not so important, but of course it is important. I shouldn't be saying not so important, but that is simple. That LLP is going to be organized because it operates on an agreement. It's more flexible, easier to form because of less compliances. There's biggest advantage of limited liability, flexible capital, because the partners can decide upon what contribution they want to bring in, and easy to dissolve in comparison to a company. So it is considered to be the hybrid of company as well as partnership. Is that clear? Okay. Now we have something called as financial year. What do you mean by financial year? Financial year starts from 1st April, ends on 31st March. However, if your LLP is incorporated after 30th September, then the financial year will end on 31st March of the year next following that year. Okay. Then we also have something called as small LLP, the concept of which you should be knowing. It means an LLP, the contribution does not exceed 25 lakh and the turnover does not exceed 40 lakh. There could be a higher sum prescribed, and that higher sum prescribed could be up to 5 crore or 50 crore, as the case may be. Okay. If you are within this requirement and you fulfill other criteria requirements which are there, then you will be classified as small LLP. So this is the definition that every student must be knowing and should know. Okay, now we start with section number 5, partners. The question is, who can become the partner of LLP? It's not that only individuals can become the partners of LLP. Well, if you are an individual and you are not of unsound mind, undischarged, insolvent, or you're not somebody who has applied to be declared as insolvent, then you are an individual and you're valid and you're allowed and you're eligible to become a partner of LLP. It doesn't matter whether you are a resident or a non-resident. Both type of individuals can become partner. Even if you're an overseas citizen, that means you're not a citizen of India, you're some foreign national, then also you can become a partner. Okay, LLPs can become partner of LLP, companies can become partners of LLP, foreign LLPs can become partners of LLP, foreign companies can become partners of LLP incorporated outside India can become partner of LLP. So we have such type of flexibility that they can become the partners. Okay, who cannot be the partner is the cooperative society and corporation sole, so they cannot become the partner of LLP. Okay, now minimum number of partners to maximum number of partners, there's no limit. There is something called as section 6, which is corresponding and similar to section 3A of Companies Act, which says that when you are formed as formed as LLP, well, you're formed with at least two partners. Now this two partners should be continuously there. Like, it should not happen that, okay, today I have formed the LLP with two partners, tomorrow maybe even if one partner dies, it doesn't matter, I can continue the LLP because LLP has a perpetual succession. No, has a perpetual succession, that is completely fine. But if at any time the number of partners fall below two, then you have to look for the other partner, because minimum statutory requirement is two partners. Now supposedly you try to find the other partner but you're not able to find it, and you continue the business up to 6 months, it's fine. More than 6 months, it's not fine, because as soon as you go more than 6 months, after that 6 months, whatever contracts you're entering into, whatever debt you're incurring, then you become personally liable. That is the only partner who's left becomes personally liable. Okay. Now, designated partner. You need to have minimum two designated partners, and designated partners cannot be companies. Ma'am, supposedly two companies have formed one LLP. Is it possible? Answer is yes. Now, two companies cannot become the designated partner, and to become designated partner, you need to be the partner. It cannot be some third party, right? So, how that is going to happen? How that is going to happen? Well, in that case, if there are only body corporates, if all the partners are only body corporates, then we will have the nominees of such body corporates, and that will act as designated partners. So every LLP must have at least two designated partners. They are like directors of a company. But to become a director, you need not be a member. Here, to become a designated partner, you have to be a partner. Okay, so two designated partners are needed. They are going to be individuals only, and one of them has to be a resident. One of them has to be a resident. Resident means somebody who has stayed for at least 120 days in the financial year. Okay. I hope I've told everything. Right. Now, who is going to become the designated partner? whoever is specified in the incorporation document, or else all the partners will become the designated partners, because you need to have minimum 2 designated partners. Maximum, they could be, all the partners could be designated partners, not a problem. Okay, fine. You need to obtain their consent, and they must have DPIN. Right, every LLP shall file with ROC particulars of DP within 30 days of appointment with the consent. So whenever they are appointed, within 30 days, you have to file this information with ROC along with their consent to act as designated partner. Fine. Now, designated partner, as I told you, they're like directors. They are responsible for all the compliances and will be subject to the penalties. Okay, so they are responsible for all the acts which are to be done by the LLP. Fine. So when LLP is required to file a particular document, and if non-filing is done, it is the designated partner who is going to be responsible. Right. Now, the designated partner can change also. There could be vacancy in the office of designated partner. If there are 2 designated partners which are required and one of the designated partner dies, that means it is a case of casual vacancy in the office of designated partner. What to be done now, right? So what you'll do is, if there is vacancy within 30 days, the designated partner will be appointed by LLP, and his consent and everything will be filed with ROC, and you will follow the conditions which are prescribed. If no designated partner is appointed, then each partner is going to be the DP. Okay. You have section 10, which states the penalty of section 7 and section 9. Now we come to incorporation of LLP. Incorporation of LLP. Basically, if I tell you, there are 3 things. You reserve the name, you submit the incorporation document, and the registration of LLP is done. Right? How do you reserve your name? You file form for reservation of name, and the period reserve name is for 3 months. Now, how to form or how to incorporate LLP? You need at least 2 persons, 2 or more. Lawful business, subscribe their names to incorporation document and file the document along with the fees and in the manner prescribed. Okay, where do you file it? ROC of the state where your registered office is going to be situated. Okay. Now, only incorporation document or application will not be filed. Of course, you need a lot of other documents. What are the other documents that you need to file along with it? Name of LLP, proposed business, address, names and address of partners, names and address of DP, and other information. Okay. Along with this, there is also going to be a statement. Statement what? Statement by advocate, chartered accountant, cost accountant, company secretary, whoever is forming your LLP, and by the subscribers to be partners, right? So by them and by these, that all the requirements of the act have been complied with, that all the requirements of the act have been complied with. Now, when you submit these documents to ROC, thereafter the registration shall take place. There is fees which is prescribed, and if all the requirements are complied with, then within 14 days ROC is going to register that incorporation document and issue you a certificate of incorporation, that now from this particular effective date, this LLP stands incorporated and has a separate legal entity. Okay. Clear? This is going to be treated as conclusive evidence, and within 30 days of incorporation, you have to file LLP agreement with ROC, because at the time of incorporation, you do not need the LLP agreement. Although it's advisable that at the time of incorporation only you should have submitted LLP agreement to avoid disputes, but that is not something which is needed and can be done later, right? So within 30 days of incorporation, file this with ROC. Clear? Okay. Now, registered office of LLP section 13. Every LLP, you have to have a registered office. This registered office can be changed, but it has to be there, right? So if any document has to be served on LLP or its partner or its designated partner, anyone can send it at the registered office and it will be deemed to be served. If you want to change the registered office, you can change the registered office and just file a notice with ROC in the form and manner prescribed. Okay, so within 30 days, actually, it has to be filed that you have changed the office. Within 30 days, this form, the form is form number 15, which has to be filed within 30 days. Okay, so that is how I learned. Clear? Okay. As soon as LLP is incorporated, it gets the power to own investments in its own name, acquire properties in its own name. It can dispose of, it can hold, it can sell properties, it can be sued, it can sue others, right? It may have a common seal. So all the features of body corporate are now available because this LLP is now registered, right? Okay. Now comes the name, section 15, name. Every LLP will have LLP as the last words. Like for companies, we have private limited and limited. So LLP, you'll have LLP as the last words, right? Now, can you keep any name? The answer is no. You cannot again keep any name. You cannot keep a name which is undesirable according to central government. You cannot keep a name which is identical or too nearly resembles another LLP, body corporate, or registered trademark. Okay, you cannot do that. I should strike this off. Okay. Now, if central government is satisfied, section 17, if central government is satisfied that LLP, you are registered with a name which is too near to another LLP or a registered trademark, right? Then what can be done, right? Or any body corporate, then what can be done, right? Central government can direct you to change your name within 3 months, and after you change your name you intimate it to ROC within 15 days, and when ROC gets this intimation within 30 days, ROC is going to issue new certificate of incorporation. This is exactly the same provision as we read for rectification of name under Companies Act. Now, registered trademark, you have to make an application within 3 years of the change or of the incorporation, right? So a new LLP is incorporated within 3 years. You get to know, you make an application to central government. Central government will give direction to LLP to change its name. Now, supposedly, central government has given the direction to change the name, but LLP fails to change the name. Central government will allot a new name to LLP, and ROC will issue a new certificate. If you do not like the name, go and change it later according to the voluntary change. You can do that. Fine. Okay. Now, relationship of partners. How the rights and duties are going to be decided according to the LLP agreement. Certainly, if the agreement is not there, any point, then it's going to be decided according to the first schedule. I told you the mutual rights and liabilities are going to be decided according to the first schedule of LLP Act in the absence of agreement. Okay. Fine. So sometimes an agreement is made before the incorporation. Then, if it is ratified once the LLP is incorporated by all the partners, it is going to going to be applicable and will impose the obligations on all the partners. Otherwise, of course, no. So, very simple thing. Then comes your cessation of partnership interest. That means ending of partnership interest. There's a partnership which we have formed, and all the partners have interest in that partnership. Yes. Now, this partnership interest is going to end. When it ends, maybe a partner has died, maybe the LLP has dissolved, maybe somebody has become of unsound mind, right? Maybe somebody has become insolvent. So the partnership interest that you had will no more be there, right? Or you may resign. If you want to, you can resign, right? So partner can cease to be the partner of LLP. That means he is no more a partner of LLP. Now, if he doesn't want to be a partner of LLP, if he wants to resign, well, you can do it according to the agreement. So maybe agreement says that you have to give 2 months notice, give 2 months notice and then resign. If there is no agreement as to how you want to resign or how you want to cease this partnership interest, then you have to give a notice of at least 30 days to other partners. Okay. Now, once your partnership interest has ceased, you are no more a partner, right? Then what will happen? You will still be called as a partner unless you give the public notice. Unless you give the public notice. If the third party has noticed that you're no more a partner, you'll not be liable to that particular person. Okay. Public notice means you can give the notice to ROC, right? And then you're free. Okay. After you cease to be a partner, you will not be interfering in the management, but you will still be liable for old obligations, and you will be entitled to receive your capital contribution and your share in accumulated profits. Okay. Now, ROC has all the details of all the partners. Yes or no? When we incorporated LLP, we gave all the details, names, address, everything of all the partners. Now, do you think this can change? Yes, ma'am. Partners can change their name, they can change their address, right? Maybe they're making huge and huge and huge profits, so they have bought a new house, another new house, like. So, do you think these changes need to be intimated to ROC also? Yes. The partner at first place, you need to tell your LLP that I have shifted from this place to this, so I have changed my address. So you inform LLP, LLP informs it to ROC. Okay. LLP informs it to ROC, right? Now, LLP, you are also supposed to inform certain other things. What certain other things? Other things like whenever there is a change in partnership. Okay, whenever there is change in partnership, like what, maybe the partner has resigned. So the resigned partner has given you a notice, you're supposed to inform it to the ROC. So when any partner ceases to be a partner within 30 days, you have to inform it to ROC. Okay, within 30 days, you have to inform it to ROC. Fine. Now listen. There's any partner, he changes his name and address within 15 days, he informs it to the LLP. LLP within 30 days of cessation of partnership interest or of change, anything, you have to fill the form prescribed and signed by the designated partner along with the consent of incoming partner. If a new partner is joined and you are informing that you will inform to ROC. Now, I told you that when we have an existing partner and that partner is resigning, he is still going to be liable till the time he does not give a public notice, right? Now, he has informed the LLP. LLP is not filing this information of his cessation with ROC. Although LLP is obligated to do so within 30 days, they should have done this, but they're not doing this. Now, because you are liable to third parties, what you can do is, if you have reasonable cause to believe that maybe LLP is not filing the notice, then you yourself can file this notice. ROC will confirm it with the LLP and ROC will register it in their records, and then you are free. Okay. Now, partner, you become an agent of LLP and not of other partners. Fine. If partner, extent and liability of LLP. See, basically, if you are a partner of LLP, then LLP is bound by all your acts. Okay, whatever you do, LLP is going to be bound, right? So, whatever you are doing in the ordinary course of business with your authority, LLP is going to be bound by it. LLP is going to be bound by it. When LLP is not bound, if you did not have the authority and the third party knows it, okay, when you do not have the authority and the third party knows it, like maybe you don't have that signing authority, the third party knows you don't have the signing authority, like maybe there's a huge firm of CMAs and I have just cleared CMA and I joined it as a partner. One of my friend wants some services, so I introduce her to the firm. So she has taken some services and now maybe I have to give some order or something like that. I give a check to her. She knows that I don't have the signing authority. I've just joined in as a partner and they haven't given me any authority yet, right? She knows about it. Still, I somehow take the check and sign it and give it to her, right? Now she is claiming from the LLP that no, your partner has signed and given this to me, so you are liable. The LLP is liable. No, the LLP will not be liable. Why? Because the partner did not have authority and you knew about it. Okay. When will LLP be liable? If partner is liable as a result of wrongful act. So this I just told you in general, right? Obligation of LLP is only the obligation of LLP and not the partners. Partners are not personally liable. Of course, there is a concept of limited liability. Okay, so whatever are the liability or the debts of LLP, they have to be met out from the properties of LLP only. From the properties of LLP only. Fine. Okay. Then we have section 29, which talks about partner by holding out. So anyone who represents himself as a partner or allows himself to be called as a partner in front of a third party, then that third party has relied that, okay, Shivangi is the partner of this LLP. Of course, I'm going to give this. Okay. So they have given money to that LLP, and now LLP is not repaying it. So they come to me and they said that, see, I gave money to your LLP, but this LLP is not giving it back now. Said, I don't know who that LLP is. Said, that day they were saying that you are also a partner and you did not deny it. So you have held yourself out as a partner in front of me. And based on that, based on that, I had faith and I relied on your words, and that is why, or I relied on your conduct, and that is why I gave the money. So you are now going to be liable. Yes. Why? Because he was not a partner of LLP. I was not a partner of LLP. I became the partner by words spoken or written. I let myself be represented as a partner. So I'm going to be liable to any person who has faith on such representation. Okay. Fine. So I become the partner by holding out. Okay. Then we have section 30 called as unlimited liability in case of a fraud. Fine. This is in general that whatever partner does, LLP is going to be liable, right? But what if the partner is trying to defraud the creditors? Partner is involved in fraud. Then in such a situation, the liability of that partner is going to be unlimited. Okay. Fine. Okay. Partner, designated partner, or employee is liable to pay compensation to the person who has suffered any losses. LLP not liable if partner acted fraudulently without the knowledge of LLP. If any fraud is done, both are going to be liable because the fraud has been done collectively. But if LLP says that I did not have the knowledge, only the partner is going to be liable. Fine. Okay. Then we have something called as concept of whistleblowing. What is whistleblowing? Whistleblowing is somebody who becomes an insider or the informer, right? So the court reduces their penalty. Like maybe there are 4 partners. One of the partner becomes the informant of the authorities. That is, he provides some useful information, or it leads to the original partner being convicted, right? So what will happen? During investigation, the court or NCLT may reduce or waive penalty, and that particular partner will not be suspended or demoted just because he has provided that information. Okay. Contribution by the partners. What do you think contribution can be brought? It has to be only cash, or it can be in kind also. It can be cash or kind. It doesn't matter. Tangible assets, intangible assets, movable, immovable property, any other benefit that you can bring on the table is more than welcome, right? Its monetary value will be ascertained, because in cash we can easily say that, okay, you have got 10,000, that means it's 10,000. But if I have got furniture, what do you mean by that, right? The furniture is worth, I could say it's worth 1 lakh, but what is the actual value? So that actual value has to be calculated, and it shall be accounted in the manner prescribed. Okay. Now, whatever is your agreed contribution, maybe you have agreed to contribute up to 1 lakh. So whatever is your agreed contribution, that agreed contribution you have to, that is your obligation to bring it according to the agreement. Okay. Every LLP, you are required to maintain certain books of accounts. What are the books of accounts that you need to maintain? First of all, you have to maintain the books according to accrual basis or cash basis. I should write over here. And if it's not written in your chart, you can also write accrual or cash basis. Okay, remember this. Accrual or cash basis. Just a second. Okay. Fine. So you can prepare the book. So you have to prepare it for double entry, accrual or cash basis, right, for every year, and it's going to be maintained at the registered office. It's going to be for such period as prescribed. Audit is not mandatory for every LLP. We'll be reading about audit a little late. Okay. Fine. Now, apart from maintaining the books of accounts, you also have to file 2 more things. One is statement of account and solvency, and the other is annual return, which we read in the other section, right? So, what is a statement of account and solvency? After your financial year ends, within 6 months, you have to prepare this. It's going to be signed by the designated partner, and it's going to be filed with ROC every year. Every year. Okay. Fine. penalty for not filing. Then we have another section called as section 35, which talks about annual return. So every LLP within 60 days of your financial year, you have to file form 11 and in the prescribed manner to ROC. That is your annual return. Again, you have a penalty for not filing. Okay. What are the documents that we have filed so far? We have filed the incorporation document at the time of incorporation, right? There are the details of all the partners, the changes that we filed about the partners, statement of account and solvency, annual return. So these are all the documents that we have filed so far. They're going to be available for inspection by any person, but in the manner prescribed. Okay. If at all you give false statement to LLP, to ROC, about in any return, supposedly you're filing annual return and you have given some false information in that annual return, then there is going to be punishment which is stated in section 37. Okay, then we have section 38. Registrar can require a lot of more information as they consider necessary. Maybe they feel that, okay, this, you have filed this information, but what about this? So they can ask it to the present partner, the former partner who is not no more a partner, but who was partner at the time of the year when you need the information, designated partner or the employee. Okay, to answer any question. If it is not answered within the reasonable time, ROC will have the power to call that particular person, summon that person and ask him the information. And if you do not do that, there will be failure. The failure will attract penalty. We have a section called as compounding of offenses. Basically, compounding means what? Escaping the trial, escaping the prosecution, right? You are paying the fine, you're paying the penalty, and you're escaping the whole trial. It saves time, energy, everything of you, of the court, right? So those offenses which are punishable with fine only, because if they're punishable with imprisonment, you cannot replace it with fine. Okay. So those offenses which are punishable with fine only, they can be compounded by the regional director or any officer above the rank of regional director. Okay, so how are you going to do that? You will make an application not to the regional director but to the registrar. Registrar is going to forward it to RD, and RD will compound it. Within 7 days it's intimated to ROC, and there won't be any prosecution. If the prosecution has already started, it will end the prosecution. Now, if you do the same offense within 3 years, then there won't be any compounding. Okay. Just like we have read that partners' share in profits in case of partnership can be transferred, although he cannot make anyone his partner in his place, in the same manner here also, the right of a partner to share the profits and losses can be transferred, maybe partially or maybe completely. That doesn't mean that if I am transferring the right to share the profits to a bank or something like that, the bank becomes the partner. No. So it is not disassociation of partnership. It does not permit the transferee, that is the bank, to come and interfere in the management. No, he is not the partner. I'm only the partner. It's just that the right to share the profits has been given to him. So that can be done. Yes, that can be done. Okay, now we have something called as conversion. Conversion of firm to LLP, conversion of private company to LLP, conversion of unlisted public company to LLP. Section 55 read with second schedule, section 56 read with third schedule, 57 read with fourth schedule. And according to the provisions of this particular chapter, basically what is being done is you make an application to ROC, right? There is some basic criteria which has to be fulfilled. Basic criteria, that means if you're converting your firm into LLP, then all the partners should be the partners of firm only. There couldn't be any third party. Likewise, the same goes for the shareholders of private company and the unlisted public company. So that is one. Okay, so except the partners or except the shareholders, there won't be any other person who is allowed to become the partner of LLP post conversion. Okay, later on you can add, that is a different thing, but at the time of conversion that is not allowed. Okay. Secondly, you have to make an application. What is the application that we make? The application is going to be made by all the partners or all the shareholders, right? And the name of the firm, the registration number, and the incorporation document. All this is going to be filed to ROC, and they will issue you a certificate of incorporation of LLP. It may be refused also, it may be admitted also. If it is refused and you're dissatisfied, you can file an appeal to tribunal. Okay, once it is registered, you inform your registrar of firms that yes, now we have converted ourselves into LLP. The similar provision is there for conversion of private company into LLP as well as public company into LLP. What is there? A statement by all the shareholders, the name and registration number of the company, the date on which company was incorporated, the incorporation document. So all these documents are filed to ROC. ROC can reject also. If you're dissatisfied, you can file an appeal to tribunal also. Okay. So this is the way how you do that conversion. Once the conversion is done, your firm, private company or unlisted public company becomes LLP. Right. So registrar will register the docs, issue you certificate of registration. Within 15 days, you have to inform your old ROC that yes, the firm has been converted or the company has been converted. Okay. The partners of the firm or the shareholders becomes partner of LLP. There shall be LLP property vested in LLP, dissolution of firm and company. So all the property of firm and the company will now vest in LLP, and the firm or the company will stand dissolved. Clear? Okay. Now, compromise or arrangement of LLP. The compromise or arrangement could happen between LLP and its partners or LLP and its creditors, right? We also have a concept of foreign LLP. I think it's stated later. No. Okay. So let me first do that. Then I'll be telling you about foreign LLP, although that's covered in section 59. So I should have told you before, but let's first do that's compromise. Okay. Now, compromise cannot happen just like that maybe a partner has agreed to contribute 1 lakh and now he is like, no, make my agreed contribution 80,000 only. So there's some kind of compromise or arrangement that's happening between LLP and its partners, right? Or LLP and its creditors also. Many times a compromise or any arrangement happens. What is going to happen is you have to make an application, right? Application can be made by whom? Application can be made by LLP, creditor, partner, right? Or maybe even the liquidator, right? So they can make an application to tribunal, right? That we want to enter into any compromise or arrangement. Now, whenever you are entering into any compromise or arrangement, it could be in pursuance of a or in connection with a merger, not in connection with a merger. If it is in connection with a merger, then you also have to comply with section 62. Okay, if it's not in connection with the merger, no problem, right? So whenever that's happening, that you will make an application to tribunal will order a meeting of the partners or of the creditors, and you have to get the consent. You have to get the consent of 3/4 in value of the creditors or partners, whoever are there. If they agree that okay, fine, we agree to this compromise or arrangement, then tribunal, if you're satisfied that yes, everything has been correctly disclosed, all the material facts have been disclosed, the financial position of LLP has been correctly disclosed, then they'll sanction the arrangement, and within 30 days you have to file this order with ROC. Okay, once you have sanctioned the compromise or the arrangement, tribunal, you also still have the power to supervise it and give directions or modifications, make modifications as and when needed. If you feel that no, this compromise or arrangement is not working out, then you can also order winding up. Sometimes the arrangement or the compromise could be in connection with a merger, like maybe there is LLP which is not performing very well, so another LLP is taking it over, right, acquiring this LLP, and based on that they have also negotiated and they have spoken to their creditors that okay, we will be paying you this, or are you ready for this merger is taking place, etc., etc. So this scheme of compromise or arrangement is happening in connection with a merger, right? So if it is in connection with any amalgamation, reconstruction, merger, or maybe you're transferring an undertaking, that is reconstruction basically, then NCLT you will sanction. Apart from the sanction, you will also, or you can also pass orders that okay, now we have transferor and we have transferee, right? The new and the old, right? So all the property and liability of old will now go to the new one. The legal proceedings which exist over here, that can be continued in this name, right? This will be dissolved without winding up. That means it need not sell its assets and pay off the liabilities. It will be transferred and it can just lose its existence and be dissolved, right? If there are dissenting people, then the provisions has to be made for dissenting people, right? And other matters. So it can pass orders with respect to this also. Whatever order has been passed, within 30 days you have to file the order with ROC. Okay, with ROC. Now you have something called as Section 59, which talks about foreign LLP, right? What do you mean by foreign LLP? LLP which is incorporated outside India but establishes a place of business in India. Now, as and when you establish a place of business in India, within 30 days you have to file with ROC Form 27, which will contain the details of your incorporation document or incorporation instrument, your MOA, whatever you have, right? The full address of LLP in your home country, list of partners and designated partners, two persons in India who are authorized to accept notices over here, the details of place of business in India. Okay, it has to be certified in the prescribed manner, right? The certification has to happen like three ways. If the country is a part of Commonwealth, if the country is outside Commonwealth and part of Hague Convention, or maybe outside Commonwealth and not part of convention. So accordingly, this is going to happen. Okay, accordingly, this certification is going to take place and happen. If there is any change, maybe you have changed your name, or maybe you have changed the people who are here authorized to accept, that is the person resident in India, or maybe you have changed principal place of business in India, then within 30 days you have to inform. If you have changed the registered office over there, or maybe you have changed the partner, or maybe you have changed the designated partner, then you will inform it within 60 days of close of financial year. Okay, you have to file this with registrar. And when you cease to hold this place of business, then also within 30 days of your intention to close, you have to inform it to the to ROC. Okay, now we have something called as winding up, right? We have something called as winding up and dissolution. The winding up could be voluntary, it could be winding up by tribunal also, right? When I say voluntary winding up, just a second. When I say voluntary winding up, basically a resolution is passed by 3/4 in value partners, right? That is treated as date of commencement of winding up. After that, you have to do a lot of things, right? First thing that you have to do is obtain the consent of creditors, 2/3 in value. When you obtain their consent, within 15 days, you have to file the consent with ROC. Within 14 days, you have to make an application before NCLT for the approval of winding up. Okay. Now, within 30 days, you have to appoint a liquidator, which is subject to approval by the creditors. So if 2/3 in value creditors approve, great, that liquidator can continue. Otherwise, you have to change the liquidator. If not appointed, NCLT will appoint. Okay. Within 30 days of date of commencement, you also have to file Form 1, which is a kind of declaration to ROC. And this declaration is by majority of the designated partners that either LLP does not have any debt, or LLP will be able to pay its debt within the specified period. Okay. It's kind of solvency declaring that, right? Okay, now within 15 days, you also have to file the statement of assets and liabilities in form number 4, attested by two designated partners, plus the valuation report, that these are the assets and these are the liabilities which LLP has. This has to be latest practicable date, right? And this is the valuation report. So all this is going to be filed with ROC. Once you are done with this, you have a liquidator whose duty is to prepare a list of creditors, partners, get the approval of creditors, maintain proper books, pay the debts, observe due diligence, quarterly report to the partners or creditors. He can be removed after giving him an opportunity of being heard. If any application is shown by ROC, or maybe the partners or the creditors want and decide, right? And the partners and creditors can also form a committee to supervise the process of liquidation and assist the liquidator. Liquidator, you're supposed to first pay the liquidation cost. Keep in mind the secured creditors and the workman claims. Thereafter, satisfy all the other liabilities, and then whatever is left, you will distribute it to the partners. If you're able to complete the winding up within 1 year, great. If not, then you have to make an application to NCLT, explain the reasons, and seek accordingly directions, right? Once you've completed the winding up process, then you will prepare a report that how do you did the winding up, how LLP property was disposed of, everything. You will get the approval of partners and creditors, and thereafter, when they pass the resolution within 15 days, LLP liquidator, you are supposed to inform two people. One is ROC. You give the copy of final accounts and the report in Form 10 to ROC. And you also make an application to NCLT for seeking the order of dissolution, right? Once you get this order of dissolution, if NCLT is satisfied within 60 days, they will give you an order of dissolution. You take this order of dissolution within 30 days, file it with ROC. ROC will immediately issue a public notice that this particular LLP stands dissolved. Okay. Now, we have the winding up by NCLT. Winding up by NCLT means what? Tribunal, on these grounds, that is the grounds mentioned under section 64, you can wind up any LLP. When, if LLP decides that they want to wind up and they want to go through the winding up by tribunal, they can make an application to NCLT. They don't want to follow the process of voluntary winding up. Okay. Second is, if their partners fall below 2 for more than 6 months, if you're unable to pay the debts, if you acted against the sovereignty and integrity of India, if you defaulted in filing statement of account insolvency and annual return for a consecutive period of 5 years, or it is just and equitable that this should be done, then winding up shall take place. Okay. So LLP may be wound up on these grounds when an application is received in duplicate by LLP, its partner, creditor, ROC, CG, anyone, right? LLP or partner, when you make an application, along with that, you also give a resolution and the statement of affairs, right? If others make an application, they don't give any statement of affairs because they will not have the statement of affairs of LLP. So when an application is received by ROC or central government or the creditor, NCLT will first send this to the LLP itself, and they get the chance to raise an opposition or raise an objection that no, we don't want this LLP to be wound up, right? So you get a chance to oppose. Fine. NCLT may admit the petition and pass orders as it thinks fit. It can also pass winding up order. It can also dismiss the application. If it passes the winding up order, within 15 days it will be intimated, and liquidator, what you have to do is now, it will also be notified in official gazette that this LLP winding up process of this LLP has been initiated, right? So that everyone around gets this public notice and is now aware that, okay, this LLP is now going to be wound up, right? Okay. So liquidator, you will be sending notice to everyone, and you will take into the custody the property, books, claims of LLP, everything. And within 60 days of passing of winding up order, you have to prepare a report that this LLP has this much cash in hand, these are the assets, this is the contribution pending, this is the liability, these are the guarantees, these are the pending court cases, these are the subsisting contracts, these are the intangible assets, everything, right? So you'll prepare such type of report, and if this report indicates that there is a fraud, NCLT can order investigation, right? If it thinks that it can be rehabilitated, they may order rehabilitation. If it thinks that it's a beautiful business and should be sold as a going concern instead of winding up, they may order this also. And otherwise, they will just consider the report and decide that, okay, this much time is needed and should be sufficient for winding up of this particular LLP, right? If a liquidator feels that, no, I need more time, they can ask for extension, and they'll get extension for up to 30 days. After that, liquidator, you will do the entire process. You have to file quarterly report also to NCLT. If any person is aggrieved by the action of liquidator, they can file an appeal to NCLT, right? You have to maintain the books which will be audited. Thereafter, when you have got paid all the debts, right, accordingly you will satisfy the claims. To satisfy the claims, first of all, you will be paying to the outside liabilities, the secured creditors. First of all, liquidation cost will be covered. Thereafter, all these are going to be paid. Thereafter, whatever is left will be paid to the partners. Okay. If anyone is dissatisfied, they have the right to appeal. Okay. Fine, once this winding up is completely done, then you will again approach to NCLT for seeking the order of dissolution, and you can dispose of the books in the manner prescribed. Okay. So, in the same manner as we have read in voluntary winding up that you seek the approval for, you seek the order of dissolution. Likewise, here also you will seek the order of dissolution, and thereafter the LLP shall stand dissolved. Okay. So these are the broad details which I've already told you. Now we have something more. There are some disqualifications which are attracted to a designated partner, that if you have been adjudged as insolvent in the preceding 5 years, you cannot be a designated partner. If if you have suspended payment or made any composition with the creditors in the past 5 years, you cannot be designated partner. If you have been involved with any offense involving moral turpitude and you have been sentenced to imprisonment for at least 6 months, okay, then you cannot be designated partner. Fine. So these are the disqualifications that you need to understand and remember. If LLP wants to change its name, it can change its name. Voluntary change of name is allowed according to the agreement. If there is no agreement, then you have to get the consent of all the partners. Once you change your name, within 30 days you are supposed to inform it to ROC. Audit, I told you every LLP's accounts need not be audited. Okay. If the turnover does not exceed 40 lakhs or contribution does not exceed 25 lakhs, then they shall not be required to get their accounts audited. A voluntary audit is allowed. Of course, you can audit as and when you want to. Thereafter, who is going to appoint the auditor? Well, the auditors are going to be appointed for the first financial year by the designated partner, and if the designated partner fail, will be appointed by the partners. If no auditor is appointed, he will be appointed every year. That is how it is. So at any time for the first financial year. Okay. Thereafter, if no auditor is appointed, it will be deemed to be reappointed. Okay. How can you remove the auditor? You can remove the auditor according to the agreement. If there is no agreement, the consent of all partners. Fine. Can the auditor resign? The answer is yes, he can resign. If he doesn't want to continue, how he can resign? By giving a notice in writing to the LLP's registered office. There are some documents which need to be preserved for LLP. We have some documents which need to be preserved permanently, like incorporation document, your registered office, your LLP agreement. Okay. All these documents are required to be preserved permanently. Then we have some documents which required to be preserved for 21 years, like relating to liquidation accounts. Some documents which are required to be preserved for 5 years, some for 3 years. After that, you can destroy the records according to the manner prescribed. Okay. So you have to learn these documents about preservation, right? So that is it with respect to LLP revision. Hello everyone. Let's now revise the chapter of ethics. Chapter, or I should say a different section, section D, business ethics, which is actually 15% coverage of your syllabus. And you hardly have to read some part, very few content for in comparison to the marks which have been awarded, right, which have been allotted. And there is also very less content to learn because ethics is a very generalized concept, although it's very vast. But to fetch marks, you have to write certain things and you have to write those only, right? You cannot change it if you want to get good marks, right? So we have identified a lot of questions, right, which are asked and which may be asked pertaining to every single topic that we have read throughout the topic of ethics. Now, ethics, although when we look at our study material, it's divided into 10 units, but we all know that the coverage is extremely less, right? So let's start revising. This is the overview, but we are not getting into that overview. We'll straight away get to the main topics. The first unit that we come across is ethics, meaning, importance, and nature. Right. So, what do you mean by ethics? Ethics is a term which is derived from a Greek word which is ethos. Ethics basically is a set of rules that define us wrong and right conduct. Now, in today's era, in today's time, when we are talking about business, because ultimately we are reading laws, we are not applying these ethics or applying these laws in our personal life, but rather in the business and the commercial world that we are talking about, right? So, when I talk about business, if there is one ethical misstep, right, that means you did something wrong, it's going to go viral on social media and the reputation can turn into ashes in a fraction, not in a few minutes, you can say, right? So it's very important to maintain ethics even at the work front, right? Okay, so ethics are the rules that define this is right and this is wrong. This I should do, this I shouldn't do. Why? Because you want to succeed in business. Set of moral principles that guide a person's behavior. The question is, what is the difference between morals and what is the difference between ethics? See, morals are our individual beliefs that have been shaped as a result of our customs, traditions, religious values, practices, and everything, right? That is the morals that we have grown up with, right? So it is a moral that we know that okay, we have been always respecting our elders, we have not been speaking in front of them, right? So this is the moral that we have grown with, right? This is the moral value or the morals that has been shaped because of my cultural practices which has come across. Now this ethics are derived from the morals. So they are individual moral beliefs. So now I know that respecting elders is right and disrespecting them is wrong. So this is my ethics which has been evolved by my morals. And these are like ethical beliefs, are these are held by me. These are individual ethical beliefs. Now, when I join any company or when I start my own business, this is an individual ethical belief which I pass on to my organization, and that becomes a corporate belief also, or corporate ethics also. Okay, the next thing is types of ethics. Now, what are the different types of ethics? These are the three types of ethics: meta ethics, normative ethics, and applied ethics. This is asked as a MCQ also, and this can be asked as a direct question also. Now, what are these three types of ethics? When I say meta ethics, it is dealing with the nature of moral judgment. Basically, first I should tell you what is normative ethics. Normative ethics is the content of moral judgment with a criteria for what is right, what is wrong. For example, if you find um, someone's wallet maybe on the road, right, or you find a 500 rupee note on the road while you're walking, now is it right or wrong? Is it right or wrong? It's a moral judgment. Based on our morals, we are going to take a judgment, right? So content of moral judgment with the criteria of what is right and what is wrong. That is normative ethics. So it is telling us, no, this is wrong. Why this is wrong? Because if we do this, we will get the curse and we'll have to go to hell. Maybe that is your criteria, that this is right, this is wrong. God will punish us if we do that, whatever it is, right? So that is normative ethics. Now meta ethics is going to deal with the nature of moral judgment. It is more like a philosophy. It is more like why everyone has their own perspective. It is like analyzing on that thing that no, maybe God has actually sent this 500 rupees because you were in need, so it has been sent by some angel, something like that, right? So there are two perspective of everything, right? So it is not going to specify that this is right, this is wrong. It's basically discussing about the nature of moral judgment. Okay, so it's beyond ethics. It's that's philosophical science. And when I talk about applied ethics talk about the application of ethics in the real world problems, right? So it always talks about the controversial topics, wherein maybe you could have one say that animals should not be eaten, you could have one say that no, growing to this, animals must be eaten, it gives us health benefits, etc., etc. So that is like controversial topics. Okay, now importance of ethics. Now, there is a difference between importance of ethics and importance of business ethics. Please keep that in mind. When I say importance of ethics, of course, it is a requirement of human life. Whenever you want to take any decision, you cannot take decision unless you have ethical values involved in it, right? Or any ethics. right? Then only you'll be able to decide that, okay, I should do this or I should do that. Otherwise your actions would be like random and aimless. Maybe you're going on the road, there is somebody who has fallen down, you should pick or you should not pick. It out of your ethics you will pick somebody, but otherwise, like, it's random. Even if you're doing, it's aimless. Even if you're not doing, it's aimless, right? Proper foundation must have a standard of value to compare the goals and actions. And system of ethics to be for emergency situations and day-to-day choices. So of course a system of ethics must be there, not just only in emergency situations but also in our day-to-day lives. The third question that may come is ethics, nature and relevance to business. Now when I'm talking, although I told you that ethics in our personal life is nothing very fancy and very much of course it's needed and it's a requirement of human life, but here we are not supposed to read about our personal life and how ethics should be incorporated in our relationships and everything, right? Here we are talking about business, purely business. So do you think ethics is needed in business, or a business without ethics can even do better? Several factors play role in the success of the company. One is your quality, the other is your cost, right? The third is also your ethical practices. How? Because if you have ethical behavior towards your customers, they'll feel valued and they'll come and they'll boost the sales. If you have ethical behavior towards your employees, they will feel valued and they will be retained, right? Okay, so when management for philosophy is based on ethical practices, leaders can direct employee by example and guide them in decision making, which is going to be beneficial for both the individuals as well as the organization. Now, supposedly there is absolutely no ethics in anyone's philosophy. So employees will always be in a dilemma whether I should do this or I should do that, right? Because they don't know what to do. If there is not always a choice which you can make random and aimless, right? If it is guided by ethical behavior, then you can make a decision in lesser time and it's going to be a better decision and it's going to increase productivity and employee morale. Okay. Now, if the company's reputation is that it does not operate ethically, investors will not buy stock. Ethical behavior is going to increase the public positive image, and I already told you it's going to work wonders on the reputation also. Then we have seven principles of public life. Again, a very, very, very important question, which is asked n number of times in examination. So that's unit 2. Here you should also be remembering one question from examination perspective, that the seven principles were set out by Lord Nolan in year 1995. So this could be an objective question. Now what are the seven principles? The first one is selflessness. Selflessness, that means you are not supposed to think about your own self, but to think about public, because you are a public servant at the end of the day. Integrity, there is a difference between integrity and honesty. Honesty is about being truthful, and integrity is not putting yourself under any obligation which where you can get influence or your work can get influenced. Like maybe you are accepting some gifts and later you feel obliged that, oh, I accepted such heavy gifts, he gave me such heavy gifts, so I must give the tender to him only. No. So that is how you should be in maintain integrity at all time. That means not put yourself under any obligation or not be in a situation where your work can get influenced. So be truthful, that means always speak the truth. That's honesty. And integrity is slightly different, right? Then we have objectivity. Objectivity is maintaining impartiality and unbiasedness at all times. So no matter what is coming to you, you have to maintain that impartiality. Maybe somebody, you are inclined towards somebody, still whenever you are making business decisions, it's always going to be impartial. Accountability, if you have taken a decision, you are responsible and you should take that accountability that, okay, it was my decision and this is the action or consequence of that decision, so I take complete accountability. Openness, there should always be transparency and disclosure. And lastly, we have leadership. Now, leadership, obviously, whenever you're working in any office, you are supposed to be a leader if you're put to that leadership position. But also, at even if you're not the leader over here, then also you should have the courage to challenge poor behavior if it is displayed in that office. Now, many students have this confusion also, ma'am, what do you mean by public life and what are we talking about? See, we are talking about the holders of public office. Holders of public office means what? The offices which are meant to serve public, like we have police station, right? Like any office like that, right? So railways, whatever it is, right? So if you are an office which is meant to serve public and you are a holder of that office, that means you have occupied a position, you are being employed by the government to serve public, so you are a holder of a public office. And if you are in that particular position, these are the seven principles that you must inculcate. Okay. Next, we have relationship between ethics and law. Now, there are five things. First is, what do you mean by law and what do you mean by ethics? So, ethics are the set of rules that guide our internal judgments, and laws are codified norms that is being enforced by the state, right? So, the government is telling us that you have to do this and you have to not do this, right? Now, ethics vary from person to person, right? I might think of something else, you might think of something else, but laws are going to apply uniformly to everyone. And if you are going to breach law, then you will be punished. But if I'm going to breach my own ethics, it's not enforceable in general cases, right? There is a complex relationship between laws and ethics. There are many laws which have been derived from ethics only because people believed in something. They have been over the years established that this is wrong and this is right, and such laws have also been made to establish that this is wrong. If you do this, you'll be punished also. And there are many ethics also which people have evolved because of the laws. So laws have been made that no, dowry is wrong and it's going to be punished. So over the years, that regressive mindset of people has changed, right? Over the years, the regressive mindset of people will change. Maybe amendment in Hindu Act, right? That now the girls are also entitled to the property, right? Now that's again debatable, and there can be a number of conversations on that, but again it might change a mindset in future, right? So it might lead to a certain type of conduct, that this is right, this is wrong. So if somebody is not doing this, then oh my god, he's doing wrong, right? So many laws are representative of ethics, and many laws have shaped ethics also. Okay, so what is important? Law or ethics? Law and ethics go hand in hand, and they're equally important. And without laws, you cannot function in a society, and without ethics also you cannot, because laws cannot be made for every single possible situation or scenario. So laws cannot be everywhere. So wherever law is not there, then you have to take a decision. That decision can be taken only on the basis of ethics, right? Okay. Now we talk about business ethics and its relevance to business. Here we are not actually talking about a lot of business ethics, but we are talking about business code of ethics. Now there's a difference between business ethics and code of ethics. Business ethics are in general what we feel about, right? Code of ethics are the formulated, documented things of ethics which the employees are expected to adhere to. So it is what? Body of policies and values that a company wants employees to adhere to. Examples: what could be in your code of ethics? Example: promoting green business practices. So maybe in your code of ethics you could incorporate that promote green business practices, like print less paper, right? Limiting that paper consumption. Second is obeying the law. At times many feel that obeying the law is not important. As long as you are in the work premises, you be and maintain that decorum. Once you step out of the work premises, then you do whatever you want to. But it's not the case. Maybe there is a driver who is driving under influence. He gets caught in drunk driving, right? Now you are running a company maybe called as Uber. So will you be confident enough to take that particular person as a driver? The answer is no. Why wouldn't you want that? Because if he can drive, if he can drink and drive after work, maybe at work also he can do that, and if such type of complaints come, it will be bad for company's reputation. So reputation is at stake. So it is, what is the code of ethics say that all the employees who want to work here must obey the law. They must be caring and considerate towards their customers. They should maintain confidentiality and privacy at all times, right? Because there is a lot of private information about customers which may be there even in law firms, right? For research, there is a lot of private information which comes, right? Now if you disclose it, then you will lose the client, right? And it's going to be very bad for image. It's going to be very conveying a very bad sense about the company, right? Next is professional appearance. Now professional appearance, because of this many companies have a dress code policy, and even when there is no dress code, then also employees are expected to wear ironed clothes, formals, business casuals, maybe on Friday or Saturday if it's working, right? Why? Because the more clean and professional clothes you're wearing, it develops a sense of confidence and trust that yes, it's correct, yes, you're doing it right, right, yes, they will do it right. So it gives a sense of more confidence, and it helps to build a better image, right? Next unit we'll move to, that is values and attitudes of professional accountants. Now when I'm talking about an accountant, who is an accountant? Accountant is somebody who's doing that accounting work, right? Now when I talk about professional accountants, they not only are doing that basic accounting, but they also have a lot of other expertise that they bring to the table, right? Expertise in different matters, right? Okay, so they contribute a lot to the financial reporting, they contribute a lot to the overall stability of the organization. Okay, one such professional accountant is management accountants, or we may say cost management accountants, right? So they are an invaluable asset of the company. And when I'm talking about management accounting or cost management accounting, it is not concerned with only reducing the cost. Right. Reduction of cost is never the focus. See, if there is an organization, maybe we are not allocating the cost in the right direction. Maybe we are spending so much on a particular advertisement which is not actually fetching us any result. Right. So when I talk about management accounting, it is not just basic accounting, but accounting in such a manner that helps the management to take better decisions. How this accounting is going to be done. So the accounting system which will be such that it is generating a lot of reports. It is making available the data to take better decisions, right? So that type of accounting system is needed. That type of accounting is going to be done. Right. So cost management is related to planning and control of cost and not just cost reduction. Right. And when I talk about management accounting is basically consisting of these three elements, which is problem solving, scorekeeping, and attention directing. So it works on the problem solving. How does it do that? By preparing financial reports, by preparing a lot of MIS, right? It is providing useful information basically. And scorekeeping is keeping all the records, and keeping the records of all the actions which have been taken by the manager. Supposedly manager has taken a particular action, so what is the result of this action? So scorekeeping. And attention directing in a sense that maybe there is one unit which is being incurring into heavy losses, so drawing attention as to why this unit is incurring losses and why are we continuing this. Maybe there is some raw material which needs to be procured from a different vendor because this particular vendor is charging very much a very high amount, right? So that is attention directing. Okay, now value chain. See, when I talk about management accounting system actually ensures and it takes care of the needs of the managers. See, managers have to take a lot of decisions. Management accounting is what? Accounting in such a manner that it's helping the management to take decisions. Managements have to take decisions throughout the value chain. Value chain means what? Value chain is different from supply chain. Supply chain is like procuring raw material to providing finished goods, the entire process. But when I say value chain includes a lot other things also, right? It includes a lot of other things also, maybe research, maybe design, maybe after sales service, everything, because value chain is everything which is adding value to the products or services. Okay, so the managers need to take decisions throughout value chain. Maybe they need to see, where should I spend my amount on research, right? Is it providing the results that we expected, right? After sales service, what is the customer satisfaction? So there are a lot of things that they need to do. So basically, whenever you are designing your management accounting system, you have to take care that managers need is met. And in that, you focus on customer focus, key success factors, continuous improvement, value chain and supply chain analysis. Again, value chain and supply chain analysis, there could be an MCQ. That value chain analysis was first promoted by Michael Porter. Right now, customer focus, the ultimate aim is customer satisfaction. Key success factors, what do you think is needed for a business to grow? Ma'am, we need cost, we need quality, we need time, right? We need innovation. Continuous improvement, we also incorporate the concept of Kaizen costing over here. I've explained you in the class. And thereafter, we have value chain and supply chain analysis. So we get to know that at which point of time there is a problem, identifying weak points by analyzing and thereafter working on them and increasing the profit margins. Okay. Then we have mission statement of the institute. The institute expects all its members to maintain a professional ethical conduct. So all the practitioners are expected to maintain independence, not to express opinion without first assessing your relationship with the client and establishing that independence, right? Disclosing all the material facts known, maintaining confidentiality at all times, informing about business connections to your client or your employer, what other business connections you have. They may be conflicting, right? And not to receive any remuneration without the knowledge or consent of the client, right? Take all the steps to, yes, clear the scope and estimate cost pre-hand, right? So take all the steps to have a clear understanding that this is what I intend to work and this is what I'm going to charge. So the client should be aware of the cost pre-hand, right? With the other members also, you should always behave with courtesy. You're not going to accept any engagement to review the work of another member without his knowledge, right? You're not going to pay any commission to secure work. You're not going to act maliciously. You're going to maintain competency standards at all times. Maybe you're not updated with anything, so attend the seminars, update your knowledge, but you're not going to let the standard get low, right? And you're going to accept only that work which you believe you're competent to do, right? So you're not going to accept anything which comes and then you're not able to deliver the same. Okay. Next, we have primary norms of business ethics. Primary norms of business ethics. See, basically, I have told you in the class also that what do you expect your future husband to be like? He should be loyal, he should be giving you that respect, trust, responsibility, somebody who takes up the responsibility, somebody who's fair, right? So, in the same manner, responsibility means personal, corporate, community, and environmental responsibility, right? Somebody who is loyal, that means employees. We are basically here talking about that if you are an employee or if you are doing any business, then how your business ethics should be, what should be the primary or the basic requirement of your business ethics. So you should be loyal. That means You should be, if you're an employee, you should be loyal to the company, you should be loyal to the managers, you should be loyal to your co-workers, right? It doesn't mean that you cannot go ahead and leave the company and switch. Of course you can do that, but there should be a proper procedure to do that, right? When you're talking about respect, you should show respect towards your clients, towards your customers, towards your employees, everyone, right? There should be trust. Undoubtedly, trust comes with transparency and reliability. So the more you don't try to hide things, you're open, you are transparent, the more it is that the clients and the customers will trust you. So it should be trustworthiness. Fairness. Now fairness means you're not making any discrimination. Maybe you are a manager and then you have to give a promotion, or you have to recommend a promotion, but just because somebody is your friend, you're recommending his promotion, that means you're not fair, and this is not the business ethics which you should display at work, right? You should be able to pick up the responsibility. Like if you're an employee, whatever task is allocated to you, you should be able to do that job. That's personal responsibility. Then maybe if you're working in an organization, somebody walks in to maintain the decorum, right, to help that particular person, that's corporate responsibility. And then we have community and environmental responsibility. That is, you should always try to promote a safe and healthy environment, work for the community also, right? And try to reduce the industrial waste and everything. Okay. Next, we have internal code of ethics. I already told you there is a difference between business ethics and code of ethics. Code of ethics is that set of guiding principles which an employee is expected to adhere to. So every company will have their own internal code of ethics, and it's very important, right? And it basically focuses that everyone should maintain integrity, objectivity, they should be competent, they should maintain confidentiality and display professional behavior. However, we have one example, and that example is for CFA members. So CFA website displays this particular example, that all the candidates and the members of CFA must adhere to the following code of ethics. What is it? That you must act with integrity, competence, diligence. You should place interest of client above your personal interest. There should be reasonable care and independent professional judgment. In investment, you should always practice professionally and ethically. You should promote integrity and maintain and improve professional competence. Okay, very simple. Next, we move to ethics in business dealings. Now, in this unit 8, we have a lot of content to read. We talk about business ethics. Now, I told you business ethics is different from code of ethics, right? So, business ethics basically is those unwritten code of principles that are governing our decisions at work within a company, right? Business ethics is an art as well as a science, right? Art of maintaining relationship, harmonious relationship with the society, and at the same time, science also, because what you give comes back to you, right? So every action has an equal and opposite reaction, right? So all of that, law of attraction, everything you have read. So it's basically science as well as an art, right? So business ethics deal with morality in the business. What we have to read is first the features of business ethics. First is code of conduct. Of course, it tells us what is right, what is wrong, what should be done, what should not be done. Second is protection to social group, right? The employees feel safe. Third is basic framework. It tells us how do you act in different situations. Fourth is acceptance, because everyone is different and they have different viewpoints and perspective, right? Then is education and guidance. And then it is not against profit motives. Of course, ethics and profit can go hand in hand. In fact, if you follow ethical practices at work, you can even lead to better profits. Then we talk about the principles. There are broadly 7 principles in business ethics, that is trustful, open mind, meet obligations, have clear documents, become community involved, and maintain accounting control, and be respectful, right? Then we have certain areas, or you can say the three broad areas in business ethics is corporate social responsibility, fiduciary responsibility to stakeholders, and industrial espionage. Right? Espionage is basically that illegal practice of investigating your competitors. So that should not be done, right? You have a responsibility towards society. You have a responsibility or a sense of trust towards your employees, towards your customers, towards every stakeholder. So these are the three broad areas where ethics need to be maintained for growth in business, right? Now there are many emerging issues. What are the emerging issues? First of all, we see ethics, the general business ethics that we have. We see ethics of human resource management, ethics of sales and marketing, right? Like employees should get fair wages, they should get fair promotion opportunities, etc., etc. Then we have ethics of sales and marketing, that whenever you're marketing your product, you should not use unethical practices to do that, right? Maybe it is going to give a boost or a kick to sales at on a temporary level, but in the long run it will be a disaster, right? Production, always there should be ethical practices. You should maintain high standards of health, and like you should if you are manufacturing a particular drink, the water which you're using should be checked properly, that it's not causing any health hazard to anyone. Likewise, and knowledge and skill, right? Ethics of IPR, ethics of knowledge. Like maybe if you want to write a book, you shouldn't go ahead and copy a particular book. That is, you are doing that infringement of copyright, which is going to lead a very bad image, right? Even if your book is super hit, it's going to turn the reputation. Now we have common unethical practices which you will find. The first one is corruption. Of course, at work, you will see a lot of corruption. There will be greed of profit. There will be accommodating a group of employees, vendors, etc. Um, Now, this prima facie might look ethical, but when you are at work and you're like being too friendly and too nice to everyone, then your work compromises. Everywhere you're just making groups, right? Then leak of knowledge, lack of knowledge, leak of professionalism, lack of professionalism it should be actually. Then you have this external pressure and ego. So these are the common unethical practices that you will find at work. Now, then we have importance of business ethics. So, how important business ethics are. Now, when you read the topic of importance of business ethics and thereafter you read the topic of need for business ethics, they both prima facie look like the same. Although need for business ethics is more important from examination perspective. What is the importance of business ethics? The public expectation. First of all, public always expect you to deliver high ethical values, right? Then business ethics encourage people to not provide or to prevent any harm to the society. It protects you from abuse by unethical employees. It protects the individuals, the employees who are at work. It improves the consumer confidence, right? You become conscious and aware of your social responsibility. It helps you develop a good reputation and image, right? Your goodwill increases. You will have better profitability, right? You're safe from legal perspectives. Why? Because if you have a good image, there won't be any legal cases and suits files against you. Okay, then we have like need of business ethics. Why do we need business ethics? First is to stop business malpractices. Almost every businessman engages themselves in some unfair trade practices. Unfair trade practices like what? Somebody is selling the goods at 100, then you may be selling the same product at 50, but you have terribly reduced the quality, and or maybe you are cheating in weights, you're cheating in measures. I asked you to give me 1 kg, you have actually provided me that 900 grams, right? So all these are malpractices which are happening in business. But when you have ethics, these practices get stopped. That improves customers confidence, because they are sure that this particular business house is ethical and they will not be cheating about the quantity, quality, price, etc. Right? So you can trust it. That type of business only survives. So survival of business. So if you want short term success, you can go ahead and indulge in those malpractices, but if you think about long term success, then for survival of business, ethics is needed. Okay, it safeguards consumers' right. Now consumer has a lot of rights, like they have a right to safety. If you don't have ethics, then you might be giving the customers any bullshit to eat, anything, right? Any crap. Now that's affecting their health largely, and they have a right to health, right? They have a right to health and safety, but just because you are not ethical enough, you're compromising on that. So if you're ethical, then it's going to safeguard the human's right also, the consumer's right also. It protects the employees and the shareholders, because you think about everyone. It develops good relations, not just with the customers, but also with the employees, also with the society, also with the competitors. There is smooth functioning, right? It helps you develop a good image. There is smooth functioning because everyone would want to work, and they will give full cooperation. The employees will give full cooperation, right? So it will boost the productivity, and there will always be smooth functioning, right? Then consumer movement. Now consumer also know their rights. They know that they have a consumer forum platform, right? They have social media platform in today's date, where they can actually um, uh, uh, expose the business houses which are indulged in malpractices or bad business practices. So the only way, if you want to survive, is to be ethical in today's time, right? It leads to consumer satisfaction also. So undoubtedly, if the consumer is satisfied, there will be mouth to mouth publicity, and there will be increase in profits, right? Importance of labor. If you provide your employees and laborers the proper wages, and they feel valued, they have good health and working conditions at work, then they will work effectively. And it also leads to healthy competition. And we have read, you haven't read actually, but under Competition Act 2002, we know that competition, healthy competition, is a boon for the business houses as well as for the consumers. Okay, then we have advantages of business ethics. It gives you a competitive advantage. Like if somebody is unethical and you are ethical, you have a competitive advantage over that particular person. Your goodwill, your productivity is increased. There will be increase in market share. There will be a good publicity. You will have like mouth to mouth publicity, as I told you, right? So you're getting a free publicity. You don't need to spend lakhs on advertising or marketing, right? Everyone will accept the products. There will be an overall growth. The management change can be made easy, and of course, there will be value integration. The last topic in this particular unit that we read is improving ethical behavior in business. How to improve that? How to improve that? Because ethical decisions are influenced by individual ethics or individual beliefs or individual moral standards, right? So basically, we have to understand the individual moral standards, and we have to also see that who we are making as managers and what are their ethics, because there is a lot of influence of managers. And if they are getting an opportunity to engage in misconduct, probably they will. Like even at house, when we say that okay, we have hired a house help, and that house help is having a very great sense of ethics, so we trust her completely, right? But if you provide any particular person an opportunity to engage in misconduct, there are heavy chances that his ethical behavior might get shattered, right? So that should not be happening, right? You should be promoting the code of ethics, you should be explaining the policies, you should be developing the training programs and encouraging people to behave ethically, providing them incentives to behave ethically, rewarding them, right? Punishing them if they are not behaving ethically. Okay, so through this you can do that, right? So how to improve code training, rewards, punishment, this is how you can improve the ethical behavior in business, right? Okay. Now, the concept of emotional intelligence. Now, emotional intelligence is a concept which is highly underrated. We always talk about IQ, which is intelligent quotient, but we forget about EQ, which is emotional quotient. When IQ talks about skill, memory, reasoning, right, numericals, everything, the better memory, the better logical reasoning skills you have, that is the better IQ you have. But we forget about EQ, the better social skills, the better empathy, the better self control and emotions, the better understanding of feelings you have, the higher EQ you have. Is EQ important? The answer is yes. EQ is the ability to understand, use, and manage emotions in positive ways. Why? Because to communicate effectively and to reduce the stress. EQ is basically having four attributes. The first one is self awareness. You should be able to recognize your own emotions. You should be able to know your own strength. You should be able to know your own weakness. The second is the ability to manage it, right? So, self management. Now, maybe you know that I get impulsive at this particular time. How do I control this, right? How do I behave in this particular manner? Because I am aware of my strengths and weaknesses. I have to control, I have to let it go, I have to manage it accordingly. The third is social awareness, being able to understand the emotions of others, okay, the concerns of other people. And the last one is relationship management. When you know your own self and you're able to manage your own emotions, you know others emotions, then you'll also able to develop very good relationships with other people, communicate clearly, right? Okay. Now, emotional intelligence is actually going to help you succeed in life because it affects your performance at school or work, it affects your physical health, it affects your mental health, it affects your relationships also. Your work will be highly affected if you're not able to maintain, or if you're not able to manage your emotions, because you may get impulsive. If your boss has said something to you, you cannot take that criticism, you burst out with anger, you tend to lose a job, right? So nowadays, even when the companies are hiring the candidates, they ask you to fill a particular form testing your EQ, that is your emotional intelligence, how intelligent you are emotionally, how well you are able to manage your own emotions, understand each other's emotions, and like be a team player, right? Then the second is physical health. If you're not able to manage your emotions, undoubtedly you'll have uncontrolled stress, which can lead to a lot of lifestyle diseases like maybe blood pressure, diabetes, etc., etc. And then it also affects your mental health. See, if you are able to understand your emotions, manage your emotions, understand others' emotions, and you maintain cordial relations with them, you will always have people to look for support, to lean on, right? But otherwise, if it is the opposite, then you will feel lonely, you'll feel isolated, and that will lead to a lot of health problems like depression, right, anxiety. Then it affects your relationships also, because you're not able to communicate effectively. So no matter, it may so happen that you have a very high IQ, you're somebody who's very intelligent but is not able to manage the emotions, will fail terribly at the relationships. Okay, so that is it. Hello, everyone, my dear CMA inter students. Today, we are going to revise the chapter of Factories Act 1948. This is going to be a comprehensive, detailed revision, yet in a concise and time bound manner. So, let's begin, right? And of course, this particular revision is in 100% English. So basically, what do you mean by Factories Act? What is it concerned of? It is regarding, or you can simply call it a social legislation, right, which regulates certain working conditions in factories. Social legislation, so definitely for the betterment of society. There are a lot of workers who turn up and come and work in the factories, but are they being provided the basic necessities that they need? Is their health being taken care of? Right, do they have safety measures? Because there are many accidents which actually happen in this factory, because there are machines, right? There might not be proper fences around the machinery, right? So in order to take care of all of that, and keeping in mind that there are a lot of young persons also who are employed in the factories which need extra or special care, because they are not somebody who is adult and can take care of its own, right? So keeping in mind all of this particular Factories Act came into picture to actually provide us health, safety and welfare measures, right? So we have to, in our syllabus, basically read these three. What are the health measures, what are the safety measures, what are the welfare measures. Apart from that, we have a lot more to deal with, right? But they're small topics. Basically, this is what we are dealing with. Apart from that, we have young persons, we have women employment, right? We have their wages, their leave, right? So all of that. Now, this particular act is applicable to throughout India, right? That means no matter in which part of the nation you open a factory, what is factory, we are going to read what is factory in terms of the act, right? So but if at all you're opening a factory, then this particular act is going to be applicable on it, and you have to abide by all the rules, all the laws which are contained in this act, right? So it extends to whole of India. It came into effect on 1st April 1949. It ensures health, safety and welfare of workers, and is also applicable to factories of central government or state government. So it is not like that it is not going to be applicable to any government entity, because usually we have a lot of laws which are applicable to public in general, but it does not apply to anything which government is doing. So here it is not the case. The factories which belong to central or state governments, it is applicable equally to them also, right? We have certain important definitions which actually I'll be dealing with you at the end, because this is of course a revision class and you have some idea of the definition, so we'll be dealing it at the end. But before we actually begin and start the core provisions, there are three definitions which I want you to know. Three, or basically I would say four definitions which I want you to know. What are the category of people that we read in this particular chapter? One is adult. Who is an adult? Who has completed his 18th year of age. Who has completed his 18th year of age. That person is an adult. Then the second category of person is a young person. Who is a young person? Young person could be an adolescent, could be a child. Okay. So adult or young person. Young person is further classified into two. It could be a child, it could be an adolescent. What is a child? Child is usually, we have a preconceived idea that child is somebody who is under the age of 14 years. No, my dear. Child is somebody who has not completed his 15th year of age. That means he could be 14 years also, he is a child. He could be 13, he could be likewise, right? So he is a child. Now, when we come to adolescent, adolescent is somebody who has completed his 15th year of age but has not completed his 18th year, right? So in between child and adult, there is an adolescent, and both adolescent and child are called as young persons. Fine. So I hope this is clear. Before we actually proceed, we needed to know this. Okay. So occupier, factory. Yeah. One definition that I'll be telling you before is factory. What is, because this is what you're actually reading. So what is a factories? Under Factories Act, what is being called as a factory? Now, factory is any premises including precincts. See, when I'm talking about premises or when I'm talking about precincts, premises is basically that building. Right? It could be a building, it could be an open land, and precincts is something which is like you enter, there is an enclosed space like that, right? Which is enclosed by the walls. So that is precincts, right? So any premises including precincts. There may be precincts in the factory, there may not be precincts, right? So that is going to be treated as factory if there are 10 or more workers who work in that particular factory. We'll talk one by one, right? So 10 or more workers. Now this 10 or more workers, we're talking with the aid of power. With the aid of power means what? See, we have two types of processes, with the aid of power or without the aid of power, right? Without the aid of power, that means you don't need any electricity for your machines, like we do something manually, right? So that is something which is without the aid of power. That doesn't mean that you don't have a ceiling fan over there, no, but you're not using power in the manufacturing process. That is what is intended, right? So without the aid of power, you need to have 20 or more workers who are employed. With the aid of powers, you need to have 10 or more workers who are employed. Now, We don't check at a particular date, okay, that at 31st March 2024, we are going to check whether we have 20% employed or 10% employed. If this was the case, every factory owner, what they'll do is, we don't want Factories Act to be applicable to us, so we don't want this to be considered as a factory. So what we'll do is, we'll employ a lot of people, but just before the year ends, we will retrench them. We'll say they are not on our payroll. So this does not matter. If they have worked on any day of the previous 12 months. So if during entire year, that is 365 days, if on any day there were 10 or more workers with the aid of power or 20 or more workers without the aid of power, then that is going to be called as a factory. Right? But then they should be in any part of which manufacturing is carried out. The question is, what do we mean by manufacturing? See, manufacturing could be making or altering of something, or you're packing, or you're washing, you're cleaning, you are demolishing, right? You are finishing, you're oiling, you're pumping oil, water, sewage, right? Whatever it is, you're generating power, you are doing printing, you are constructing, right? Or you're preserving something in the cold storage. So that is also included in the definition of manufacturing. So the definition of manufacturing process is actually, I would say, exhaustive. See here, I think we'll have the, yes, here it is. See. So manufacturing process includes all of this. Ma'am, do we need to learn the definition of manufacturing process? It's not very commonly asked, but of course, when it is included in your syllabus, you should be knowing everything, right? Now, let's say I am talking about, there is a, let's say there is a factory or a place where somebody is stitching old bags. Right. So you have a lot of bags which are being stitched properly, decorated, and then being sold. Is it going to be considered as a factory? The answer is yes, ma'am. Why not? Yes, it will be considered as a factory. Okay. Or it will be considered rather as a manufacturing process. And because there may be 10 or more workers with the aid of power, then that is going to be considered as a factory. Right? But let's say I have opened an institute wherein the students come and I am imparting them education. So maybe a lot of people put in their advertisements that we are producing CMA. So are you actually, is it the manufacturing process which is being carried out? The answer is no. Right? So you have to understand what is manufacturing process which is being carried out, and according to that, this is the definition of factory, right? Other definitions we are going to deal with later. Okay, so we will actually begin with the main content. Now, notice by occupier. What is occupier? That you basically know somebody who has the ultimate control of the factory. In detail, we are going to learn it later, right? Now, whenever you are setting up a factory, whenever you are starting a factory, how will somebody get to know that, okay, this is the factory that you have opened? Because there are many illegal factories also which are being run in the nation. Right. So there are a lot of people who actually open a factory, some manufacturing process is going on, but they haven't reported their factory. Right. So if the inspector actually comes and inspects that area and finds that, okay, this is a factory and you're not complying with the factory laws, then they'll seize your factory, they'll put in penalties and adequate punishment will be given. So whenever you are actually opening a factory, occupying a factory, right, you know what is the definition of factory. So whenever you're doing that, 15 days before occupying a factory, you actually have to send a written notice. Okay, written notice which will contain the name, address of factory, occupier, and what is the manufacturing process that you're carrying, right? This you are supposed to send it to the chief inspector, right? And also whenever there is a change in the manager, then whenever you appoint new manager, you have to send the notice of appointing new manager also to the chief inspector, right? So this is a very short section which you have to read, but this is being asked when we are talking about multiple choice questions. Okay, so it is not very frequently asked because it's a section 7 very small section. Then we also have section 7A, which actually talks about the duties of occupier. So occupier duty is very simple, and it's not something which we read and elaborate. It is simply that it is the duty of occupier to actually ensure that the health, safety, and welfare of all workers is intact. So whenever they are coming to work, the safety has to be ensured by the occupier. It is the duty of the occupier to ensure that all the workers are safe in the factory. Their health is not compromised. They have been given adequate welfare measures, at least the basic ones which are prescribed in the factory. So Factories Act actually tells us this is the minimum that you must provide. The factories should actually provide more than that, right? Okay. Then we have section 8, which talks about appointment of inspector, and we have section 9, which actually prescribes the powers of inspector. Powers of inspector is one such question which is often asked in examination. Now, what is appointment? State government can appoint persons with the prescribed qualifications to become the inspectors. Okay, and they may also assign them the limits. Okay, see, practically, if I tell you we have chief inspectors, we have a lot of authorities, and practically the DM of the area is involved over here. Okay, so let's say whatever is the prescribed qualification, because we don't have to get into that detail, whatever is the prescribed qualification, accordingly, state government will appoint them as the inspectors, that you are the inspectors and this is the jurisdiction limit which has been given to you. This is the local limit within which you have to ensure, you have to get to know that what are the factories, how many factories are there, are they following the are they following the laws or not, right? If not, go inspect them, right? And thereafter report, impose penalty and like things. What are the powers of inspector? They can enter into any place. Like if you go to areas like there are many industrial areas in Delhi, if you ask me. And I have seen it personally that even in residential areas, I cannot recall exactly the name of that particular area, but in that area, it is a residential area. But almost under every house, what they're doing is the ground floor or the first floor, there's some manufacturing processes going on, wherein even if it is without the aid of power, let's say without the aid of power, there are 25, 30 people who are working. So that is a factory, right? That is a factory, but it has not been reported anywhere that I have opened a factory or they're not following any laws. So now if I am the inspector and I suspect that particular place to be used as a factory, I have the power under section 9 to enter into that place. I can examine the premises, that what are you using, which machinery are you using, which substance are you using, because even if you have reported it to be a factory, you may be using some hazardous substance, but you're not taking adequate care for that, right? So if there is any accident which has happened, the inspector has the power to inquire into that accident, right? Procure any document as they need to, right? They can seize any register. There are a lot of registers which are mandatory that you have to maintain. There might be some registers which they maintain just like that, right? So inspector has the power to seize it. They can also take any substance or article, like supposedly you are emitting out some hazardous substances, right? Or there is some disposal of waste, right? You consider it to be no, it is completely harmless for the health. So I can take a sample and get it tested, right? What could be the probable health hazard, right? And I can exercise, if I am the inspector, of course, I can exercise as whatever powers as prescribed. Okay. So this is in general. Now we come to the next type of authority that we read under this act, which is actually certified surgeons. Again, state government can appoint certain medical practitioners to be the certifying surgeons under the Factories Act within a particular local limit, right? Now they are what? They are medical practitioners. So what do they actually do? They have different duties. Number first, they examine and certify young persons. First thing you have to understand that child is actually prohibited to work in a factory, but child also has a different category, like somebody who has attained the age of, or who has completed the age of 14 years still a child till he completes the age of 15 years, but he is allowed to work in the factory. Child who is under the age of 14 years is not allowed to work in the factory. Now, when we are talking about the adolescent, that means somebody who has completed the age of 15 but has not completed the age of 18, right? So he's an adolescent. Can he work in the factory? The answer is yes, he can work in the factory, provided he obtains a certificate from certified surgeons. So he has to obtain a certificate that yes, I am medically fit to work in a factory. So you have to go to a certified surgeon, they'll examine you and provide you the certificate. So that is the duty of certified surgeon, to examine and certify the young persons, right? Moreover, you have other duties also. What other duties? You have to examine the person engaged in factories in dangerous process. See, anyone who is day and night exposed to some harmful gases that is being emitted in that is being inserted, or whatever it is, you're inhaling that particular gas which might be harmful for the health and body, right? So that particular persons or those workers should be examined every 3 months or every 6 months, that there are no side effects that are actually taking place. They should be provided adequate safety measures, medicines, whatever needed, right? So you're doing that. The third one is you are exercising medical supervision. In case of illness doesn't mean that you went out for a holiday, or some workers went to enjoy, or they went to a temple, or they went to some fete, and there they have had some ice creams and their throat got ill, right? So they have a sore throat, they got cold, right? So that illness is not to be examined by medical supervision over here by the certified surgeon. For that you have ESI, right? So we read these things under that, right? Here what we are discussing, if there is any illness which has come because of the work that you're doing, right? Or maybe there is an injury which might be suspected because the manufacturing process has changed, or you have started to use some new substance, or maybe there are young persons who are actually, it is not allowed to employ these young persons in some dangerous process, right? We have to take extra care of the young persons, but if at all they are employed in a work which might cause harm to their health, then there also you need to exercise medical supervision. Okay, clear? Fine. Then we come to the health measures. Health, which is covered in chapter 3 of the Act. So it talks about cleanliness, disposal of waste, ventilation, artificial humidification, overcrowding, lighting, dust, drinking water. So there are a lot of, and we'll read them section by section, right? What is it talking about? Health measures. Health measures means what? To take care of the health aspect of all the workers. So the very first one. Section 11, cleanliness. Now, every factory should be kept clean, free from effluvia. Effluvia is some kind of foul smell which comes because of some substance or the dust, right? So it has to be free from all that terrible odor which might be coming, right? Any drain, any other nuisance, whatever it is, it has to be kept absolutely clean. Okay, so this is something which is given in general. Now we have something which is, for which timelines have been given. That if there is dust on the floor, do you think it should be cleaned every day? Of course, ma'am. So there has to be no dust, no accumulated dirt on the floor, on the benches, on the staircase, on the passages, everywhere. So clean that dirt every day and dispose it off, right? Now, if we are talking about the floor, it has to be cleaned with disinfectant every week. So once in every week, you wash it with disinfectant, like we have Lysol or any other type of disinfectant that you might be using, right? Just to destroy the germs, because every day that might not be possible. Every day you must clean the floors, of course, but with disinfectant at least once in every week, right? Next we have, there has to be drainage. That is something that you all know. Now, the interiors, the walls, the roofs, there has to be whitewash at least once in a period of 14 months. Okay. Then if the surface has been painted or varnished, then it has to be repaired or re-varnished once in every 5 years. If it is washable, see, if it cannot be washed, then once in every 5 years you will repaint it, right? If it is washable, then once in every 6 months you will actually wash it. Wherever whitewash can be done, then of course whitewash has to be done within a span of 14 months. Okay. Then if there is smooth impervious surface, then it has to be cleaned within every period of 14 months. And all the doors, windows, they have to be painted or they have to be varnished once in every 5 years. So ma'am, do we need to remember all these dates? 100%, 200% you have to remember, because this is a very common question which is often asked in examination. So you cannot compromise with it, right? The next section that we have, section 12. In fact, this was the question which this was the section which was actually the biggest one. Other health measures sections are very small. Section 12 talks about disposal of waste and effluents, right? So whatever waste is being generated by the factory, that has to be disposed of. So what measures have you taken for the disposal, right? So there has to be effective arrangement for the same. Next is section 13, which talks about ventilation and temperature. Now there are two things in this. Ventilation, every factory room has to be properly ventilated. Why properly ventilated? Because factories are one such place that they need ample of windows, ample of doors for some fresh air to be circulated. Otherwise there will be like a lot of suffocation. Secondly, when we talk about temperature, see, factory is a place where where manufacturing process is being carried out. So if manufacturing process is being carried out, like if I talk about cold storage, there is a very low temperature that needs to be maintained, right? There might be cases when you need very high temperature to be maintained, right? And the workers will need to go in there. So it is providing them a lot of discomfort, right? So if they have to work in excessively high or low temperatures, then you have to adequately insulate other parts, right? Or provide them a space, right? Separate their process, that okay, they're not having the lunch in that place only, otherwise lunchroom has to be there, but you have to separate their processes, like okay, they go in there for about half an hour and then they come out, they can rest over here, right? So that has to be done. The next one is section 14, which talks about dust. So there could be a lot of dust, because if you all know that let's supposedly we have some carpenter at our home and he's working. Now every time he cuts a particular wooden piece, there will be a lot of different type of dust which comes, and it's extremely harmful also, right? There are certain plies for which the dust is extreme, right? So this is somehow injurious because they are inhaling that only. So if there is dust, it should not be accumulated in the room, right? Because if it is accumulated in the room, there will be obvious inhalation, more inhalation. So if there is dust which is being generated, there should be adequate exhaust which is actually taking them out or cleaning, whatever has to be done. It depends upon the process to process. The next one is section 15. We have heard a lot about humidifier. What is humidifier? Air actually loses its moisture. And that's why even if when AC is switched on and there is no humidifier around, what happens? We start to feel a little choked. Why? Because it's all dry. There is no moisture in the air, right? So that has to be adjusted. So if the humidity of the air is increased, right? State government has the power to in fact prescribe the standards of humidification, right? And what methods you should adopt to increase the humidity, right? And how you determine the quality. So you have to follow that. Next is section 16, which talks about overcrowding. Here, one question or one thing that you must remember is 14.2 cubic meters of space. This is often asked as MCQ, right? Or as an objective question. In every workroom in a factory, at least 14.2 cubic meter of space for every worker must be there, right? So you cannot do so that, like that, okay, I have this much space, let me employ 20 people to sit here. No, they cannot, right? So you have to have this adequate, this is the minimum space which must be provided per worker. Then we have section 17, which talks about lighting. Every part of the factory has to be properly lighted, right? There could be lights coming from the windows, right? And there shouldn't be any obstruction for the light, and that's it, right? There is one more thing when we talk about flashlights, right, or reflection. So it should not so happen that it's causing some eye strain or there is a risk of accident to any worker. Like if there is a window which when sunlight is being through that particular window, there is some kind of eye strain which is being generated. When we were very young or when we were very small as kids, we used to do this a lot, right? Supposedly we have any shiny surface, like if we have a mobile phone, we would actually like to do this, and there would be some light flashing or coming to your eye which is causing some kind of strain. No, don't do that, right? So this should not happen, because there is very high risk for the workers to be prone to an accident also, because if suddenly they are doing something and this light comes, right, so their hand could be hurt, right? So this should be absolutely clean. There should be proper lighting. There could be glazed windows, right? And the light should be clean from obstruction. Plus, whatever shadow is being formed or a reflection is being generated, it has to be ensured that there shouldn't be an eye strain or risk of accident. Next is drinking water. Drinking water is what? Of course, you have to provide drinking water. Normal drinking water, yes ma'am. Normal drinking water, it has to be at least 6 meters away from the washing place or urinals or spittoons, whatever is there, right? But there is one more thing. If there are more than 250 workers in a factory, then you also have to provide the facility of cool drinking water. So, during hot weather, of course, there is no one who during chilly winters they are going to demand for cool drinking water. No, but during hot weather you have to provide them. Then comes your latrines and urinals. Now this is something which is a basic necessity and has to be provided, right? What you have to ensure over here, that it has to be a separate facility for both your female and male workers. They have to be lighted properly, ventilated, clean, very important, right? So it is very important. There has to be proper sweepers who are going to be employed. And if the workers are more than 250, it has to be washed once in 7 days, right? Now, this particular cleaning, many students think that, okay, if there are less than 250 workers, then I don't have to keep it clean. No, the cleaning has to be done. Of course, every day there has to be cleaning. But here I'm talking, if there are more than 250 workers, then it has to be cleaned with suitable disinfectants or detergents, whatever you call, at least once in 7 days, right? Then we have section 20, which is spittoons. Spittoons is something which is very much needed, right? In India especially, because mostly workers have this tendency of consuming tobacco in some form, right? So every factory should have sufficient number of spittoons at convenient places, and they should also be kept clean. Then we have safety measures. Now, we are not supposed to read the safety measures in detail. Okay, however, we'll just go through the safety measures. Chapter 4 provides us for the safety measures. The first one is fencing of machinery. So there are a lot of machinery which are actually moving, which are in use, in motion, and if you go near them, you could actually hurt yourself. So there should be properly fenced, right? The next one is employment of young people on dangerous machines. Although we have a section number 23, which clearly says that young worker will not be allowed to work in any machine which is actually dangerous, right? And if at all they have to, they should have, or anyone who is appointed should have received sufficient training for the same. Then we have floors. Basically, if I say that, okay, there are different floors in a particular factory, there will be staircase, there will be passages, so they should be kept clean. And it should not happen that if I am walking, I am slipping, right? So it should be, that should be taken care of, right? Because somebody might slip on the stairs. They should be of good construction quality also, right? Strong. There has to be safety officers. Safety officers are not required in every type of factory. Safety officers are needed where 1000 or more workers are generally employed, right? The building has to be maintained. Wherever inspector feels that, oh, the building is in such a condition that it may demolish, right? It may fall down, right? Or it could lead to a condition where health of the workers is being compromised, right? So they will ask for repair, right? So safety of buildings or safety of machinery is also very important. The machinery should also be in a good working condition, right? If there are any defective parts, they have to be replaced, they have to be repaired. There should be proper precaution or measures which can be taken if there is an outbreak of fire, right? So because fire is something which spreads very quickly, so what are the safe means for escape? What do you have? Proper fire extinguishing equipments which should be installed in the factory or not, right? So that is also something which is needed. Then we have explosive or inflammable gas, right? So a lot of dust or fume may be generated. So what are the measures to prevent any explosion from them, right? How are they going to escape from that, right? You have to protect your eyes. Eyes protection is very important. So for that, you can wear some suitable glasses or whatever. You have to consult the medical practitioner, of course. And if there is excessive light, then also you have a very high risk on your eyes, right? So you have to take care of that also. Then excessive weights should not be lifted by people, right? So state government can also prescribe rules that this is the maximum weight which may be lifted by men, by women, by adolescents, right, who are employed in the factories. Okay. And there should not be openings in the floors, right? Like there are pits on the ground, right? Because if somebody is carrying a lot of weight and walking in there, and there is a huge opening somewhere in the floor, he might fall down, he might hurt himself, right? So there are all these safety measures which needs to be taken care of. Fine. Okay. Then we have chapter 4A, which actually talks about the hazardous process. But before we go on to that, we have something called as site appraisal committee. What is site appraisal committee? Or let me get to this. Okay, no problem. We'll do this first. Let's go by the sequence only. Otherwise, you might be confused, right? So what is actually site appraisal committee? Again, central government has the power to constitute, state government has the power to constitute site appraisal committee, right? So what actually they do? If you want to open a particular factory, you have finalized this particular location, and this involves some hazardous process. That means if you put up a factory over there, it is going to emit out some gases which might not be good for the environment, or it is involving some hazardous process, right? So state government has the power to appoint a site appraisal committee, which will consist of the chief inspector of the state, of course, who is going to be the chairman, and there will be other people, right? Now what they will do is, whenever an application for establishment of factory which involves hazardous process comes, they will examine it. So site appraisal committee is going to examine the application for factory involving hazardous process. They can also call for more information, and they have to make recommendations to state government within a span of 90 days. Okay. And if the application is approved by central government, then you don't need any further approval from your central board. Okay. Fine. Here I can basically write if the application is approved by state government. That could be more appropriate. So if state government actually accords you approval, then you don't need to get approval from any state board, any central board, like we have under the Water Act, Prevention and Control of Pollution, right? Or we have the Air Act, because this is going to emit out or dispose of some gases in the environment, right? So we don't need that. We don't need any such further approval. Okay. Then duties of occupier, I've already told you in general what are the duties of occupier that we read over there. Occupier has to disclose info regarding danger and detailed policy of health and safety, draw emergency on-site disaster control plan, measures for handling or disposing hazardous process, right? So the occupier, this is not the duties of the occupier in general. The duties contained in section 41B actually talks of the occupier of any factory which involves hazardous process. So the disclosure is very much required, that what could be the probable health hazards and everything, right? So he has to lay down a detailed policy with respect to health and safety of the workers who are going to be employed. Fine. So there are more things in detail. Then when we come to 41C, here we talk about specific responsibility of the occupier when we are talking about hazardous substance. So what he has to do is he has to maintain health records, up-to-date health records of every employee, every worker. Okay, because they're exposed to harmful substances or toxic chemicals or whatever it be, right? Then we have section 41D, where we talk that, okay, central government has been conferred the power to appoint an inquiry committee. So if there is an extraordinary situation which happens in such a factory which involves hazardous process, CG has the power to appoint an inquiry committee that go and inquire into the health and safety of this particular factory. Are they observing this or not? And if any failure or any negligence is discovered, then they are going to be adequately punished, right? Likewise, we have section 41E, and this is about power of central government to prescribe emergency standards. Okay, so if CG is satisfied that we don't have any standards prescribed for this particular hazardous process, right, or the standards that they exist, they are not sufficient enough, then it can actually go ahead and prescribe more. Fine. Now, section 41F, so the maximum threshold limit for exposure of toxic substances or exposure of chemicals that is being given over here, right? Then we have section 41G. Section 41G talks about occupier to set up a safety committee with equal workers and management to promote cooperation. Because if I am into management, right? I come every day to the factory, I look at the workers, but still I will not be able to know the ground and the real problems that they're actually facing. And in turn, even if I'm genuinely concerned and want to do for the betterment of the workers, still I'll not be able to do unless they also participate and they let me know the ground problems that they're facing, right? So it is very important to have that worker participation in the safety management. So there should be a safety committee which is going to be formed, in which there will be management and also the workers, and they'll try to cooperate with each other and promote safety at work. Okay, then we have section 41H, wherein workers notify occupier about likelihood of danger and immediate action has to be taken. Like supposedly there is a machinery which suddenly starts to make some crackling sound. Now this shows that there might be some accident. So they're foreseeing an accident and they immediately reported it to the their occupier, and the occupier has to immediately take action, shut down the machinery, report it to the inspector and do that. Okay, fine. Then we have the welfare measures. Okay, I usually teach the welfare measures before, but since we had this way in the chart, so I have dealt it this way only. What are the welfare measures? We have section 42, which talks about the washing facilities. Washing facilities have to be kept clean, right? There should be suitable washing facilities for the workers, right? And for male and female, there should be separate washing facilities and it should be kept clean. That's it, right? Then we have section 43, which talks about storing and drying clothing. So if you have wet clothes, there should be proper place for drying them. There should be proper place for keeping the clothes which you're not wearing. So the workers usually, they come in their own clothes and then they change the dress of the factory. So where will they keep the clothes? Right, so there should be proper facility for storing and also the facility for drying clothes, because the uniform gets actually dirty. They have to clean it, they have to dry it, right? Then we have section 44, the facilities for sitting. The workers usually in the factories are working all day long in standing positions. So when they are not working, they should have suitable places for sitting also, because it affects the health of the workers. Then we have section 45, which talks about first aid, right? So at least one first aid box should be there for every 150 workers. So one box for every 150 workers, one thing, right? And it should have all the prescribed contents. It should be readily accessible and maintained at all times, right? Thereafter, if there are more than 500 workers employed in a factory, then there should be one ambulance room, and there should be an ambulance which should be available, and there should be nursing staff which is available at all times, because anytime some accident might happen. Okay. Section 46, which talks about canteens. If there are more than 250 workers, there has to be a facility of canteen which will be provided in the factory. And of course, there can be rules made for the canteens. The expenses of running is to be borne by the employer only. Okay. Then section 47, restrooms, shelters and lunchrooms. There has to be proper in every factory. If there are more than 150 workers, there have to be adequate arrangements for restrooms and lunchroom. Okay, and if it is a lunchroom, then of course it has to have drinking water also, right? So you all can take their meals over there and they can enjoy the meal. They have the drinking water over there, right? And it has to be kept clean. It has to be lighted, it has to be ventilated. So all these general things are there. Then comes your section number 48. Section 48 is all about crèche. Now, this is basically needed for more women workers, of course, because although men can also carry their babies to work, but this is not the case, right? So if in a factory there are more than 30 women workers, then you have to provide them a room which can be used by them, and it is for the children under the age of 6 years, right? So if there are more than 30 women workers, then you have to provide a crèche for them so that they can come with their babies and they can be kept over there. Right, they can be over there. It has to be properly lighted, ventilated, clean. There has to be an in charge, right? Then comes your section 49. Section 49 talks about welfare officers. If there are 500 or more workers, then occupier has to employ such number of welfare officers as may be prescribed. Okay, now state government has been given the power that you can go ahead and prescribe what are the duties of welfare officers and what are the qualifications of welfare officers and like things. Okay, so I hope this is clear. Fine. So we are done with the welfare measures. We are done with all section 41 that we have read. Now we come to chapter 6. Chapter 6 contains the working hours. Okay, so working hours of adult. First of all, we are talking adult working hours. Every adult is allowed to work only for 48 hours in any week. Okay, 48 hours in any week. He's supposed to get a weekly holiday also. Weekly holiday means the first day of the week shall be a holiday. Usually students have this misconception that the week starts from Monday. The answer is no. The first day of the week is Sunday. Okay, so the first day has to be the holiday. Holiday for the whole day in every week has to be there, and weekly holiday is usually the first day. If there is a factory which is open on Sunday and doesn't provide you a holiday on Sunday, in lieu of that, it is going to provide you a holiday, a full day off on any 3 days immediately before or after. That means Monday, Tuesday, Wednesday, or you can say Saturday, Friday, Thursday, whatever you may say. So on any other day apart from Sunday, right? So that is how it is going to be provided. Now there is one more thing. He's not supposed to work for more than 9 hours a day, including, or you can say 10.5 hours, including rest. No period of work is going to be more than of 5 hours, rest of at least 1 hour. That means at a stretch, you cannot go and work beyond a span of 5 hours. So these are all about duty hours of an adult. Holiday is something that I have already told you. But whenever you change the weekly holiday, it has to be notified to the workers and displayed. The notice has to be displayed in the factory. Fine? Okay. Just a second. Now, let's say there is a worker who actually worked for 48 hours and 10 minutes more, right, in a week. So, will it be violation? The answer is no, right? So, increase of 15 minutes or so should not be violative of this particular section as we're talking about, right? Now, when we come to holidays, is something that I have already told you, weekly holidays. How is it going to be working? And holiday means 24 consecutive hours beginning when your shift ends. It should not be that, okay, today your shift has ended at 3 p.m. and I say that, okay, now your today the rest of the day is holiday and tomorrow you have to come. No, it has to be, there has to be at least 24 hours, right, when your shift ends after that. Okay. Now we have something called as compensatory holidays. What are compensatory holidays? Supposedly there is a worker who has been called even on Sunday because there is a lot of workload, right? So he did not get any weekly holiday. Now he has to be allowed a comp off, that we say, right? So he has to get a compensatory holiday within 2 months immediately following that particular month, right? So supposedly he has let go of his 2 Sundays, so in the next 2 months he'll be getting a comp off. It could be any day that he wants to take, right? And he'll get that within next 2 months, right? In the same month also, or maybe within next 2 months also, he is allowed to do that. Okay, fine. Okay, now we have something called as overtime. I have already told you that the worker is allowed to work for maximum 9 hours in any day and for maximum 48 hours a week. This is something that we already know. Now, supposedly he works for 12 hours in a particular day, right? Because that is the demand of the work, and in lieu of that, he'll be allowed and he'll be getting that. But if he is working for more than 12 hours, this is the general shift that you can keep. But if he's working for beyond that particular period, he has to be entitled to overtime rate of wages. What is overtime rate of wages? Supposedly he gets 600 per hour. That's too much actually, or let's say 100 rupees per hour, right? That is what his basic wages is. So for the first 9 hours he'll be getting 100 per hour, but for the next 3 hours he'll be getting 200 per hour. So he will be entitled to overtime or wages at twice the rate. Fine. The adult worker, or when we talk about double employment, basically the adult worker is not entitled to work in 2 factories on the same day, right? Because there is a saturation of how much you can work, right? And of course, for child worker, double employment is again prohibited. It attracts penalty. We have section 99, which we probably read at the end, and it clearly says that if there is a child worker who works in any factory, he works in another factory, right? So the parent or the guardian, whoever is actually going to be punishable with a fine. If the parent says that I don't know where my child was, he has been lost throughout, then of course, if it was without the consent, then they'll not be penalized, but otherwise they will be penalized. Okay, fine. When we come to women employment, right? no woman is going to be allowed to work except between 6 a.m. to 7 p.m. Right? So this is the general tenure that we have for women, that this is the time which is authorized. Now, state government may authorize employment of women between 10 p.m. and 5 a.m. Right? So that is depends if there is the state which is safe, the state government provides that assurance, plus the work is of such demand that no, they have to work during that tenure only, right? So accordingly, it can be done. Fine. So we have section 66 where we talk about employment of women, which clearly says that you're not going to allow during that period. However, state government can authorize you. Right? Fine. Then comes your advance payment. Advance payment is what? Supposedly you are taking a leave for 4 days. Right? Now, if you're taking a leave for 4 days, you are entitled to get the payment of those 4 days in advance if you're an adult, and if you are a child, then you have to take at least 5 days leave to get this advance payment. That means if I am an adult worker working in a factory and I'm applying for a leave of only 2 days, I will not be entitled to advance payment. Fine. However, if I am taking the leave for at least 4 days, then I will be allowed to take that advance payment also. Clear? I think it's very simple. Now, because I'm talking about leave, we have a lot to talk about leave. There is chapter 8, which actually talks entirely about annual leave, which is granted with the workers. Fine. Okay. Child worker, as I've already told you, if you are a child, then you're not allowed to work unless you complete 14 years of age. Now, once you've completed your 14th year of age, you're still a child, but you can work in the factory, right? Till the time you don't complete 15th year of age, you will be called as a child only, but you're working in the factory. And because you're a young person, you have to obtain that certificate of fitness. Once you complete your 15th year of age, then from that tenure till you complete your 18th year of age, you are called an adolescent and still a young person and still require the certificate of fitness. The certificate of fitness has a validity of only 12 months. Okay, so you have to get it renewed. You have to apply for it again. Okay, it has a validity of only 12 months. So if you are a young person, that means you are a child under the age of 14 years is prohibited to work in a factory, right? And other than that, if you're a child or an adolescent, then you or your guardian will make an application with all the documents, which is going to be signed by the manager in which you're proposed to be appointed, right? And it will be sent to the certifying agent. He will certifying surgeon. He will examine you that are you fit enough to work or not, and thereafter grant you certificate, which is going to be valid for 12 months, and it may be revoked if you're no longer fit. Okay, fine, ma'am. Now, because we are talking about child worker is not allowed to work for more than 4.5 hours in any day and during night. Female child is not allowed to work between 8 a.m. to 7 p.m. And the work is limited to 2 shifts, not spread over 5 hours. Okay, 5 hours. The manager has to maintain a register. The register is not supposed to be maintained only for the child workers, but also for the adult workers. Child workers, you have to maintain a register wherein the name of the child, the nature of work, the group to which he is included, right? And the certificate of fitness, right? The number of certificate of fitness, every certificate has a number, right? So that has to be maintained in the register. If I talk about the register of adult workers, then that also has to be maintained, and there also there will be name, the nature of work that they're being given, group or relay to which they belong, right? And other particulars. All this is going to be maintained in the register of workers. Okay, now we come to leave. Annual leave, right? Every worker who has worked for 240 days or more in a factory in a calendar year. So starting from January to December, if you check that, okay, this is the worker who has worked for 240 days or more, he is entitled to leave. Leave like because wherever, no matter wherever in the corporates or in any company that you work, you are entitled to some leaves. You can get sick leave, right? ELP, there are a lot of leaves, right? So here also it is being given that you get a weekly off, that is different. You get the holidays which are off, right? Holi, Diwali, whatever it is there, that is different. Apart from that, you are entitled to annual leaves. Annual leaves like what? For every 20 days that you have worked, you'll get 1 day off leave, right? So supposedly you have worked for 40 days, so you are entitled to 2 days of leave. That's how it is being calculated. And for child, for every 15 days that you have worked, you get 1 day of leave. Okay. Now, when I'm computing this 240 days, I have to check that whether I have worked for 240 days in a factory or not. If the factory was not working, there was a day of layoff, it doesn't matter. I was not at mistake, so that will be counted in my 240 days, right? If I am a female worker and I am on maternity leave, then up to 12 weeks, it was not going to be it is going to be counted in that 240 days, right? So these are all deemed working days, the leave which I have earned in my prior year. Supposedly in my prior year, I earned a leave of 20 days, and this I have used in this particular year, right? So is it non-working day for me? No, it is going to be included in that 240 days for calculating this particular year, right? So if I don't take this leave, I can carry it forward to the succeeding year. Maximum 30 days in case of an adult and maximum 40 days in case of child, that can be carried forward, right? How do we apply for taking leaves? We have to apply to the manager to avail leave, and we have to apply at least 15 days before. If we are working in a factory which involves public utility service, that does not have to stop. So in that case, we have to apply at least 30 days before. Fine. So we will make an application and they will actually grant us leave, and we are also entitled to advance payment if we take at least 4 or 5 days leave, whatever the case be. Okay. Then we have something called as encashment of leave. Okay. So first thing was what leave we'll get. The second thing is carry forward of leave. So that also we have done. The third one is availing of leave. How do you avail the leave? So you have to make an application to manager at least 15 days before, right? Then you have advance payment. That is also something that I've already told you. Then you have encashment of leave. What is encashment of leave? Supposedly the worker is dismissed. Okay, now no more you're required. He's discharged or dismissed, or he leaves or he dies, whatever it be, right? So he will get amount in lieu of his leave, right? So immediately before termination, if you are entitled to 30 days of leave, then you can encash this leave. Okay, you can encash this leave and you will get it. The payment is going to be made before expiry of second working day of discharge, or in case of death within 2 months from superannuation or death, whatever the case be. Okay, fine. Now this what is the wage that you'll be getting? Supposedly you're taking leave, but what is the wage that you'll be getting? Whatever you were earning full time, the same you'll be getting during leave also. Okay. So I hope this is clear. Apart from that, we have penalty, enhanced penalty, that is supposed to be revised by you all, right? So penalties you are going to revise on your own. Now we have certain definitions that we didn't do, so we will go back to the definitions, right? And we will quickly revise them. Yes, here we are to the definitions part. Right, there are few definitions that I already told you, but there are few important definitions. In the charts we have covered the important definitions only, so these important definitions will be discussing. The very first one is competent person. What is competent person? Who is a competent person? Competent person is again somebody who is recognized by the chief inspector. Now, he may be an individual, he may be an institution also. How do you recognize a competent person? There are a lot of things that are needed in case of a factory, supposedly there is a factory, we need to check, is the building appropriate or not, is it going to demolish, are the conditions okay? So we need to have a lot of competent persons who can actually do or carry out inspection. Fine. So chief inspector has the duty to do that. Chief inspector appoint or recognize a lot of people as competent person for carrying out inspection in the factory. Right. Now, they will see that if I am appointing this particular institution as a competent person, do they have the qualification, experience as I need, and do they have the facility to carry out this particular inspection? If yes, well, they will appoint. Okay, so we check, or the chief inspector actually checks the qualification, experience, and facilities that are available, and based on that, having regard to that, they actually recognize or appoint certain person as the competent persons. Okay, clear? Fine. Next we have is the hazardous process. Hazardous process is what? Any process which is specified in first schedule. Any process which is specified in first schedule. Now here you have to take extras or special care, because it may cause some health impairment, or it may result in polluting the environment. That is the two things that you have to understand. Okay, so hazardous process is any process or activity which is specified in first schedule, wherein the raw material or the intermediate goods or the finished goods or any waste which is being generated, any effluents which are being generated, it would cause impairment to health or pollution of general environment, and that is why we need to take special care. So unless special care is taken, this would happen, but we don't want this to happen. That is why we take special care. So what is hazardous process? Any process which is specified in first schedule, which unless special care is taken would result in this. Okay, manufacturing process is something that I have already told you. Then we have worker. Who is called as a worker? A person who is employed, he may be employed directly, or usually we have contractors that, okay, we want 10 workers, so that particular contractor will give us 10 workers, right? So worker is somebody who may be employed directly, or who may be employed through some agency or contractor. Okay, now he is being employed with or without principal employer's knowledge, it doesn't matter, right? Whether for remuneration or not, it doesn't matter. In the manufacturing process or cleaning or machinery premises, so anyone who is cleaning the machinery is also a worker, or any incidental work. See, one is the direct work and one is the incidental work. Unless you clean the machinery, unless you oil the machinery, unless you set up this, the machinery cannot work. So those are incidental works only which are being happening, right? So first thing is you have to be employed. Any unemployed person is not going. That means there has to be a contract of employment between the two of you, right? Now this contract of employment could be direct one, or also through some agency or contractor. It doesn't matter. It should be direct or through some agency. It doesn't matter. You should be employed in the manufacturing process only, or maybe some incidental work or cleaning of machinery. That is the third aspect which you have to understand. The fourth aspect, it may be for remuneration or may not be for remuneration, right? So if you're receiving wages as remuneration, then great. Or if you are employed for no wages, then also you are a worker. You are entitled to these health, safety, welfare measures. All these are needed. Okay. Now, one thing that you have to remember is any member of the armed forces of the union is excluded from the definition of worker. This is something that you have to specially remember. The definition of factory is something that I've already told you, and now we have the definition of occupier. Occupier is somebody who has the ultimate controls of the factory. So if the factory is owned by a firm, then any individual partner, like if there is a factory which is owned by a company, in company we have a lot of the directors, right? Board of directors. Now any of the director may be entrusted or delegated the authority to control this particular factory. So that particular director becomes the occupier. So if it is a firm, any of the individual partners; if it is a company, any of the directors; if the factory belongs to central government or state government or local authority, then whatever person is appointed by that central government, state government or local authority, right? If ship in which repair is being carried out, so there is a dock, right? And there will be a ship. You understand what a dock is, right? Now here some repair or maintenance work is being carried out. So that particular area also become a factory in a way. So who is the occupier? Who has the ultimate control over that particular area? So there are two things, right? There will be an owner of dock. So for certain sections and certain purposes, we consider owner of dock to be the occupier, and in certain cases, we consider owner of ship to be the occupier for workers employed by him and the premises or the plant and machinery. So they are going to be deemed to be the occupier. I've explained you in detail in the class. I don't think here it is needed. So that is how you will remember the definition of occupier. So we have covered basically all the important definitions that are needed. And you have to learn the definitions also, though not word by word, but you should be able to write in your own words, because the definitions are also asked in examination, and you must actually know them, right? So hope you have understood the entire chapter of Factories Act, whatever is incorporated in your syllabus, and you're able to recall it well. Thank you. Let's now revise the Payment of Gratuity Act 1972. The first question comes to your mind that what exactly gratuity is. So gratuity is derived from the Latin word which is gratuitous, right? Gratuitous always means that you're not getting anything in return, right? So when employer is giving a gratuity, which is a kind of gift from employer to employee, he's not expecting anything in return. So apart from the salary, apart from other retirement benefits like PF, which is being offered to an employee, this is also a retirement benefit, a social security benefit, an old age benefit, which is being extended by the employer to an employee. Okay. The most important section comes into play is the section number 4, right? That is the first section. Before that, the object of this act, if you ask me, it is to provide for a scheme of payment of gratuity to employees. Where it is applicable, Payment of Gratuity Act is applicable to MRP of P, that is mines, railway company, ports, oil fields, factories, and plantation. And apart from that, to every shop establishment which is employing 10 or more persons with aid of power, or 20 or more persons without aid of power. Okay. So if you are working in any establishment, any shop, factory, mine, plantation, oil field, ports, if it is covered under the Gratuity Act, and if you are working as an employee with it, then definitely you are entitled to gratuity. The question is who an employee is. Under the definition of employee, an apprentice is not covered. Employee could be any person, whether your terms of employment are express, implied. You may be engaged in any kind of work, and but what is not covered is somebody who is holding a post under government, whether it's central government or whether it's state government. Okay. The maximum gratuity that can be paid is 20 lakhs. Fine. Now we begin with, and what is gratuity? Payment by employer to employee at the time of termination. Now, what is exactly called as termination? We have 4 things here. Termination shouldn't be written. What should be written is death or disablement. Okay. I will just strike it off and write this. Because termination may happen because of retirement, superannuation, resignation, or death or disablement during the course of employment for the past services rendered. So it is a lump sum payment which is paid to employee. Applicability, I have already told you. Once applicable, this act is going to be forever applicable. It came into effect with effect from 16th September 1972. Okay. Now, there is one definition which you all should know, that is of appropriate government. So, what is the government that we, or any factory, any railway company, any shop establishment is, it is applicable to? See, if you are such an establishment which has branches in more than one state, no state government can govern you or make rules for you, right? Because you are spread over in more than one state. So, in that situation, central government is going to be the appropriate government, including railway, port, mine, oil fields. In all other cases, the relevant state government is going to be the appropriate government. Okay. What is considered as family? Because you can give a nomination only in the name of a family member, so you must know who a family member is, whether we are talking about male employee or we are talking about female employee. If we are talking about the male employee, it will be it will be self, wife, children, dependent parents, and dependent parents of spouse, right? Widow plus children, child of predeceased son. Okay, so this is actually the case. When I take and when I say that, okay, I'm talking about a female employee, it will exactly be the same. The only difference will be, right, instead of here I've written spouse, so it doesn't make any difference. But otherwise, if for a husband, it will be wife, for a wife, it will be husband, right? Okay. Who an employer is. If the establishment belongs to government, then any person who has been appointed for supervision, such person is going to be called as the employer. Okay. If there is no person appointed, then whoever is the head of ministry. If it belongs to any local authority, any municipal corporation, anything like that, then the person appointed for supervision, that particular person will be charged as a person, as employer. Because throughout the act we have seen a lot of places where you are going to put in the responsibility that, okay, employer had to pay this, employer did not pay this, employer had to calculate this gratuity amount, employer did not calculate, and that is why there is somebody else who has to do or step in, the controlling authority comes. So basically the responsibility is being entrusted on the employer, and he is going to be liable for a lot of things. So it is very important to establish who an employer is going to be. Okay. If no person is appointed, the CEO of local authority, and other case, whoever has ultimate control over the affairs of that establishment. What is wages? All the emoluments that you're earning, including DA, but does not include bonus, commission, HRA, overtime, or other allowances. Fine. Okay. Now, we have one very important definition or very important meaning which is actually there in section 2A, and that talks about continuous service. Before I go on and tell you what continuous service is, one thing that you should establish here is that an employee will be entitled to gratuity only if he has rendered 5 years of continuous service. Continuous means uninterrupted service. So once you have done 5 years of continuous service, then when you terminate your job, that means when you retire or you resign or you leave for any other reason, there is death, disablement, then you will be getting that gratuity. Okay, then the person will be getting that gratuity. Fine. So to get the gratuity, first you should work in an organization to which gratuity act is applicable. Second, you should be covered in the definition of employee. That is, if you are an apprentice, if you're a trainee, you will not be getting gratuity. Third, you should do continuous service of 5 years. And fourth, if you have done continuous service of 5 years, then you make an application and everything when your job is terminated. What is continuous service? Continuous service means you have been in uninterrupted service for that particular period. But uninterrupted doesn't mean that I cannot fall ill for just 1 day, 2 day, right? So sick leaves are allowed for everyone. So if your service has been interrupted for sickness, maybe there is some accident, maybe absence for duty without leave. Without leave is without sanction. There are some sanctioned leaves, there are some unsanctioned leaves. Fine. Then cessation, any cessation means a stop or a pause which is not the fault of employee, right? It could be layoff, it could be strike, it could be lockout, right? Which is not the employee is not responsible for this interruption. So if you are doing that continuous service with these interruptions, it's completely fine. It will be treated as continuous service only. But what if I am not doing, I have not done this continuous service? Then am I not entitled to gratuity? Then we have to check whether you are deemed to be in continuous service or not. Deemed to be in continuous service means what? Means if you have worked for 240 days in an year, it doesn't matter what your whether you were taking permissible breaks or non-permissible breaks, you have gone for 240 days in a year. It's deemed that you had done continuous service for this year. The next year also you have done that. Next year also. Likewise, if you do continuous service for 5 years, then you are entitled to gratuity. Okay. But the time limits are different for different cases. What are the different cases? First of all, we talk about seasonal factory and other business. Seasonal factory that does not work all year round. That is, it is not working for 12 months, right? It's working for maybe 4 months, 5 months, 6 months, 7 months, 8 months. So whatever it has worked, the working days into 0.75, that is 75. If an employee has gone to work for 75% of the working days in a seasonal establishment, it will be deemed that that particular employee has rendered continuous service for that particular season. Okay, for that particular year as of that matter. Okay, fine. So if like maybe the seasonal factory has worked for 100 days, right? If you have gone for 75 days, it is deemed continuous service. For other business, it depends. Whether your organization is working for less than 6 days or 6 days or more. If less than 6 days, you have worked for 190 days, great. If 6 days or more, you should have worked for 240 days. So if you fulfill this criterion condition, it will be deemed that you have rendered continuous service for that particular year. When we are checking continuous service for a period of 6 months, it's exactly the half that's been taken. Okay. Now, the next thing which comes is notice of opening, notice of change, and notice of closure. So this form A is opening, this form B is change, and this form C is closure. Okay. What is this happening? That when you open any such organization to which Gratuity Act is applicable, or maybe you were employing only 5 people earlier, now you are employing, you have hired 10 more people, right? So now maybe Gratuity Act is applicable to you. So when Gratuity Act became applicable, within 30 days, you have to submit this form A to the controlling authority. Who is controlling authority? Appropriate government decides that and designates an authority as controlling authority of that particular area, so that you know, and you have to notify it. When you change your name or maybe address or nature of business, then also you have to intimate the controlling authority within 30 days. And if you intend to close down the business 60 days before the intended closure, you have to inform it to the controlling authority. Okay. Now, there is one very important thing, and that is Form U. Okay, so employer, you have to display an abstract of the act, all the rules in English as well as a language which is understood by the majority of people, and that has to be displayed. Apart from that, there is also something that needs to be displayed, and that is the name of the officer with designation, that is Mr. X is authorized and he can receive notices on my behalf. So everyone should clearly know that Mr. X is the authorized person to receive the notice on the employer's behalf. So that is also going to be displayed near the entrance. So these are the 2 display things that you have to remember. Okay, now we come to the main section, as I told you, section 4. So if an employee has rendered continuous service of 5 years, Of course, this continuous service of 5 years is not required in case of death or disablement. Okay. In the case of disablement, a person may choose to continue the service. That is a different thing. But in case there is permanent disablement and the employee cannot continue the service, if you have rendered service for even 3 years, you will be entitled to gratuity. Okay. Otherwise, you need to complete a continuous service of 5 years, and you very well now know what continuous service is. But you will be entitled to get gratuity only on termination. Fine. Okay. What is the amount of gratuity that you get? For every you get a month of wages for every completed year of service or part in excess of 6 months. So let's say an employee has worked for 7 years 8 months, so he will be getting gratuity of 15 days. The monthly salary, the monthly wages are 8,000 for 8 years. Why? Because 7 completed years and this part of year is in excess of 6 months. So this will be treated as 1 year only. So for 8 years, right? For every year, your 15 days wages. The next year, your 15 days wages. That is how you get it, right? If you're drawing normal monthly wages, the calculation is very simple. But if it is a piece rated employee whose wages are not fixed per month or according to the time, then you have to calculate that what his average comes without any overtime. Average of last 3 months, and that is how the monthly wages are being calculated. When we talk about seasonal establishments, you get gratuity only for 7 days and not for 15 days because you haven't worked for whole year round. Okay. Now, sometimes I told you that gratuity, the after disablement also the employee may continue to work. So after disablement, he has reduced wages, but the gratuity is paid on the basis of last drawn wages. So he will have reduced wages. So accordingly, in case the person is disabled, he had some wages before disablement and some wages after disablement. Accordingly, his gratuity will also be calculated. Like if he has worked for 6 years in total, 3 years after disablement, 3 years before disablement. So he will be getting gratuity for that entire 6 years, 3 years at the rate of disablement, 3 years at the increased wages. Okay. Can the gratuity be forfeited? The answer is yes. Forfeiture means taking away of something because of your mistake. That means the employee has done some mistake and that is why he's not entitled to gratuity anymore, right? If the service was terminated because of any act, willful omission or negligence which has caused damage to the property of employer, or you have done some disorderly conduct or act of violence, or you have been involved in an act involving moral turpitude during the course of your employment. Act, I shouldn't say, I should actually be saying an offense. Okay. An offense. Okay, so in these cases, the forfeiture is going to happen. In those cases, forfeiture of gratuity may be done wholly or partially depending upon how serious your offense is. And here, the forfeiture is going to be done to the extent of damage. So if your negligence has caused a theft in a factory and that theft led to, or that theft was of 30,000 and gratuity payable is 60,000. So 60 minus 30, you will be getting only 30,000 as gratuity. And your 30,000 gratuity is forfeited to the extent of damage. Why? Because your negligence has caused damage to the property of the employer. How it is done? The employer sends a show cause notice to the employee and the employee gets an opportunity of being heard and the final decision of employer is bounding. Okay. Now, there is also something or some provision called as of nomination. What is nomination? See, every employee, once you complete 1 year of service, then you have to give a name that in case death or death happens, then the gratuity is going to be paid to that nominee, because if the employee is alive, it is a retirement benefit and it's paid to the employee only, right? But you can you have to name a nominee. Nominee could be more than one person also, and you file this form of nomination within 30 days after 1 year of service in duplicate. You may send it by registered post acknowledgement due or by personal service to the employer. Okay. If you have a family, it has to be a family member only, right? If there is no family, then it can be in favor of any person, but subsequently once you acquire the family, the old nomination is going to turn out void, and you have to make a fresh nomination in the name of family member, and you have to give it to the employer. Okay, employer is going to keep it in safe custody, and one attested copy is returned to the employee, right? This nomination can be modified in form H also. Okay, now how do you get the gratuity? The gratuity, you know how, what is the amount of gratuity, who is entitled to gratuity, but how do you get it? There are two things. One thing has to be done by the employer, the other thing has to be done by the employee. Employer, what you have to do? Employer, you have to do, once the gratuity becomes applicable, you calculate that gratuity, you compute the amount of gratuity, and you send a notice to the employee as well as the controlling authority, okay, that this is the gratuity which is going to be payable. Fine, and you have to make arrangements to pay it within 30 days, right? Now what employee has to do? Employee, if your termination is due, that is, you know that you are going to turn 60 next month, and then you'll be getting the gratuity, so 30 days before that date of gratuity become payable, you have to make an application and send it to the employer, give it to the employer. If your termination is unknown, that means maybe a sudden death happens, so sudden death happens or sudden disablement happens, right? So in that situation, within 30 days of gratuity becoming payable, you have to file this form. The form may be filed by the employee, form may be filed by the nominee, form may be filed by the legal heir, as the case may be. If there is no nominee, ultimately legal heir gets it if the employee has died, right? So these are the forms which may be filed by respective people to the employer. Okay. So what you do is you are filing this form to the employer. Now what employer is supposed to do? Employer, within 15 days, you will see whether the claim is admissible or the claim is not admissible. If the claim is admissible, you agree that yes, this employee has to be given this much gratuity. You have already calculated the gratuity. You had already issued these forms, right? You had already given notice, I would say, right? Even if you're not receiving this application, it is your duty also to give the notice. Okay, so if I have explained you that in detail, it's just a quick revision, fine. So if the claim is admissible, you will send this form to employee and fix that, okay, on such and such date I'm going to pay you the gratuity, right? And you cannot fix a date like, okay, I'm going to pay you gratuity after 1 year. No, not later than 30th day. Okay, and later on you will pay it on the same date in cash, DD or check. If it is less than 1000, money order can also be done, and you are going to intimate it to controlling authority. Okay, if the claim is not admissible, then you will give the form, you'll tell the reason why you're not considering your gratuity, and you will also give notice to controlling authority. In case there is a dispute regarding the amount of gratuity, then you have to deposit the gratuity with the controlling authority, and the controlling authority will hear both the parties, that is the employee and the employer, and decide that, okay, what is the exact amount of gratuity which is payable. And after it passes the final order, the gratuity will be paid by the controlling authority to the employee. If the employer has deposited only 30,000 but the amount payable is 40,000, then the controlling authority will ask for 10,000 more and pay it to the employee. Okay. Now, if the employer refuses that, okay, I'll not accept your nomination, okay, or if they refuse to entertain your application, or you reject your eligibility, or there is lesser amount that they are paying, or there is no notice that they issued which they are supposed to issue, then employee, within 90 days you can make an application in form N to controlling authority. Okay, controlling authority may accept your application even beyond 90 days. Now, why are you sending this application? Why are you making an application to controlling authority? To seek their order in the similar manner. Like as when we were children, we would just go to our parents and say, this, my brother or whoever he is, right? He, she, not giving me my water bottle, not giving me my tab, not giving me this, not giving me that. Why are we saying? Just to seek direction. Seek direction in a sense. Now that mother, father, parent is going to give direction, is going to say, give it back to him, give it back to her, right? So now he gives it. In the same manner, When the employer is not doing all of this, we are going to the controlling authority to just become a child and say, this is not doing that. Right now, controlling authority will give instruction that do this immediately, and that particular person will do it. Okay. So if the person is not satisfied that no, I don't have to do it, you can go further to father, right? So here also you can further go to appropriate government. Okay. But before that, so if this is not done, employee within 90 days, you can make an application to controlling authority, and controlling authority is going to call both the parties and hear the parties, decide the date, time, and place, sittings as decided. And if you do not want to appear in person, you may also send your representative along with the letter of authority. Fine. Now, during the hearing, if the applicant is not coming, that means you have raised a request and you are only not coming, it will be dismissed. But if you have raised a request that the employer is not doing something and the employer is not coming, then X party, that is without party, the employer, without the employer, the decision will be taken by the controlling authority. Fine. So controlling authority will record that this is my conclusion, this is my finding. This copy is going to be sent to both the parties. If the party is aggrieved, within 60 days, they can appeal to appropriate government, and appropriate government will pass the order. Okay, fine. Now, there is something called as approved gratuity fund. And what is approved gratuity fund? Approved gratuity fund is going to have the same meaning as under Income Tax Act. I have given you a question also, and I have explained you in that we have something called as compulsory insurance under section 4A, right? That is, if an employer has to pay gratuity, if he has gratuity payable, then he needs to get that compulsory insurance done, right, for that payment of gratuity. But if the employer is maintaining a good gratuity fund, then he is exempted from doing that compulsory insurance, right? So that is about approved gratuity fund. Okay. So I hope it is all clear. There is something called as powers of controlling authority. That what powers controlling authority has. So controlling authority has the same powers as a court has while trying a suit under CPC, that is Code of Civil Procedure. That is, they can enforce the attendance, they can call any person, they can ask for production of documents, they can examine the persons on oath, they can receive affidavits, they can even issue commissions. What is issuing commissions? Like appointing somebody else to go and witness the examine the witness, right? Then we have penalties, which are stated in section 9. There are 3 penalties that you have to listen and you have to learn. Then we have something called as section 10, which talks about exemption of employer from the liability. So if I am an employer and I feel that no, I'm not responsible with this, I can prove that I am not responsible. There is somebody else who is the actual offender, and I bring that offender before the court, right? Then, if I pass, or if I succeed in actually proving that yes, I exercised due diligence, I have not committed the offense, that other person has committed the offense without my knowledge and consent, and in that situation I can be free from the liability. Okay, I can be free from the liability. Then there is something also called as protection of gratuity. That is, whatever gratuity is payable to me is not going to be attached to any of the civil, revenue, or criminal proceedings. I explained you that in detail, right? And that is it. Okay, thank you. Let's now revise the chapter of EPF and Miscellaneous Provisions Act 1952. Right. What it is all about. When I say employees provident fund, you are basically setting aside a sum of money, timely setting aside certain sum of money for the benefit of future, right? Thinking about future, right? And who is setting aside? It is basically for the benefit of the employees. Employees provident fund. It is one of the social welfare legislation which has been created, which has been made mandatory by the government. And if you go deep inside the concept, you will realize that this is basically for the class of employees who do not tend to think about their future or save money for their retirement, for post retirement, and all of that. Okay, because somebody who is drawing, who is highly educated and who's drawing a very good salary can take care of these things, but somebody who's drawing a very less salary and is maybe not so educated, not so aware, does not realize the importance of this, does not do this, right? So government has made it mandatory. Okay, now, it is mandatory for whom? For the employees working in an organization to which EPF Act is applicable. The question is, EPF Act is applicable to what? It is applicable to every factory which is engaged in an industry that is specified in Schedule 1. I've already told you almost every industry is specified in Schedule 1, right? And in which 20 or more persons are employed. Other establishment in which 20 or more persons are employed. If in any establishment there are less than 20 persons employed, in those establishments also central government can give them 2 months notice and make that this act is going to be applicable to you also. Okay, and if all the majority of the employees and employer feel that this act should be applicable to our establishment also, they can make an application and the act will be applicable to them also if Central Provident Fund Commissioner feels so. Now, once the act is applicable to you, it doesn't matter that you are an organization which had employed 30 people, but now your workload has reduced and now you have employed just 10 people. You have retrenched the other 20. Still, the act will be applicable because once it is applicable, it continues to be applicable forever and ever and ever. Okay, ma'am. So there is an organization to which EPF Act applies. So that organization has to register themselves with the authority or with the organization EPFO, right? Okay, so now the employees become EPF member. Ma'am, do all employees become EPF member? The answer is no. The act is actually applicable and mandatory for the employees who are drawing salary not exceeding 15,000 per month. So if your salary is up to 15,000 per month, then it is mandatory for you to become the member of EPF if your organization, if on your organization EPF Act is applicable. Now, when I say 15,000 per month, it means the wages. Wages is basic wages plus dearness allowance plus retaining allowance plus cash value of food concession. Okay. So that was about applicability. Now we have these 3 schemes under this act. Now, if somebody becomes the member of EPF, he also becomes the member of pension scheme and IDLI, Employees Deposit Linked Insurance Scheme. Okay, so there are 3 benefits all rolled into one under this act, and there are 3 different schemes framed. So just like we read Companies Act along with the rules, we read this particular chapter along with the schemes. So we have EPF Act read with Employees Provident Fund schemes. We have EPF Act read with Employees Pension Scheme. We have EPF Act read with Employees Deposit Linked Insurance Scheme. Okay. This scheme is meant to promote savings. This scheme is a retirement pension, that is an annuity regular payment after retirement, and this is for sudden relief to the family members in case of death, just like we have life insurance policy. So it gives you a cover of up to 6 lakhs. Okay. So these are all the social security benefits which are being given. Fine. Okay. This is something that I've already told you. Now, we also have something called as non-applicability. That is, the act is not going to be applicable to any establishment, like any cooperative society which has employed less than 50 persons and is working without the aid of power. I have explained you what are the cooperative societies are. Right? And to other establishments which belong to central government or state government, and they have already given their employees the benefit of PF, pension, etc., according to a different scheme which has been framed by CG or SG. Right? Likewise, to any establishment which is actually set up under a central act like LIC, under a state act, and whose employees get the benefits of PF, pension, etc. under any scheme. So if they're getting such benefits, it's not going to be applicable. This act is not going to be applicable to them. We have some important definitions under this act. The first one being appropriate government. So appropriate government could be central government, it could be state government. When I talk that for me, what will be the appropriate government, central or state? Well, are you an establishment which is operating or which is having branches in more than one state? So your appropriate government cannot be state government, it has to be central government, right? Or if you're a railway company, if you're a port, if you're a mine, oil field, then appropriate government will be central government. In all other cases, it's going to be state government. When we talk about the authorized officer, under this act, the senior most or EPFO organization head is the Central Provident Fund Commissioner. Then we have additional, we have deputy, we have regional. So all these are called as authorized officers only. Fine. Basic wages, I've already told you. Basic wages. The wages means basic plus DA plus RA plus cash value of food concession. Basic wages means all the emoluments that you're earning without any allowance, without any cash value of it is not actually cash value of consideration. It is cash value of food concession. Okay, so it's not going to include any of these, right? Then we come to the definition of employer. Now, there is a difference between employer and occupier, right? When I say occupier, then we have occupier of a factory, basically somebody who has the ultimate control over the affairs of the factory, right? He may not be the owner of the factory, but he's controlling all the affairs, or he has appointed someone who is the agent and he is controlling the affairs of the factory. So somebody who is in charge of the factory, somebody who is having all the control of the factory, somebody who is taking all the decisions will ultimately be responsible for the things that went wrong in that factory, right? So that particular person is the occupier. Now, when I say employer could be the occupier, it could be the owner, it could be their agent, representative, manager that they have appointed, any like, okay, for a factory. For any other establishment, whoever has control. When I say employee, who is going to be an employee? Employee could be any person who has been employed. He might be doing some supervisory work, some managerial work, some manual work, any work, right? And he is getting his wages from the employer. Now, there are two people who are included in the definition of this employee. One is the apprentice. Apprentice is a trainee, right? We have an Apprentice Act 1961 where the definition of apprentice is given, that who is going to be treated as an apprentice and who is not going to be treated as an apprentice. So if you're an apprentice which is engaged under the Apprentices Act, then you're not covered over here. You're not an employee over here. Otherwise, you are an employee, and the persons who are employed through the contractors, they are also going to be covered in this particular definition. Factory definition, very simple. The premises, including precincts where any manufacturing is going on with or without the aid of power. Okay. Then we come to the three different schemes. EPF, Employees Provident Fund Scheme, covered under Section 5. Then we have Employees Pension Scheme, covered under Section 6. Okay. Then we have Employees Deposit Linked Insurance Scheme, that's covered under Section 6C. Now, EPF scheme came into effect from 2nd September 1952, and it talks about creation of a provident fund which is going to be administered and vested in the hands of central board. Ma'am, what does the scheme tell us? This scheme basically tells us all that is stated in Schedule 2. It provides for all the matters which are stated in Schedule 2. Ma'am, we really don't get it. See, this particular act has 4 schedules. Schedule 1 is about the industries that we have already discussed, that the act is going to be applicable to every factory which is specified, falls under this industry specified in Schedule 1. So we have that specified. The other 3 schedules are about the other 3 schemes: EPF, EPS, and IDLI, right? So Schedule 2 talks about that what should be stated Just like under Companies Act, we have like a format articles of association or memorandum of association, right? In the same manner, here we have that for these matters, the scheme should say, like the scheme should be formulated in such a manner that it talks that, okay, the scheme is going to be applicable to which employees, how are you going to avail the scheme, how do you get money from that, so what is the form that is going to be used, all of that is going to be specified in that scheme. We don't have to read the scheme, and we don't even have to read the schedule, but you should be knowing that schedule 2, 3 and 4 likewise tells us that. Okay, the question is that, ma'am, it's going to create a provident fund, right? So every employer, now you have registered yourself with EPFO, and the applicable employees to whom EPF Act is mandatory, you create an account, their EPF account, and they become a member of EPF, right? So they are now the members of EPFO. Okay. Now, the fund is not going to be the money that you're collecting. What ideally is happening, you are setting aside some part of your salary, some part of your income to a fund which you will be using after retirement or maybe for certain things, right? This is the vision, this is what we are thinking. Right. Now, we all know that employer, employee, they both contribute to the fund, and that fund is not with the employer. He's not handling that fund. That fund is actually being handled and administered and vested in the hands of central board. The question is, what is a central board? So central board is something which has been established by central government. We have central board, we have executive committee, we have state board, right? Who is there in central board? Central board is nothing but it is a group of people. It is actually considered to be a statutory body, right, which has like perpetual succession and all of that, right? So it is a statutory body, and it comprises of certain people. Who are there? There will be a chairman, there will be a vice chairman, then there will be some persons representing employers, some persons representing employees, some persons of government, central government representatives, some of state government representatives, and Central Provident Fund Commissioner. Whoever is holding the post of Central Provident Fund Commissioner will also be a member of Central Board. So that appointment is ex officio. That means by virtue of you being in that office, you also become a member of Central Board. Okay. Now, Central Board is there. Then we have Executive Committee. Executive Committee is like a delegate to central board, so it is going to assist central board in all the functions that they're discharging. What are the functions that central board discharges? Central board is basically supposed to handle this fund, administer, monitor this fund, right, and do a lot of things. Executive committee, you are supposed to assist central board and help them discharge their functions, right? Then we also have something called a state board. Now, state board, what they are going to do, they are going to be appointed again by central government in consultation with the state government. So they decide that, okay, this should be the state board which is going to be constituted, because at the state level, there are a lot of things which need to be done. So who tells them what to do? They are going to do those functions which central government is assigning them from time to time. Okay. Now, in EPF scheme, there is a contribution by employer and by employee. The rate is 12%. It's written the other way around. The rate is 12%. Minimum contribution rate is 12%, right? So employer, you have to contribute 12% of the wages, right? Employee, you have to match that equal contribution. Okay. Now, it is mandatory for the employees who are drawing salary up to 15,000. It is mandatory, right? If you're drawing a salary of maybe 20,000 per month and you want to be a part of this EPF scheme, can you? The answer is voluntarily you can, but then your maximum contribution will be restricted to 15,000 only. There is also a rate of 10% for certain establishments, which you don't need to learn in a lot of detail, but I have told you that, right? Okay, so that is the contribution which is being made. Now, employee, your contribution of 12% of the wages will directly go to the EPF account, but employer, your contribution of 12% will not directly go to the EPF account. In fact, 8.33% will go to the pension fund, and 3.67% will go to the EPF. 8.33% of pay, 3.67% of pay. So ideally what you're getting is 12% of pay by the employee plus 3.67% of pay by the employer. This is what is accumulating in your EPF account. Otherwise, employee, you're not supposed to contribute anything to the pension fund. Employee, you're not supposed to contribute anything to the IDLI scheme, that is insurance linked fund, right? But employer, you have to contribute 12%, out of which it is diverted to both the funds. The third fund, you have to contribute 1%. Okay, so this is your additional burden which you have to do. There is no escaping. This is something which is mandatory. So accordingly, hire your employees. But this is something which is mandatory and has to be done. Now, every contribution that you're making is going to be rounded off to the nearest rupee. That is 50 paise or more is going to count to the next number. Okay. And I've already told you, when I say 12%, 12% of wages means 12% of basic plus DA plus RA plus the cash value of food concession. Okay, fine. Okay. See, this is how I have written, because this is how it's written in your study material. But I have also told you how it is actually, what it is, right? So I have told you the real thing also, and I've told you this way also. Okay. Now, can we withdraw from this fund or can we take advance from this fund? Of course, there is a difference. When we say withdrawal from the fund, it's like settling this particular account. And when I say advance from this particular fund, like if I'm saying withdrawal, maybe I have a house help and she comes to me and says that from tomorrow I'm not going to come settle my account. That is withdrawing everything, right? And maybe when she comes and says, the next case, she comes and says that I want 2,000 advance, right? So I give her 2,000 advance, that will be adjusted in the next month, right? So that is how it is done. Ideally, she's never returning me that advance, but however, it is advance only which she has taken, right? So that is the difference. Now there are many more things, many more conditions about advances, withdrawals and all of that, but you don't have to read it. So basically for your exam, since it's a very important question from examination perspective, this must be understood well, and this must be learned well. I wouldn't say understood well, because there are a lot of things that you're not reading to understand the entire perspective. So when I say withdrawal from the fund is allowed for if you're constructing your house, or if you're purchasing your house, or if you're repaying your loan, not a normal loan but in special cases. If you're withdrawing 1 year before the retirement, of course this again has a limit, or if you're withdrawing up to 75% of the balance, you can, if you're not employed for 1 month or more. Okay. Now, advances. You can take advance from the fund in case of illness, for marriages, for post-matric education, when there are abnormal conditions like maybe earthquake, riots, COVID, etc., etc. When certain members are affected by electricity cut, when certain members are physically handicapped. So in these cases, you can take advance. Next, we come to employees' pension scheme, right, which is covered in section 6A. What is pension scheme? Pension scheme, basically central government wants, and they think that okay, we are thinking about after retirement, but after retirement also, if collectively, because when I talk about provident fund, it's a lump sum payment given one time, right? So if a person gets that lump sum payment, he might spend it, but there has to be a pension which he's getting on a regular basis, like annuity, right? So you don't have to contribute anything extra to this employee's pension scheme. The contribution by the employer is being diverted to the employee's pension scheme, and this is for providing superannuation pension, that is once you attain the age of retirement, retiring pension that is otherwise done on superannuation, permanent disablement, widow pension or widower's pension, children or orphan pension, right? So again, there is a pension fund which is being created, and the same is also going to be administered by the central board. How the contribution comes into this pension fund: employer, this contribution comes, and employee, no contribution comes. Fine. Scheme ceases to be completed on 58 years. Okay. Now, this is schedule 3, my dear. This is schedule 3. When I say EPS scheme, what is this scheme going to provide for? The matters which are contained in Schedule 3. What are the matters that which employee is applicable? What is going to be the employer's contribution? What is going to be the minimum qualifying service? Because it cannot happen that you are working in an organization for just 2 months and then you claim that, okay, I should be getting lifetime pension. No, you're not going to get that. Minimum, maybe you need to be in employment for 10 years and thereafter you'll be getting pension. So what is the condition that is going to be stated in the scheme? What is the manner and period of service? How do you protect employees interest if the employer is not contributing enough, right? What accounts, what registers, what forms are to be maintained, right? Manner of contribution by exempt establishments if they want to be, how it is going to be dispersed, then how are you going to manage the expenses and others. Okay, then we have Employees Deposit Linked Insurance Scheme, that is IDLI, right, covered under Section 6C. Now, this particular scheme came into effect on 1st September 1976. It gives you insurance benefit up to 6 lakhs and there is a weight ceiling limit of 15,000 that we already know. What about the contribution? The employer, you're not supposed to make any contribution to this. Employer, you are going to make a maximum contribution of 1%, right? Plus, you have to give an administrative expenses, which will be 1/4 of the contribution that you have given. Okay. Now, we have few other sections. There is a whole hierarchy. We have section 7A, 7B, 7C. Thereafter, we have that appeal, which may be made. Okay, so what is 7A? 7A talks about any dispute. So we don't know whether this particular factory, EPF Act is applicable or not, or this particular establishment, EPF Act is applicable or not. So there is a dispute. The employees may be contending that yes, EPF Act is applicable, so the employer must contribute. He's not contributing because he's saying that no, EPF Act is not applicable to my establishment, right? So there is a dispute. To resolve this dispute, what has to be done? An application has to be made to the authorized officer. You know who an authorized officer is, all the provident fund commissioners, right? So they're all the authorized officer. Now that relevant officer and that concerned authority, what they'll do is they'll hold an inquiry. Okay, how do they hold an inquiry? They give an opportunity to both the parties. They give an opportunity to employer also to say his thing, right? And thereafter, based on that inquiry, they will decide that how to resolve this dispute, and they will also determine that okay, yes, the act is applicable to you, so you have to pay an amount of 5 lakh is due from you. So that amount which is due from the employer. Why will the employer listen to him? Because the authorized officer has been entrusted with and has been given the same powers as a court has while the court is trying a suit. Like they can call the persons that you have to come for attendance, they can examine those persons on oath, they can ask for documents, they can receive affidavits, they can send somebody for examining the witness, right? So all these powers have been conferred to the authorized officers. Okay, now sometimes it may so happen that the employer has not turned up for the inquiry, or maybe the employee has not turned up for the inquiry, or maybe some other person. So in case there is failure to attend the inquiry, what happens is the authority is going to decide the case without that party, with whatever available information and documents they have. If within 3 months you feel that no, I had sufficient cause, there was a death in family or something like that, and you can come up with a sufficient cause and say that is the reason I could not come for the inquiry, please set aside this order and again hold the inquiry, I will be available. So if you provide that sufficient cause within 3 months and you request, then they may set aside. Okay, and again the inquiry will be held. Now sometimes it may so happen that while the inquiry is going on, you could not find that proof, you could not find the document, and you kept deferring it, but ultimately the inquiry was decided and an order was passed by the authorized officer. But later you found a new document which is actually going to turn the tables, which is going to turn the case, right? So because you have discovered some new evidence, you can go back to the same officer, right, and tell them to review his order and provide him the new evidence or the new document. Maybe that there is a new discovery, or maybe that document was not available earlier, or maybe there is an order passed which says 25,000 plus 40,000 is 62,000. So there is a mistake which is apparent on the face that you have made a the addition is incorrect, right? So you can go ahead and you can give that order back to the officer and say and ask to review that order. So he will change that. He'll see that can it be reviewed or not, right? So maybe you have discovered some new evidence, maybe the evidence could not be produced earlier, maybe there is some mistake, maybe there is some error apparent on face, or maybe there is some sufficient reason. So in that case you can apply for review, and the authorized officer may review and may also reject if there is no sufficient ground. However, the officer also has the power to review his own order suo motu. Okay. Apart from that, we also have section 7C, which tells that till 5 years of passing those orders, if the authorized officer feels and believes that employer, I asked that document and you did not provide the document. Now that I've found your document, I feel if I had this document, your amount due would not be 50,000, rather it would be 5 lakh. So within 5 years, till 5 years, they can reopen the case. Okay, and they can pass orders. Fine. Now, if you are dissatisfied with the order under section 7A or 7B review order or 7C, trying to recover that escaped amount, right? So all these three, if you're dissatisfied with any of these orders passed by the authority, you can appeal to appellate tribunal. But when you're appealing to appellate tribunal will ensure that if the amount due calculated is 1 lakh, at least 75,000 must be deposited with appellate tribunal. Then only they are going to entertain your appeal. Supposedly you bring a plea that no, I don't have 75,000. This is absolutely unfair, injustice. You provide them sufficient grounds, then maybe they'll reduce your amount, or maybe they'll waive off that, okay, you don't need to deposit. Fine. So it depends upon case to case, but prima facie, this is the situation. Okay. Now, once you have appealed to appellate tribunal may confirm that no authorized officer, whatever they said is correct. They may modify, they may say, no, you don't have to pay an amount of 5 lakh, but 4 lakh only. Right? So they may modify, or they may annul, that is dismiss and refer back to the authority that you inquire it again. You see it again. Okay. Then we have other very few small sections. One is protection against attachment. That means whatever account is there, whatever amount is there in your EPF account, that is not going to be pledged, that is not going to be provided as a security to bank. It's not going to be attached. You will have all the rights against it. The employer will not reduce your wages just because they can reduce their statutory payment to PF. Like if you have a salary of 10,000, then the PF is 1,200. If you have a salary of 5,000, the PF will be 600, right? So they cannot reduce your salary or wages for this particular reason. If you're working in one company or organization, then you leave that organization and go to the other one. Whatever accumulation is there, it will be transferred to your new account. That is, the account is going to be the same to the new establishment, right? So nothing is going to be lost or wasted. Then we have one section called as section 14, which is penalties, which you're going to revise on your own. And then we have the last section that we have to read in this particular chapter, that is section 14A, which talks about offenses by companies. So what is offenses by companies? Supposedly, when we read the penalty, we come across and see that, okay, if you do not do this, you're imprisoned for 1 year. Now, a company cannot be sent to imprisonment. A company cannot be sent to jail, right? So what happens in this particular situation? There has to be some natural person who is actually guilty of the offense. It's not the company which is doing that offense. It is the person who was in charge, who was responsible. That particular person is doing the offense. So when we are talking that a company has defaulted, the company has not deposited the PF amount, so who is responsible? Who should be sent to jail? Who is going to be imprisoned? The person who was in charge, right? But if he proves that I was the in charge, but it is not my mistake, I've exercised due diligence, I've done this, I've done that, there is somebody else who has done that fraud, right? So if you can prove your innocence, fine, you will not be responsible, you will not be liable. Otherwise, we have the director, manager, secretary, any other officer with whose consent this was done, right, who knew that this is going to be done, right, then that particular person will be responsible for the offense, right? Okay. Let's now revise ESIA, Employee State Insurance Act 1948. Now, this particular act has 8 chapters in total, and this is basically the first legislation on social security for employees, and it provides you 4 benefits, right? This particular act has come into picture to provide the benefits to employees whenever the employee is sick, that is sickness benefit, maternity benefit, employment injury, and others, right? When we actually go on to understand the benefits, we also come to know that, okay, even if there is a funeral expense, that also will be provided, right? As regards to applicability and extent, it extends to whole of India. With respect to applicability, it is applicable to all the factories. Now, when I say factory, the factory has been defined to mean a manufacturing entity where 10 or more persons are employed. Okay, so if they're not employed, they're ideally not factories. The seasonal factories are not covered, on seasonal factories, ESI Act is not applicable. Apart from that, you have to understand that once the Act is made applicable, it's going to be applicable forever. And the government establishments are also covered. Apart from that, appropriate government can give 1 month notice and extend the provisions on any other establishment also. Okay. Now, if you are an employee of such establishment to which ESI is applicable, you still have to confirm that if the wage limit is exceeded, that is, the wages of workers should be less than or equal to 21,000, it shouldn't exceed 21,000 per month, then you are covered under ESI scheme. Otherwise, you're not covered under ESI scheme. Okay, we have different definitions that we have to read over here. Appropriate government for establishments like a railway company, like port, like mine, like oil fields, and the establishments which have or operate in more than one state. For that, it's central government, otherwise it's state government. Confinement is the labor which comes after 26 weeks, and it doesn't matter whether whether the birth of the child is live or dead. Okay, then we have the definition of dependent, which I have explained you through a wonderful chart, like how many relations could be there, and through that I have tried to explain you that, and I have tried to basically make you learn that, right? Because that is the only problem that you face when you read certain definitions like dependent. Okay, so dependent could be when the wife could be dependent, when obviously the person dies, then she becomes a widow. When the son, daughter, then you have grandparents, you have grandchildren, you have brother, you have sister, right? So everyone is in a line, and thereafter you can judge whether the person is dependent or not. Okay. Then we have a definition called as employee. Who is an employee? The employee may be a person who is directly employed by the principal employer or through an immediate employer, or whose services are let on hire, right? Temporarily let on hire. It doesn't matter. It doesn't matter that whether you are employed for the administration of factory, or you are appointed or employed for the process of purchase of raw material, sale, etc. An apprentice is also covered. We have the canteen workers who are also part of employee, who are treated as employee. We have part-time employees, they are also employees. Casual workers are also employees. Anyone who is rendering services outside that establishment is also an employee. Okay, but what is not included is the apprentice covered under Apprentices Act, the member of Navy, military, or Air Force, and the person whose wages exceed the prescribed amount. And there was a case law of ESIC versus Ramanuja, in which it was established that the partner is not an employee. Okay. Then we move to the main sections. We still have more definitions to discuss. We have immediate employer, we have the disablements, we have principal employer, we have seasonal factories, right? So I'm not getting into discussing all the definitions over here. We have wages. What do you mean by wages? Wages basically includes LIC premium subsidy, overtime allowance, HRA. Then we have incentive bonus, but what it does not include is that bonus or gratuity or any contribution or the traveling allowance. That is all not a part of wages, right? Wages is basically whatever you're getting in cash, right? Whatever is being paid to an employee. Okay, so that is going to be treated as wages, but what is not treated as wages, that also you should remember. Okay. Apart from that, there is, right. Let's now begin and discuss the main provisions. The first provision that we discuss over here is of ESIC. What is ESIC? It is an organization which is being created and developed by government, right? It is a body corporate. That means it has the capacity to sue. It can be sued. It has perpetual succession. It has common seal, right, etc., etc. Now, what is the constitution? Who is a part of ESIC? Chairman, vice chairman, then we have members representing employers, members representing employees, members representing state government, members representing UT, medical profession. Then there are going to be 3 members from the parliament. Then there is going to be director general, who is, by virtue of his being in that office, he's also going to be a part of ESIC. So obviously he's the head of ESIC. He's also the part of standing committee. He's also the part of MBC, that is Medical Benefit Council. Okay. Now, what are the powers, or what actually ESIC does? ESIC, what do they do? They are basically responsible for administering the entire ESI scheme, right? They formulate regulations, they overlook the scheme and everything. Okay. Now, they also have the power to appoint regional boards. Just a second. They also have the power to appoint regional boards and local committees or benefit councils, right? Okay, the term of office of corporation in general is 4 years, and they may be appointed, or they may be re-elected after their term. They may be reappointed after their tenure expires, right? Then we have a standing committee. What is standing committee? Standing committee is a group of the same people, just like we have a board of directors, that is the ESIC, and then we have audit committee in under Companies Act. Likewise, we have a standing committee who's actually doing the ground level work and assist ESIC in the administration. Okay, so who are going to be a part of standing committee? The constitution, if you look at it, a chairman, 3 members of the corporation who are going to represent state government, then um, 3 members who are going to represent the employers, 3 members who are going to represent the employees, 1 member who is going to represent the medical profession, and 1 member is going to be from that parliament of member, right? Member of parliament, 1 member from that. And the director general, of course, I told you he is going to be there as a part of standing committee. Now, in general, the term of office of standing committee of the members is 2 years. Why am I saying in general? In general, because when I said ESIC also, there is a different term prescribed for the first 3 categories. However, we are not getting into that detail right now. Powers. What do you think standing committee do? Standing committee, basically you're administering the affairs of the corporation, you're assisting the corporation, and thereafter whatever case comes to you, because there are a lot of policies, there are a lot of matters which need to be dealt with, right? So there are certain matters which are being specified in the regulations that if they come with you, you don't have the power, and the ultimate power will be with the ESIC, right? So what you have to do is you have to submit these cases to ESIC for consideration, and their decision will be final. However, other matters you can deal with, and these matters, if you feel that okay, I need to submit to ESIC and I need to discuss, then at your discretion you can do that. Okay. Then we also have Medical Benefit Council. What is Medical Benefit Council? Now, Medical Benefit Council is a very essential and important part in this particular chapter. Why? Because ultimately the first benefit that's being provided under the Act ESI is medical, because this particular act talks about the negligence which we have seen over the years done by the workers, because workers don't think of the future, like whatever they are earning they're spending. They don't think that, considering the fact that there are so many diseases which are rising in our nation, we have to be prepared and we must have a medical insurance, but they will never spend on that medical insurance. And if at all they fall sick, they will be admitted in the hospital, but they will not have any amount to pay. Although we have government hospitals and everything, but this is they don't get that entire cover and everything, right? So this is a beautiful legislation which actually secures their life, right? Although they have to contribute a very little part, but yet their life is almost secured in terms of medical, in terms of any employment injury. There are a lot of dependent persons, right? Their life is sorted. They'll be getting periodical payments in case anything happens to the insured person, right? So medical benefit council is very important, who is going to be like, there is Director General of ESI, obviously, Director General Health Services, Deputy Director General, then Medical Commissioner of the corporation, one member representing each state, three members from representing employers, three members representing employees, three members representing medical profession. One is going to be a woman, so that the problems faced by women are also dealt and discussed on the table, right? So that is the constitution of Medical Benefit Council, immensely beneficial and much needed. Okay, now the term of office in general is 4 years. And then we have the duties. They are going to advise corporation regarding administration and certification of benefits. If there is any ESI hospital or dispensary opened and there is no doctor available, or the doctor who was supposed to be there is not coming on time or anything like that, that means there is a medical practitioner who is not rendering his duties properly. So a complaint is filed against him. Who is going to look after that complaint? This Medical Benefit Council. So it is their duty to investigate. It is their duty to provide advice to the corporation and standing committee when they are making policies or they are making any regulations with respect to medical benefits and like, and other duties as are prescribed. Is this clear? Okay. Now, whether you are a corporation, member of corporation, standing committee, or medical benefit council, every such authority or body is going to meet. How often are they going to meet? Meet at such time and such place with such frequency as may be specified in the regulations, right? Okay. Now, the corporation or standing committee, you have been formed, right? But you're not performing your duties as you were supposed to, or you are abusing the power which has been conferred to you. So government in such a situation will give you an opportunity of being heard. They will hear your call, your take, and thereafter they will supersede if they find that yes, there is a default. Supersede means what? There are these members, they will be removed from the office, and there will be a new constitution, a new committee will be formed, a new standing committee will be formed. All the members of the standing committee have to vacate the office. They're no more the members of standing committee. Okay, so the government is going to supersede, the government is going to remove them and take charge. That is how it happens. Now, whether you want to become a member of ESIC, or you want to become a member of Medical Benefit Council, or you want to become a member of Standing Committee, you cannot become a member if you attract any of the disqualifications which are being stated in section 13. What are the disqualifications? The first one, the person should not be of unsound mind. Okay, the person should not be undischarged insolvent. He should not be convicted with any offense involving moral turpitude. And lastly, if you are a person who has any interest in any contract which is there of any party with the corporation. So corporation and any party has entered into any contract which is a running contract or a subsisting contract. Okay, and the person who is going to be proposed to be a member of ESIC or Medical Benefit Council or Standing Committee, you have an interest in that contract. The interest could be direct, the interest could be indirect. If you have that, then you are biased somehow. You will be biased somehow. You cannot bring that independent perspective and make policies or think about people or take actions in an unbiased manner. You cannot do that, right? So you are disqualified. Okay. Once you have become the member of such committee or such Medical Benefit Council or the corporation, you can still resign if you want to. All you have to do is give a notice in writing to central government. Okay, if you fail to attend 3 consecutive meetings, then you will be ceased to be the member. And if you again want to be the member, you want to restore your membership, you can restore the membership according to the rules which have been made. Okay, then comes the part of registration. Registration ideally has to be done by the employer also, but we don't have to read it. When we talk about registration of employees, what is it? It is a one-time exercise. So it has to be done once in the lifetime of an employee. You give your details. What details? Your basic details, your family details, your family photo. You give it to the employer, and employer actually gets you registered under on ESI portal, right? Once you have registered yourself, you have been given an insurance number which is unique and going to be used throughout your life, right? So basically, what are we doing through registration? The person is obtaining that information and recording that information about his employment, that okay, where are you employed, what is the benefit, what are the wages, etc., etc. So all those is being recorded. It's for the purpose of identification. Then we come to the fund, employee state insurance fund. So ESI fund is being held with ESIC and is being administered also by ESIC. But this is a fund, that is, it is a pool of money. Where do it get money from and where can it spend it? Right? That means the sources of fund and the utilization of fund. Ma'am, ESI fund, whatever contribution is being made by the employer and the employee, that goes to ESI fund only, of course, ma'am. Then because they are doing a social cause and because government is involved, government could also give a lot of donations, other individuals could give donations, some body corporate could give donation, government could give any grants, right? There could be some gifts received. So all that is going to be the sources. And when I talk about utilization, see, the first thing is medical treatment, right? Medical treatment, that is, if anyone is sick, he has to go to that ESI hospital or the dispensary. There will be a cost of treatment. That means you're setting up ESI hospitals and dispensaries. So the setting up of hospitals and dispensary, that will also involve a cost. When you have built a huge hospital over here, then the maintenance of hospital, that will also involve a cost, right? How will we meet these expenses? These expenses will be met by none other than ESI fund only, right? You have seen that we have ESIC, this is one corporation, then we have standing committee, then we have MBC. They're all doing some work. The members are doing the work. The employees, there are n number of employees under these statutory bodies. The employees are doing their work. So employees have to be paid salaries, they have to be paid allowances, the members have to be paid the fees, right? From where it's going to be paid? From this fund only. Okay, so benefit of medical treatment, fees to the members, salaries to the officers, then office setup cost, establishment and maintenance of hospitals, payment of contribution towards medical treatment. See, if the hospital is not available in your area, you have to refer it to some other hospital and you have to remit the fees. Cost of audit, setting up of ESI courts. Then if there is any suit which has been instituted, then you have to bring up that suit, you need money. To defend the suit, you need money, right? If the suit, if the court announces for any settlement, then you have to pay under that for that you need money. Then we come to contribution. Now, contribution by employer is 3.25% of wages and by employee is 0.75% of wages. It has to be paid not within 21 days, but within 15 days, right? Within 15 days of the last day of the calendar month. This has been changed long back, but the institute has not changed. That is why I've written it like this only, but you keep in mind both the time limits, right? Okay. The mode of payment, how can it be paid, right? It can be paid through SBI net banking, or maybe you can create a challan and then go to the nearest branch of SBI and pay it in cash, check, demand draft, etc. Okay, challan can be created on ESIC portal, right? Okay. Then there are two types of employers that we have read about: principal employer and the immediate employer, right? So basically, immediate employer is actually the employer, right? Because he's the contractor, he has supposedly a workforce of 100. Whoever wants it, he supplies that workforce. That is what is being happening, right? So the principal employer to whom the workforce is supplied, that means he is the owner of the factory. And then we have a contractor, like, so owner of the factory, you have taken that workforce from him. So you have like 20 employees maybe. So you have paid ESI contribution in respect of all the 20 employees, but you are entitled to recover it from the contractor, because you are paying to the contractor only whatever, and he is distributing that, right? So in the first instance, it is paid by the employer, but principal employer is going to bear all that cost. But principal employer shall be entitled to recover the same from the immediate employer. Immediate employer, you will actually maintain the register of all the employees that have been sent through you. Okay. Now, this recovery can be done as a debt or as a deduction. That means principal employer has to pay you an amount of 1 lakh, and the contribution made by the principal employer on the behalf of those employees is 10,000. So you will deduct 10,000 and the balance 90,000 will be paid to you. Okay. Then we have section 43, which only tells us that corporation has the power to make regulations for different matters. Thereafter, we have something called as recovery of contribution. So there is contribution which is payable by the employer to ESIC, but they have not paid it. So if they have not paid it, it is like government dues, and government knows how to get that dues. So just in the same manner as land revenue in areas, like you own a land, you have not paid taxes on that land, right? So that is due to government and you're not paying it. So the government has a separate act through which they prescribe a procedure that areas of land revenue can be recovered in this manner. They appoint a recovery officer, there is attachment, there is sending of notice, etc., etc. So they appoint a recovery officer who can actually go ahead and can attach, that means restrict the rights of your property, sell the property, arrest the employer, approve the receiver. Okay. Now they can do this not just for the factory or the establishment's property, but also for the property of principal or immediate employer. Yes. So if the factory's property cannot recover the contributions, then they'll go to the principal or the immediate employer's personal property and they will get it recovered. Okay. Benefits, although we have read it before, benefits given under section 46. So if somebody is sick, there will be periodical payments. If somebody is sick and needs medical treatment, there will be medical treatment. If somebody is in maternity leave, periodical payments during confinement also, and or miscarriage. If somebody gets disabled, then periodical payments. If somebody dies, then the dependents are going to be paid periodical payments, right? If somebody dies, then the funeral expenses benefit is going to be paid to whoever conducts your funeral. Okay. Once you get the compensation or the benefit under this act, you will not be entitled to the compensation under Workmen Compensation Act. Okay. Supposedly, because you're not allowed to combine the benefits, right? You cannot combine two benefits like sickness benefit and maternity benefit. If you're receiving both, that is not allowed. You cannot be combining sickness benefit and disablement benefit, or maternity benefit and disablement benefit. So a lot of times it happens that some benefit has been improperly received. That means you were not entitled to receive that benefit, but because you have received it, you are liable to return it to the corporation. If you do not return it, it will again be recovered in the same manner as if it was the areas of land revenue. Okay, fine. Now there are some other sections, and then there is adjudication and penal provisions. I'm not revising over here because the penalties you can revise on your own. You need to only quickly go through, okay, for this punishment we have this penalty. Okay, first of all, we'll look at the adjudication. We know that state government has the power to constitute ESI court. Now, these ESI court are going to decide a lot of disputes which are being raised. Disputes like what? If I am a person, whether I am an employee or not, like canteen workers, whether they're an employee or not, it is going to be decided not by just normal court but by ESI court. Okay, Fine. Then the rate of wages, maybe I'm being paid this much amount of wages for today, then the next day, what is my average daily wage, right? How many days? So that is also, if there is a dispute, if there is a dispute on contribution, that what is going to be the rate of contribution? Who is the principal employer? Nobody is deducting. Who is responsible for my ESI, right? How do I have the right to this particular benefit or not? I have already received this benefit, but this benefit I've received for the previous contribution period. So if there is any dispute, any such thing, that is going to be decided by ESI court. The dispute could be between principal employer and corporation, between principal employer and immediate employer, employee and employer, right? The person, any person and ESIC or the corporation. Okay, so if you have such dispute, you can go ahead and go to the ESI court. Now, let's say there is ESIC which has asked you that you are an employer and you have to pay a contribution of 1 lakh, but you disagree, right? So you moved to ESI court to decide this dispute. Now, ESI court will not entertain your application unless you deposit 50% of this 1 lakh. Okay, so if there is a dispute between principal employer and the corporation with respect to the contribution, then you have to deposit at least 50% of the amount. It may be waived as decided by ESI court. Now, if the ESI court has passed an order and you feel that it is about a question of law, then you can move an appeal to High Court within 60 days. Okay. This I have already told you. The benefit is not going to be transferable. And then we have these two sections, section 72 and section 73. What do they talk about? One is employer not to reduce wages. Just because you have to pay like 3.25% of wages as contribution, you think that, okay, let me reduce this wages only, so accordingly the contribution will decline, right? I will pay these wages, maybe not on the payroll, I'll pay it in some other form. So you're reducing wages not because you have to give less wages. You're reducing wages just because you want to escape from the contribution that has to be done, right? So that is why you're reducing wages, which is not allowed. Likewise, if somebody is sick and asks for leave, you retrench that person, you dismiss that person, that go away, we don't need you now. Or somebody is going into maternity leave, so you, instead of giving that leave and giving that maternity benefits, what you do is you dismiss that person. So you cannot dismiss anyone, you cannot reduce their salary or remuneration or wages, whatever we are talking about, in case the person is sick, in case the person is receiving any maternity benefit, or in case the person is disabled and receiving some disablement benefit. Is this clear? Okay. Okay, so now we are going to revise the chapter of Code on Wages 2019. Now, when I say Code on Wages, why am I not saying Wages Act 2019 or something like that? Because whenever we say code, it's basically a compilation or collection of a lot of laws as opposite to the act, which just focuses on one specific piece of legislation, right? So when I am saying code, it is basically covering a lot of laws, and when it was introduced, it consolidated and repealed four major labor laws, which is Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. This particular code extends to whole of India, right? And basically, if I talk about the purpose of coming of this particular code, was to regulate all the employments, not just any basic particular industry, but mostly all the employment, and to bring uniformity, because there was a lot of inconsistency of provisions prevailing. And although even today when I'm reading this particular law, there are a lot of interventions by the state governments, because they also have been conferred a lot of power, yet there is a uniform central law which is going to be applicable in removing a lot of discrimination and disparity. Okay, now Certain definitions that we should know before we can actually proceed to revise the chapter is, first is wages. When I say wages, it's providing a uniform definition of wages, which is going to include basic DA retaining allowance, right? And if any remuneration in kind is given, then 15% of that is going to be a part of the wages. What is not included is HRA, statutory bonus, conveyance allowance, house accommodation, then contribution which is made to the pension fund, PF fund, any sum which is paid to defray special expenses due to nature of work. Like maybe you are supposed to work in some cold storage and there you have to wear something for which you have been provided that expense, because in a month you need 4 sets of that maybe costume, right? So that is the payment which is made by the employer to employee to defray some special expenses. Then any overtime allowance, commission payable, gratuity, retrenchment compensation, all of it is not a part of wages. However, there is one thing which needs to be understood, that the allowances cannot exceed 50%. That means there should be, the basic component should be 50%, right? Allowances mentioned, if they cannot be in excess of 50%. Okay, then we have the definition of employee. Employee could be any person who's employed for any work: skilled, unskilled, semi-skilled, manual, supervisory, administrative, technical, operational, clerical, doesn't matter, any type of work. What you have to remember is that it does not include apprentice and armed forces member. As against the worker, when I say worker, there is a difference, and the worker is not going to do that managerial and administrative work. Apart from that, all the types of work are included for workman also. Workman specifically includes the working journalist, sales promotion employees, but does not include the employees in Air Force, Navy, Police Service, and the employees who are drawing wages in excess of 15,000. Okay. Thereafter, we come to the provisions of minimum wages. Now, the first thing that is there in section 3, it talks about discrimination. So there is going to be no discrimination in 2 cases. One is for the payment of wages. That means if a man is being paid 1,000 for the same work, the woman should also be paid 1,000, and vice versa, right? And for recruitment also. That means if for a work which is not specifically involving some heavy labor, something like that, if for a work a woman and a man candidate approaches, you're not going to discriminate that, oh no, let's not take woman, I'll take man only. No, it should not be happening. Okay, so no discrimination in payment as well as in recruitment. Then we have floor wage and minimum wage concept. Section 9 tells that central government has the power to fix a floor wage. Okay, floor wage means that central government fixes floor wage, then appropriate government fixes minimum wage. Minimum wage cannot be lesser than the floor wage, and the actual wage that is being paid by the employers to employees cannot be lesser than the minimum wage. Okay, fine. Now, appropriate government, you are going to fix that minimum wage by consulting with the advisory boards. What advisory board? Central advisory board and state advisory board, whatever the case be. Central government, you are going to fix the floor wage after consulting central advisory board. Okay, how minimum wages are going to be fixed? Minimum wages may be fixed for time work or for piecework. When it is fixed for piecework, appropriate government ensures that minimum time wages is given, and time work may be fixed like by hour. Like they may say that 200 per hour is to be given, right? Or by day, maybe 600 per day or something like that. Maybe month, 5,000 per month, anything like that could be fixed. Okay. Now, whenever you are fixing minimum wages, you have to keep in mind that what skill is required, what is the difficulty level of the work, what is the difficulty level in terms like what is the temperature that they have to deal with, right? What is the humidity? Are they dealing in any hazardous process? Is it underground work? So they should be comparatively paid more. So keeping in mind the category of workers, the skill involved, the difficulty level, that is how the wages should be fixed, and these wages should be revised at least at an interval of 5 years, not exceeding 5 years. Okay. Now, Now, whenever appropriate government is fixing or revising the wages, they can also form as many committees as they want to. And basically, there are two methods, right? You hold the there is a committee method, there is a notification method, right? And you can fix wages or you can revise wages using those methods, right? When we are talking about committee, you appoint a committee, there are inquiries that are being held, and based on that recommendations, appropriate government is going to fix or revise the wages. When we talk about notification, there is publishing of proposals, and you accept that representations from whoever is concerned. You give minimum time of 2 months for seeking that representations, and based on the representations, you either fix or revise the rates of wages, right? You also consult the advisory board, right? Okay. Now, now minimum wages could be specified in 3 ways. In 3 ways means what? There could be an all-inclusive rate, there could be a basic rate plus the cost of living allowance. There could be a basic rate plus allowance, which is going to be adjusted as the appropriate government may direct. That means maybe appropriate government has said that the minimum wages are going to be 3,000 plus retaining allowance of 500, which is going to increase 5% every year. So that is also how they can say. Okay, now appropriate government, if you have the power to provide for minimum wages, you also have the power to fix the number of hours of work. That one day a person is going to work for only 8 hours, that is going to be a normal working day. Every 7 days there will be one day of rest. Okay, and if you want the employee to work on the day of rest also, then you have to give him that overtime rate of wages. Okay, however, there are certain exceptions where this fixed working hours don't work and this normal working day doesn't really suit. In the case there's an emergency, then employees definitely have to work. In case the employees have to do something which is preparatory to the main work, so you have to prepare that, then only the main work can be done. In cases where the employment is essentially intermittent, like we have in railways, right? So railways, they are like, okay, I am traveling but I don't have to be active, I don't have to do anything physically, it's just that I'm not at home, I'm at work, right? But my presence is as good as I'm just resting, right? So it could be like that. So that way you cannot decide the normal working day, or you cannot say that these are going to be the working hours or something like that, right? For the employees, maybe for technical reasons, your work has to be completed before the duty is over, or maybe there is some irregular natural thing happening because of which you have to work. So these are the exceptions. These are the exceptions. Now you have been decided a normal working day or the number of hours of work. If you work more than that, you're entitled to overtime. But what if you work less than that? Then also you will be getting the same wages. That is, your wages will not be reduced unless you are showing the willingness that I don't want to work. Maybe you have gone to work and there is a layoff, maybe the machinery is shut down, maybe the electricity is cut, there's power cut, so you are willing to work but there is no work. That doesn't mean that I have worked for half day and I am entitled to half the wages. No, I'm entitled to exactly full wages and same wages, so there won't be any reduction in wages. Okay, now how the payment is going to be done? Payment can be done by cash, check, or the crediting the bank account, right? Time limit for payment of wages is very, very, very important. Okay, what is the time limit of wages? See, wage period can be fixed. It could be either daily, weekly, monthly, or fortnightly, right? If it is daily, end of the day. If it is weekly, end of week. Why have I not written over here? If it's fortnightly, before end of second day after fortnight. After fortnight. And if it is monthly, before 7th of next month. 7th of next month. Okay. Now, if the employee is removed, if the employee resigns, if there is dismissal, retrenchment, anything, then the wages are going to be paid within 2 working days. Okay, is this clear? Fine. Then we have something called as, okay, this I already told you, right? Then we have something called as deduction from wages. See, ideally, there is no deduction which is allowed. What is called as deduction? The employer is asking for any payment from employee. That is also deduction. So you are being told that central government has fixed a floor wage, then appropriate government, keeping in mind that floor wage and other factors, they fix a minimum wage, right? Now, an employer, you have to pay minimum this wage to your employees. So supposedly the minimum wages is 5,000 per month. Now you want to pay only 4,000. Can you? The answer is no. There is no deduction, which is there are no deductions generally. However, there are some allowed deductions. Maybe somebody is absent from duty. He has not worked for more than 10 days in a month. Why will you pay him the whole salary or the whole of wages, right? Of course, it should be deducted, right? So there are certain allowed deductions. But more than that, if you're going and maybe the employer is saying, you have done this, give me 500 rupees. Now, if you're taking anything from the employee, that is also deduction. However, there could be loss of wages from suspension, a valid suspension for a good cause. Maybe you have demoted somebody for a good cause. Maybe you have withheld someone's increment for a good cause. So if these are the cases and somebody is suffering from loss of wages, that is not going to be treated as deduction. There are certain allowed deductions. What are they? Fines imposed, absence from duty, damage to property in custody, house accommodation, amenities supplied, recovery of advances. Of course, if somebody has given an advance, if the employer has given an advance, then they will recover the advance. Deductions of income tax, that is an allowed deduction. Contribution to PF, pension, allowed deduction. Payment of cooperative society. Likewise, if you want to be a part of the trade union, then membership towards that trade union. Okay. Then um, recovery of loan, that is fine. Now comes certain points with respect to railways. What are the certain points with respect to railways? Now, if you're an employee of railway, if you are into railway administration, then the railway administration might have suffered losses because the employee accepted counterfeit currency. Secondly, the railway administration might have suffered losses because you failed to take and collect certain charges, maybe for the food, maybe for the freight, anything like that. Okay. Thirdly, railway administration has suffered losses because the employee has issued incorrect refund or rebates. So for all these losses which the employee, which the railway administration has suffered because of the fault of employee, they're going to deduct that. Thereafter, if there is any contribution to Prime Minister's National Relief Fund, then that is also going to be deducted. Anyways, the deductions are not going to exceed 50% of the wages. The deductions are not going to exceed 50% of the wages. Now, when I say that the fines can be deducted, you also have to comply with certain provisions of fines to actually deduct them. Firstly, you can deduct for a fine, but then you should have got the previous approval of appropriate government. Secondly, you should have clearly displayed a notice about the fines on the premises. You will not take the fine unless you give the employee an opportunity of opportunity of being heard, you can say. The maximum fine can be 3% of wages payable. It cannot be more than that. You cannot impose fine on somebody who is under the age of 15. If there is an act which has been done, then the maximum time for recovering that a fine is 90 days. After that, you cannot recover fines, and you will maintain a fine register, okay, wherein you will enter all the details. Thereafter, you have to utilize that fine for the benefit of employees only. You cannot fill your own pockets with that fine. Clear? Okay. Next, we have chapter 4 that talks about payment of bonus. So, on which establishments bonus act as the payment of bonus provision. So this particular chapter is applicable. If you are an employee of establishment with 20 or more people, then yes, bonus will be applicable, and you will be entitled to bonus if you have worked for at least 30 days in an accounting year, right? Now, ideally, the bonus is paid to the employees who do not draw wages exceeding the prescribed amount per month. Okay. Now, if you are an employee, you know that, okay, on this particular establishment, provisions of bonus, that is chapter payment of bonus, is applicable, right? Now I am an employee of that particular establishment, so I should be getting bonus, right? Now, to get bonus, there is one condition, that I should have worked for at least 30 days in an accounting year, right? Okay. 30 days in an accounting year. So if I haven't worked, I'm not eligible for bonus. But if I have worked, I'm eligible for bonus. For how much bonus? Minimum is going to be 8.33% or 100, whichever is higher, and maximum is 20% of the salary or wage. If somebody is under the age of 15, then this is slightly reduced, right? But supposedly, the employer has thrown the employee out of the premises because he did some fraud, or because he showed some violent behavior while at work, or because he was involved in theft, or because he has been convicted for sexual harassment. Then, in these cases, the person will not be entitled to any bonus. Okay. Now, when I say that you should be working for at least 30 accounting days, what do we mean by that? Right? What do we mean by that? So we have section 28, which tells us how to compute the working days. Right? Now, maybe there is an employee who is on maternity leave. Right? He's on she is on maternity leave. I don't know why this happens. We have a tendency of giving examples and saying he. Sometimes it doesn't work. Okay, so she has been on leave for maybe 180 days, and she has worked for just 28, 25 days in an accounting year. So ideally, she's not entitled to bonus. But because she's on maternity leave, and when she's on maternity leave with salary, then that is treated as a deemed working day. So actual working days are 28, maybe the deemed working days are like 180. So total, you have worked for more than the required time limit, and hence you are entitled to bonus. Likewise, if somebody has been laid off means what? You're not working because there is no work, there's lesser work, right? Like in corporates, we call it as somebody is on the bench, right? That means he hasn't been handed over any project. So if you're not working, that doesn't mean that it's not your working day, right? It's not your fault, right? Okay. Then we have leave with salary. Somebody has taken a sick leave, he's entitled to take that sick leave. That doesn't mean he's not working and he's on leave only, right? He's on leave with salary. That means those are the allowed leaves, right? Somebody is absent due to temporary disablement. Maybe at work there was an accident, there was a mishap, and because of which somebody has become temporarily disabled. That is also his working day for this particular purpose, right? So for this particular purpose of calculating bonus, this is going to be treated as a working day only. Okay. Now, when we talk about bonus, all the branches of establishment are going to be treated as one for the purpose of computation of bonus, unless there is a separate balance sheet in P&L which is being maintained. How do you compute bonus? We first of all see the gross profit. Thereafter, we deduct broadly these three things: depreciation, direct taxes, and other specified sums. Why have I written this? Because this is when we look at the direct taxes, we will find these rebate and allowances are only allowed. So that is why I've written over here. Thereafter, we get the gross profit after deductions. We subtract the difference in taxes. Difference in taxes, what is it? Like whatever profit we have got, tax on that, right? Tax on this particular profit. Then profit minus the bonus and tax on this amount. The difference between both these taxes is the difference in tax which is adjusted to this amount, and thereafter we get available surplus. Thereafter, we get available surplus. Now, this available surplus, from this we get allocable surplus. What is allocable surplus? For banking companies, it is 60% of this available surplus, and for other establishments, it is 67% of this available surplus. That is allocable surplus. Now there may be different situations, because bonus is an obligation and it is mandatory. It doesn't matter whether you have heavy profits or you don't have profits, you have to pay this bonus. Bonus is a mandatory obligation on the employer, right? So there could be a lot of cases that maybe allocable surplus is more than the bonus that you want to pay. Then great, you have huge profits. Whatever is the surplus can be carried forward as to be set on in the coming 4 accounting years, but the maximum set on that you can do is 20% of the wages. That is the maximum bonus payable. I have made this right. Okay, so we have this illustration in the charts also. Okay. Thereafter, there could be a situation when the allocable surplus is equal to bonus. So fine, there will be nothing to be carried forward, nothing to be utilizing, anything. We don't need it. When the allocable surplus is less than bonus, then we have to see, do we have carry forward? If we do not have carry forward also, then there will be set off. That means the minus loss will be carried forward, right? Okay. Now, of course, this is slightly technical to understand the provisions of set on and set off, and that's why we have done this beautiful illustration and we have understood exactly every point how set on and set off happens. This I am not going to explain again in this revision class, right? So set off, you have to understand that it is not opposite of set on. Set off happens when the allocable surplus falls short of minimum bonus payable and there is insufficient set on carry forward available, right? As in this particular case, the carry forward available is 35,000 only. We do not have any allocable surplus and this is the minimum bonus payable. So to pay this particular bonus, we do not have funds. We don't have any allocable surplus, and the carry forward from the past years, the excess profit carry forwards from the past years is only 35,000. So ideally we use this 35,000, but we are still deficit of 69,167, which is going to be carried forward to be set off in the coming years against heavy profits. Okay, is this clear? Yeah, fine. Now, when I talk about new establishments, then for the first 5 years, you are going to pay bonus only if there is profits. For the 6th and 7th accounting year, slightly different rule of set off and set on. And from the 8th accounting year, it's exactly the same as we read for other types of establishments, right? Okay. While computing bonus, the gross profit will be as decided by central government. So you will have to calculate in the manner prescribed by central government. Thereafter, there could be certain proportionate reduction if the employee has not worked for all the working days. If you have paid any bonus or customary bonus or puja bonus, then you are entitled to deduct it from the same. If maybe you have paid bonus before the bonus actually became due or payable, then you are entitled to deduct that also. If there is any employee who is guilty of misconduct and has caused some financial loss to the employer, then you are entitled to deduct bonus for that particular employee also. Is this fine so far? Okay. Now, what is the time limit for payment of bonus? Payment of bonus has to be done within 8 months from the end of financial year, which can be extended up to 2 years, right? If the appropriate government finds, okay, fine. If they are satisfied, they can extend also. Now, sometimes it may so happen that you have a dispute whether bonus is payable or not. If bonus is payable, what is the amount of bonus payable? No, I am saying this amount is payable, you are saying this amount is payable. Now, if we are on a dispute that 15% is payable, then at least 8.33% you can pay timely, and the balance you can pay later once the dispute is resolved. So once the dispute is resolved, within 1 month of the settlement order, you have to pay. Okay. Now the chapter, this particular chapter is not applicable on the employees under LIC, seamen, employees under the Dock Workers Act, employees under the authority of central government, state government, local authorities, employees of Indian Red Cross Society, universities, hospitals, RBI, public sector financial institution other than a banking company, right? Employees of inland water transport establishments and others as may appropriate government notify. Why? Because maybe they're exposed to better bonus provisions and facilities, so they have a better scheme. Why should this particular scheme be applied to them if they have a better scheme? Yes or no? Yes, ma'am. Next, we move to chapter 5, which is advisory board. Right now, we have central advisory board and we have state advisory board. Central advisory board, you are going to advise central government, right? In fix, because when I talk about fixing minimum wages, who can fix minimum wages is the appropriate government. Appropriate government could be central government, it could also be state government in a lot of cases, right? So whenever it's central government, it's going to fix the minimum wage and it is also fixing the floor wages for everyone. The appropriate government at the state level, or the state government being the appropriate government, is also going to fix minimum wages for certain establishments, right? So they take the consultancy of the state advisory board and they take the consultancy of the central advisory board. Okay, so central advisory board, you're going to advise central government regarding fixing revision of minimum wages, increasing employment opportunities, and deciding the extent to which women may be employed, other matters. Exactly, the state board is also going to do the same thing for advising state government. Who is going to be part of central advisory board? Members nominated by central government representing employers, equal number representing employees, independent persons maximum 1/3, and 5 representatives from state government. The state advisory board is going to constitute members representing employers, equal number representing employees, independent persons not exceeding 1/3, and 1/3 are going to be women in both the cases. Okay, fine. There will be a chairperson. Now, state advisory board, you're also allowed to form different committees if you want to, and they're going to assist and support you. Fine. Okay, the term of office is going to be as prescribed. Then we have the next right. Then we have the next chapter, which is payment of dues, claims, and audits. First of all, it's the responsibility of the employer to pay minimum wages, to pay bonus, to pay all the sums which are stated in the code. If the employer doesn't pay, it will be the responsibility of the company or the proprietor or the firm or the association, because employer could be different. Like maybe we have assigned, there is a company and this particular person has been, one of the officer or one of the director of the company has been identified as the employer. So if he is not doing, the entire company is responsible. Okay, now sometimes when the employee dies, the employer has to pay, maybe bonus is payable to him, so you have to give that bonus to the employee, but then employee has died and the employee's family is nowhere to be traced, we don't know where he lived, etc., etc. So you'll open the nomination file and whoever he has nominated, you'll pay to that particular person. Supposedly he has not nominated any name, then what you are going to do is you're going to deposit it with the authority. Once you have deposited with the authority, or if you're paid to the nominee, you are discharged. Nobody can question you. Now, we have different claims with respect to bonus, claims with respect to wages, whatever it is, right? I have got lesser bonus, I've got this, I've got that. So appropriate government, you have a power to appoint an authority under section 45. Thereafter, you also have a power to appoint an appellate authority under section 49. So here you appoint the authority which is going to be at least the rank of gazetted officer. Okay, now see, now we have an authority. If the employee feels, or the trade union or the inspector cum facilitator, if they feel that okay, we have got something lesser, or there's any claim, they can make an application for claim within 3 years. The authority is going to decide the claim and endeavor will be to decide the claim within 3 months. They can also order compensation up to 10 times. If it is not paid despite the order, then they can issue recovery certificate, and this is going to be recovered in the same manner as land revenue arrears are recovered. Okay. Now, if you're aggrieved by the order, you can go to appellate authority under section 49, and again the authority is going to dispose it off. The endeavor will be to dispose it off within 3 months. Okay. Now, whenever there is any proceeding which is going on, maybe before the authority, before appellate authority, before tribunal, or before any arbitrator, because any dispute which arises over here with respect to wages and all is considered to be industrial dispute under Industrial Disputes Act, right? So if this is an industrial dispute under Industrial Disputes Act, it is written that it is going to be referred to arbitrator. Arbitrator is like not going to the court but going to a third party who gives the judgment, and it's going to be binding. So it's like saving a lot of judicial time and energy and money and all of that, right? So if you are going there, if this is the whatever authority is there, they will be needing a lot of documents, and whenever the employer is providing any document like balance sheet and P&L which is audited, the authority can be satisfied of the accuracy. They do not need to ask for any proof that okay, you prove that this is accurate. Why? Because it's audited. Still, if you're dissatisfied that no, I have a doubt that there is something wrong in this, then they may take steps to find out the accuracy. Okay. Employer, you are going to maintain the register of the details of employees, display abstract of code, wage rate, wage period, name and address of inspector cum facilitator, and you will also issue wage slips. Okay, in general. Right? Okay, just a second. Yes, claims we have done, the presumption also we have done. Okay. Appeal also we have done. Then we have chapter 7, which talks about inspector cum facilitator. Now, inspector cum facilitator is basically again appointed by appropriate government, and they have a specific geographical limit which may be given, and then there is some selection of randomized selection of inspection. They're treated as public servant. Now this inspector cum facilitator, you have been got that okay, this is the establishment which you have to inspect. Now, they just don't have to inspect the establishments, but they also are supposed to advise the employers and workers. Although you have wide powers, you can examine any person, you can require any person to give that information, you can search, you can seize the documents or records, you can. If there is found if there's any default or defect which is being found, that okay, I went to this particular establishment but the employer of the establishment is not paying wages timely, so there is a default that you have found. Now you are not going to immediately impose fine, you will rather tell the employer to rectify his mistake. So that is how the inspector cum facilitator works. So you are supposed to advise the employers, right? Why should they comply with the provisions of the act? What are the benefits, etc., etc. Okay. And if there is any defect or there is any abuse by the employer, then you are going to notify it to the appropriate government. You will bring it to the notice of appropriate government. Okay. You can exercise other prescribed powers. Now, there are some small provisions in chapter 8 which we talks which is offenses and penalties. First of all, the court is not going to take cognizance unless the complaint is made by government, employee, trade union, or inspector cum facilitator. Okay, there won't be any suit against appropriate government. Okay, there are a lot of penalties which are given, like employer, if you pay lesser amount, then you can be fined up to 50,000, right? If you repeat the same offense, then what can happen, right? If you do not maintain the records, again you can be fined up to 10,000, right? But you will always get an opportunity before prosecution. Okay. Now, we have a section called as section 55, which talks about offenses by companies, which is a very generic section found in almost every law. So if the company has committed the offense, then there must be some officer in charge, and that particular person will be guilty and will be responsible. If there is any director, officer, manager who consented to the to that particular task, then he is also going to be responsible and guilty. We have a provision for composition of offense also. So maybe there is an employer who has committed some offense, and that particular offense is like maybe fine only, or fine or imprisonment. It's not imprisonment only or imprisonment and fine. Okay, that means it can be compounded. Compounded means you pay the fine and you are saved from that court trial, right? You're saved from that prosecution process, right? So, in that situation, you can make an application for compounding in the prescribed manner, and thereafter, there won't be any prosecution against you. If the prosecution is already started, then the prosecution shall end and the person will be discharged. Okay. Thereafter, there is going to be no court, because we have the authorities over here under code on wages. Like we have the authority under section 45, under section 49, we also have the arbitrator and all. So if you go to a normal court and you think that, oh, you admit my claim, I'm not getting bonus, the court is not going to entertain your suit. You have to go to the authority constituted under this code only. Whenever there is any claim which has been filed that I haven't got bonus, then it is the duty of employer to prove that I have paid the bonus. Okay. Then there is one more provision, section 63. Yes, this one. That employer, you will be discharged if you bring and prove that somebody else is the actual offender and you exercised due diligence and the offense was committed without your knowledge. Okay, so that particular person will be deemed as guilty and you will be free and you will be saved. Okay. Now, if there is any amount which has been deposited with the authority, that is not going to be liable to attachment by any court. Why? Because basically that is not employer's amount, but that is a debt towards the employee, right? We're only revising, my dear. If you haven't read the concepts, if you haven't learned the provisions well, then you will face difficulty even in the revision, because this is a quick revision, right? That we are doing of the entire chapter, which is going to save time, but save time of the students who have read and have gathered the concepts, right? Thank you.